Today, my name is Chitam Thakur. I am your chairperson for the IP section. Welcome. I see a lot of familiar faces. Say hello whenever you see me walking around. Welcome, you guys. I hope you enjoy today. I hope you get the CLE that you need and the information that will help your practice. We put together a really great CLE conference here today for you. I couldn't do this without the support of your executive committee. As I see folks, I'm going to call them up here, let them introduce themselves, and then we're going to get started. I see Jason Cooper. Come on up. Cher, come on up. Yeah, come on up. Line on up. I'm going to embarrass you all. Jason, Cher. I see Mike. Come on up, Mike. Neil, I know you're there. Come on up. Clint South, I know you're back there. You got to come up. I see Chris Leidner. Come on up, Chris. Who else am I missing? If I haven't called your name and you are on monthly calls with me for the IP section executive committee, you better come on up. All right. I am a little myopic without my glasses. If I'm squinting at you or if I don't recognize you, it's because of that. So I'm going to let these, you know what? I'm going to briefly let these guys walk up and just quickly introduce themselves. I want you guys to get to know, if you don't already know, your IP section executive committee. So please, a loud clapping welcome for your... I see Justin, come on up.
I'm Cher Gregoire with Berman Fink Van Horn, and I am co-chair with the State Bar IP section trademark committee.
Y'all join the trademark committee if you haven't and you're interested.
Join the trademark committee. I'm Jason Cooper. I'm a partner at the Sladkus Law Group, co-chair of trademark committee with Cher. And there's a QR code, a bunch of QR codes right outside the door, so make sure you scan and join the trademark committee.
Good morning, everyone. My name is Mike Cicero. I'm the chair of the Trade Secrets Committee, and I work for the Mavesey Law Firm based in Michigan. I work remotely from my home office in Cherokee County.
Good morning. I'm Neil Weinrich. I'm a shareholder with Berman Fink Van Horn, and I am Mike's vice chair on the Trade Secrets Committee.
Good morning. I'm Clint South. I'm patent counsel at Ballard Spahr. I'm co-chair of the patent committee.
Good morning, everyone. My name is Devin Knapp. I'm the co-chair of the patent committee, and I'm an associate at Finnegan.
Good morning, everyone. I'm Chris Leitner, I'm chair of the section, and I'm really excited to see everybody here today. And Chitam for pulling this off. Thank you.
Justin Ward. I'm the co-chair of the in-house committee, general counsel for a corporation in Savannah called Blue Force Gear.
Hey guys, you see the diversity presented here. One of the reasons I wanted to call these people, bless you, is because we have a distinct set of practice backgrounds. We have a distinct set of practice experiences, levels of seniority. If you guys are interested in taking a leadership role, please step up, join a committee and meet your executive committee and become a part. Raise your hand the next time a position opens up and said, hey, I would like to do such and so, this kind of work or whatever have you. So please join us, please support us. Again, I hope you have a fantastic CLE conference today. Come grab me if there are any issues. I hear the good and the bad. So please come grab me and say, hey, Tom, something's not right with this, that, or the other. Please let me know. We'll get it fixed if we can. One thing I want to point out is this is not me being rude, but I'm going to try to keep us on track for time. We're already 5 minutes behind. That's my fault. But I'm going to try to keep us on track as much as I can. So if you guys are a panel or if you're a speaker and you see me slowly creeping up the side, it's because I'm about to pull your mic from you. And so fair warning, don't be offended. All right, good. Again, these guys, big round of applause. They made today happen.
Morning, everybody. Neil Weinrich again with Berman Fink Van Horn. I'm the vice chair of the Trade Secrets Committee. I have the pleasure of introducing our first speaker, Chad Lackey. Chad, come on up. Chad is a director with DOOR, a national jury and trial consulting firm. Chad has been a jury consultant for over 20 years. He's consulted on hundreds of civil and criminal matters. He has extensive experience designing and conducting focus groups, mock trials, surveys, other trial research to test the persuasiveness of case themes and relevant jury profiles. Chad's practice centers on complex commercial IP and white collar litigation. However, he has experience in a number of other areas, and his experience really runs the gamut. Today's presentation, Chad's going to be presenting his findings of a survey of eligible jury respondents from 4 top venues for IP cases. And the survey focuses in particular on attitudes towards conduct associated with the theft of trade secrets. I had the pleasure of seeing Chad present on this topic at the American Intellectual Property Law Association's Trade Secret Summit, and I thought it'd be a great presentation for this group. It has relevance to particularly to trade secrets, but also to all the other IP topics that we're going to cover today. So let's welcome Chad, and I'll turn it over to him.
Good morning. So about, I guess, at the beginning of the pandemic, our firm started doing a lot of survey research on the subject of intellectual property. What do you do when the courts are shut down? You're a jury consultant. You start doing surveys. Well, we've been doing it now for the past 6 years, and I'm here to talk about one of the more recent ones that we did at the end of 2024. And the subject, as Neil mentioned, was looking at people's attitudes when it comes to conduct related to the theft of trade secrets. A lot of people have experience that is very relevant to issues surrounding the theft of trade secrets, unlike when you're talking about intellectual property cases involving patents, where everyone is completely baffled and has very little experience with the subject matter of how to construct a motherboard. But when you talk to people about what does it mean when someone takes paperwork from an employer and brings it with them to their next job, they have definite opinions. Now, we looked at 4 venues, and you can tell we did this at the end of 2024 because one of the venues was the Waco division of the Western District of Texas. Just a couple of months later, Albright announced that he's going to be moving to Austin at some point. So we didn't know that at the time. But in any case, we looked at the Central District of California, which is largely around Los Angeles, the District of Delaware, which is the whole state, the Marshall division of the Eastern District of Texas, and the Waco division of the Western District of Texas. One of the first things we learned, which was interesting, is that venue did not matter. People's attitudes towards employment and these kinds of issues were common across different venues. We looked at 2 particular topics. The first is retaining trade secrets. We looked at 2 different components of retaining trade secrets. First, we asked people how acceptable or unacceptable is it for an employee who is leaving a job to take technical plans for technology that their employer develops. So they're actually taking documents, CAD files, electronic files with them when they leave. We also asked them how acceptable or unacceptable is it for an employee who is leaving a job to take those plans if they helped develop the technology. And there was an interesting difference there. So the first in retaining is you just bring documents with you. The second component is you're bringing documents with you regarding technology that you worked on as an employee. We also looked at passing trade secrets, giving information to a new employer. First thing we considered was giving an employer those documents. So we asked how acceptable or unacceptable is it for an employee to give their current employer a document containing technical plans for a piece of technology that their prior employer developed. So they just didn't take that document with them. They gave it to their new employer at their new job or next job. We also asked a different wrinkle to this. Well, what if you don't actually give the physical document? What if you give the information, but you rely on your memory rather than the document? So you're sharing information about a prior employer's work product, but you're doing it relying on your memory. And finally, we asked how acceptable or unacceptable is it for an employee to share details about how a prior employer solved a critical technical problem. So what we found was when it comes to retaining trade secrets, the majority of people found taking documents to be unacceptable, which is, I guess, good news if you're an employer. What's interesting is that when you start talking about documents about a piece of technology that the employee worked on, the majority of people feel like it is okay for an employee to leave and take those documents if they worked on that technology. So there's a pretty dramatic difference there, and you can see some of the risks that that poses for employers. Well, when it comes to attitudes about passing trade secrets, the majority of people believe it is unacceptable to give a new employer documents that describe technology that a prior employer developed, which is good. And a slight majority believe that it's unacceptable to provide that information, but to rely on your memory. Interestingly, a majority of people believe that it's okay to provide critical information about how technology was developed that your prior employer developed. It's okay to share that critical information with a new employer. Again, that's something that would be of interest to employers who develop technology. What was more interesting about the landscape of what you see here is when you start looking at how these attitudes vary among different groups. The first thing, age differences. Age turned out to be incredibly important in how people looked at these employment issues. The majority of 18 to 24-year-olds believe it is acceptable to take documents with them, while the majority of older individuals believe it's unacceptable. And that applies even when you're looking at whether or not they consider it to be completely unacceptable. Older individuals are more likely to believe that taking those plans, that's completely unacceptable. You just can't do that. That doesn't happen quite as often for younger people who are much more likely to justify that behavior, to make excuses for it. Well, mostly it would be wrong, but in this case, it's a little bit different. We also found that 65% of those who were 45 to 54 and 69% of those who were 55 to 64 and 76% of those who were 65 or older believe that taking plans was completely unacceptable. So that would be important information to know if you're picking a jury in a trade secret case. Because older people and younger people think very differently about these issues. When you talk about someone taking plans that they help develop, they help build the technology, you see a similar pattern. The majority, and sometimes the substantial majority of younger people believe it's acceptable. If you worked on a project and you bring plans with you, you take them home, that's fine. this kind of gives you a sense of that for many people, they believe that the employee has some ownership over their work product. It doesn't belong just to the employer. I help do it. So if you help do it, you're allowed to bring documents, or at least most people are forgiving of that kind of circumstance. When you get to older people over 55 and above, the majority think that that is unacceptable. You see a similar kind of difference when you talk about passing technical documents. Almost half of those who are 18 to 24 believe it's acceptable to give technical documents to a new employer. 40% of those 25 to 34 believe it's acceptable to do so. And the youngest and oldest respondents, and this is the chart you see below, dramatically differ when it comes to attitudes about using one's memory to pass technical information. For older people, you can't do that. They find it unacceptable. For younger people, sure, why not? That age difference is interesting, not just because it has implications for jury selection, but it raises a question, why? One possibility is that for younger employees, they just haven't been educated or trained enough about what constitutes a trade secret, what belongs to the employer, what doesn't belong to the employer, and what you are and are not allowed to bring with you to another job. That's a problem that's relatively easy to solve if you're an employer. However, there may be something else going on that is shaping these differences. For a lot of very young people, they are and exhibit much less loyalty to their employer than people in prior years. They don't experience pensions. You know, a 401k is a luxury. They're used to hopping from one job to another. Layoffs can come at any minute. Getting a job is very difficult. So for many young people, it's not surprising that you see behavior that's consistent or attitudes that are consistent with a lack of loyalty to their employer, because from their perspective, their employer hasn't shown them loyalty. So why should I give them that? There were some gender differences too that we found. While a majority of men and women both think that retaining and passing trade secrets is unacceptable, women tend to take a more negative view of this conduct. For example, 66% of women believe taking those documents is completely unacceptable, while only 49% of men do. And similarly, a majority of women believe that giving plans to a new employer is completely unacceptable, but only 40% of men do. So men apparently are more likely to make excuses for this type of conduct, for whatever that may be. We also found some interesting racial and ethnic differences, that Caucasians tended to be more disapproving of this conduct than others. The differences, though, were relatively small. And interestingly, when you looked at the different racial and ethnic groups, attitudes about these issues amongst Caucasians and Asians tended to be very similar to each other. And the attitudes about these issues for African Americans and Hispanics also tended to be very similar when it comes to these issues, but they differed from each other. 61% of whites believe that taking plans is completely unacceptable, whereas 48% of African Americans and Caucasians, African Americans and Hispanics do. And you see that also when you look at giving those plans to a new employer. The majority of Caucasians believe doing so is completely unacceptable, but only a little bit above a third of non-whites do. Why that is? Not sure. It may have something to do with the barriers that people face and different groups face in the workforce. The more barriers you face, the more likely you will be to find ways around them. Or at least believe that, it's more acceptable to do so. You would think that one of the things that may drive people's attitudes about this subject, because we're talking about auto mechanics and teachers and social workers, they just don't understand the technology and the rules around the workplace that govern development of technology. So we also looked at high-tech workers. And keep in mind that these are high-tech workers who do not work in large tech hubs. We're looking at Los Angeles, Waco, Texas, Marshall, Texas, and Delaware. We looked at, in particular, those who had mostly worked in computer science or IT. There were about 100 of those in our sample. We looked at those who had mostly worked in the field of engineering, about 40 engineers in the sample. And we looked at those who had jobs that involved working with an employer's patented or proprietary technology. We had roughly 250 of those workers. So in looking at this group, you would expect, because they're more familiar with the issues surrounding development of technology, they would think differently. Well, when you look at computer science and IT workers, what do you find? You find that they were more accepting than others of both retaining and passing trade secrets. They were more likely to believe it was acceptable than others to take an employer's technical plan. They were more likely to believe it was acceptable to give those plans to a new employer and to provide that information relying on your memory rather than passing a document. So IT workers and computer science people are more accepting of both retaining technical information and giving that technical information to a new employer. So if you're working a trade secret case, sometimes you find yourself in a position where you like these people because they may be able to explain technical subjects that are key to your arguments at trial. Well, be aware that that carries some risk because for them, they see this conduct as normal. I'll give you a couple of examples. We were working a mock trial in the Boston area about a trade secret case, and we were working for the plaintiff in that particular case. And we had a design engineer, young kid, 35, probably been out of school for maybe 7 years. He was horrible for us. Right when he started deliberating, he was taking the position that I don't see that this information is secret. I mean, people bring stuff with them all the time. I know about this information. I'm an engineer. I work on this stuff. I can't take that knowledge out of my head. All that comes with me when I get a new job. And having documents is normal because we're required to work from home and we need those documents to do our job. And lo and behold, when I left my employer and went to a new one, look what I found in my office. These 500 documents. Didn't throw them away because they might be useful. It was what made him a particularly dangerous juror, especially when you're working for a plaintiff, is that he knew the lingo. Other jurors looked to him to provide insight and expertise on industry standards and practices. So that was a very clear example of how some of these people view trade secrets. I also had another young man who was a coder, not a design engineer in San Francisco. The case involved technology like video equipment that you would put on an exercise bike to watch while you're pedaling. And it involved the technology part of it and the internet part of it, how it connected and all this kind of stuff. And the coder's first take when deliberating on whether or not this technology was a trade secret was computer code can never be secret. You get it on GitHub now. You ask AI to write it. It's not secret anymore. And he knew that. And he saw completely that, unlike everybody else who was basically approaching it as computer code, my gosh, I know anything about that. That has to be secret. That has to be special. You have to take care of it once you write the code so that somebody doesn't take it. Well, not for him. He's like, computer code is everybody's, everybody. Everybody has access to it. Everybody can get whatever they want and nothing is secret. So engineers, I don't know, being naive, I hope they would think somewhat differently and take their job more seriously and responsibilities more seriously than IT workers. No, they pretty much thought the same. They really didn't view retaining or passing trade secrets differently than anybody else. And when they did think of it differently, they thought it was more accepting. They were more accepting of taking that information. Over a third of them thought it was acceptable compared to about a quarter of everyone else to give technical documents to a new employer. So granted, it's not half, it's a little over a third, but you're still running into a significant portion of that group who think that this kind of conduct is completely acceptable. Nearly a quarter of engineers believed it was okay to take that document and give it to their new employer. So they're not just more likely to bring it home, they're more likely to pass it. But again, it's a minority, but the fact that 25% say it's completely acceptable to do that, no ifs, ands, or buts about it, is pretty remarkable. We also took a look at those employees who work with proprietary and patented technology. Turns out, big surprise, they're more accepting of retaining and passing trade secrets as well, sometimes much more so. They're more likely to believe it's acceptable to take technical plans, almost twice as much. They're more likely to believe it's acceptable to give those documents to a new employer, almost twice as many again. Believe that to be the case. And they're more likely to believe it's okay if you rely on your memory or you just share critical technical details about how a prior employer solved a technical problem. So high-tech industry workers, and I don't, in some respects, don't find this surprising, because if you're working one of these cases and it involves technology, you're always laser focused on the high-tech people who are engineers, who are IT professionals, who are coders, because they're going to be the most likely to understand and to bring some expertise into the jury room. But it doesn't necessarily have to stay at when you're talking about high technology only and the development of technology. I'll give you an example. One of the things that we didn't ask people about were trade secrets involving business information, client information, things like that. I was working on a case in Las Vegas involving trade. It was a trade secret case, but it didn't involve technology. It involved paperwork and contracts and forms. And the argument was that these forms that businesses typically use qualify as trade secrets, because if you take all of someone's paperwork and all the documents they need to do business in the real estate industry and you use them yourself, you have a competitive advantage because you don't have to retain a lawyer to draft an agreement. You don't have to hire others to develop the documents you need to do your business. And lo and behold, what did real estate agents think about this? You're dumb if you don't take it. You're dumb if you don't use it. Because from their perspective, it's a very competitive industry. And for a lot of real estate agents, they work for a company and then they'll go out on their own. And so and we talked to a number of them who went out on their own and they're like, of course I did. I just changed it up a little bit. So redlined and tracked their changes on the contract, changed some of the language, used a different logo, but the meat of the documents were all the same. And from their perspective, yeah, why not? So it's no surprise that people who are working in an industry can think very differently about the types of information they think it's okay to bring with them when they change jobs or go out on their own. One of the things we looked at was, so I gave you the example of an engineer or somebody who's leaving a job and they find out when they're cleaning out their office, they brought a lot of paperwork home with them. And they have stacks and stacks of technical documents and stuff that they worked on in the past. Well, that it's a problem for employers, but in most cases, it's completely different than taking those documents and passing it along to a new employer. So one of the things we looked at was, for these people who might accidentally bring documents home with them, do they think differently about passing those documents to a new employer than others? Because when you talk to a lot of employees about confidential and proprietary information, many of them think, well, of course I'll have some with me somewhere in my desk because I worked at a company for 5 years and I have paperwork everywhere. Some of it's in my glove compartment. Some of it is stuck in suitcases that I haven't used in the last 2 years. Some I know is stuck on the refrigerator because my daughter drew on the back of, a contract and I stuck it on the refrigerator. And what we found was interesting and worrisome. That those who retain these kinds of documents and this information are much more accepting of giving that information to a new employer. 70% believed it was acceptable to give a new employer confidential and proprietary documents from an old employer. 70%. 82% believed it was acceptable to give a new employer confidential and proprietary information if they relied on their memory and didn't just hand over a document. That's a lot. So if you are facing a jury and trying to deal with a trade secret case, if you can try to assess if people are retaining documents by accident, whether it's technology that they worked on or otherwise, it would be a good thing to inquire about that because it's going to make a difference in how they view the case. So as we've been talking about this, I've been kind of relating this to jury selection. And if you're picking a jury. And so if you are a plaintiff and you're looking to pick a jury, the high-risk jurors you have to take a close look at are those who are young, under 35, especially under 25, African Americans and Hispanics, men, those who have backgrounds in IT or computer science, those who've worked with patented or proprietary technology, and those who have retained documents from a prior employer. The one thing we found that I didn't put up here, which was kind of interesting, is that there's another group of people who tend to be very accepting of passing trade secrets. Bankers, people in finance and who work in the banking industry, almost across the board, consistently, they were much more accepting of this kind of conduct than people who work in any other job. Why that is, I'm not really sure, because if we were surveying people on Wall Street and bankers on Wall Street, I'd have some theories of why they would be accepting of this kind of conduct. But we're not talking about them. We're talking about people who are handling mortgages in local branches and people who are working, tellers. We're talking about back office, regular people who work in the banking industry. And that's an interesting thing. And I'm not exactly sure why that's the case. So if you're working for a defendant who's been accused of getting involved in the theft of trade secrets, the people you're going to need to be worried about are those who are older, because they tend to find this kind of thing is incredibly unacceptable. Women are going to be better for you than men, although in this case, the primary driving difference is among age groups. When you look at the differences between men and women and racial and ethnic groups and even occupations, it's age that is the big driver. And finally, Asians and Caucasians. So one of the things that this shows when you're dealing with a trade secret case and how people think about their work is that many people feel that they have ownership of whatever they do at work. And for many of them, they also feel that they're making a bargain with their next employer. You hire me because of what I know. You hire me because of what I've done. You hire me because of my experience. So for the average person who's working in these fields, the line gets kind of gray when you're talking about what's okay to bring with you and what's not. For most people, if it's in your head, sure, it's fine. Because all of us, you can't remove stuff that's in your head. But many people think that, well, I learned how to be an engineer there. So what I learned there, I take with me because that made me a better engineer. That made me a better scientist. And so for them, there aren't clear lines when you're thinking about your responsibilities to your employer and your responsibilities to the technology you help develop. That's it. Any questions? Yeah.
Did you distinguish between groups of IT people that actually wrote their own code versus open source, the GitHub group?
No, we didn't. And it's most of the people, when looking at the IT people we have, are system administrators. They're, the people who you call when your computer doesn't start. There are coders, but remember, we were looking at venues that weren't technology hubs. So you didn't have a plethora of coders in Waco or Marshall, Texas, or Wilmington, probably more in LA. But it was mostly just kind of your run-of-the-mill IT people. But there were a few, but there weren't enough to really draw distinctions about them.
I think if you took a look at how old the technology was perceived to be, that would have a big effect on how people view it.
Yeah. And I think that's very true. And I think when you looked at one of the things we did look among IT professionals, because we had more of this group than we did a lot of other types of workers, is that you saw the age difference play there as well. So younger IT people were much more forgiving when it came to this kind of stuff than older IT people. And I think to some extent too, when you look at people who've achieved some type of management position, they're going to be much more, interestingly, not as much as you would hope, because you would hope that managers are going to be your first line of defense. You're going to be working with trade secret information, that your managers on the floor are going to be policing the employees. They are more likely to find this kind of stuff unacceptable, but not as much as you would expect. And one of the most interesting findings came from business owners themselves. You would expect people who own businesses, who are officers and directors of corporations, would be like, you can't do that. Can't do that because I don't want my stuff taken either. Well, it turns out they're kind of wishy-washy when it comes to this. And when you talk to some of them, the reason why is rather obvious. Because I don't want other people to have my technology, but if I can get my hands on theirs without consequence, good for me. Yeah.
How have these survey results affected the questions you asked during voir dire, if at all?
In many respects, a lot of this stuff, you don't need to technically ask about it, because in most trade secret cases, if you have a supplemental juror questionnaire, you're going to have to, but most information that the judges are going to get from juries, you're going to get. That's going to make a difference, what they do for a living. Have they ever worked with proprietary technology? Are they engineers? How old are they? You know, all that kind of stuff is rather run-of-the-mill information that comes forward pretty quickly in jury selection. The trickiest one is retention, is trying to ask jurors about that. And that depends whether you're in federal court or state court, when you have some leeway to deal with that issue. But we have been able to ask in some cases, have you ever worked, you know, you can ask things like, have you ever worked a job that required you to bring documents home to do your job? Have you ever left a job and found that you had documents and materials from a prior employer? Those questions are easy, but whether or not you can get a judge who will let you ask them and probe is going to depend on the judge. Anything else? Okay.
All right, everybody. Good morning. All right. Good morning, everybody. I'm Cher Gregoire with Berman Fink Van Horn. I'd like to introduce my co-moderator today, Jason Cooper, who is a partner with the Slagkiss Law Group, and we are co-chairs of the Trademark Committee. We're extremely fortunate today to have an outstanding panel of in-house intellectual property leaders who are shaping trademark strategy for well-known global brands and organizations. I'm pleased to introduce, starting from my right to left, we have Andy Weeks, Senior Legal Counsel, Trademarks at the Coca-Cola Company. We have Antigone Payton, who is General Counsel at Spanx. Oma Reggie, who is, I'm sorry, I skipped somebody. Brent Radcliffe, Associate General Counsel at Blue Cross Blue Shield Association. And Oma Reggie, Managing Chief Counsel, IP at McKesson. We'd like to thank you all for being here. Our topic for today's discussion is trademark branding enforcement challenges in 2026 from an in-house counsel perspective. And we're going to focus on how our panel navigates data-driven decision-making, applying trademark strategy with business speed, optimizing in-house and outside counsel relationships, and anticipating planning for future challenges. We'll start each section with a question and then open it up to the panel. Can everybody hear me? Our first topic is data metrics, improving the value of trademark work. So I want to kick off with the following question to the group. How are each of you framing the impact of trademark work, including data metrics and value, in terms that your teams and executives can understand?
Okay, I'll jump in. Can you guys hear me okay? I want to make sure I don't have to.
Can you up it a little bit?
Is that better? Beautiful. Okay, I'm going to jump on this one.
Okay,
Hey, yeah,
perfect.
I can speak from the diaphragm. Yeah, so I mean, from my point of view, although data metrics are important and helpful in understanding the work we're doing, in my experience, the C-suite and leaders at my company, they care mostly about like the what legal looks like and what they're doing. And what I mean by that is like, are they like a roadblock to us getting our job done, or are they actually like partners helping us find a solution? And I think the pitfall that gets you into the first of the two, which is obviously like kind of the problem bucket, is if you're just not involved throughout the entire process. So like, I think it's important to make it clear to the teams you're working with, if you're a trademark attorney, that you are part of finding a solution and a path forward, that you're, and I think when that's the story that you're telling, like the abstract numbers about wins and losses or the number of clearance searches you're doing, like none of that stuff really matters as much as like, are you helping them get the work that they want to get done?
Just to add a little more on that, I absolutely agree with Andy. When we think about the value and the business goals for our organization, which is consumer focused, right? It's very much aligning what we're doing from a legal perspective to that goal. So for instance, if we're growing a certain channel with our customers, some of the protection activities that we engage in, how does that add value in terms of what we're trying to accomplish with growth on that channel and protecting our brand on that channel? What's the highest and best use of our outside counsel team versus in-house team in terms of evaluating risk and reporting on risk? The business might make a decision to move forward in spite of that risk, but as long as we adequately articulate it, we're all in the boat together, rowing in the same direction. So it's really about being a cross-functional and cross-matrix business partner to the organization. And the thing that I like to tell the team is we're not the party of no, we're the party of how. And I mean that both in a proactive and in a reactive manner.
Yeah, I think just to kind of, I don't like to piggyback, but to kind of go with what Andy was saying, I think just describing how the work that we're doing in our department ladders up to the organization's priorities for the particular annual cycle is one way that we describe what we do in a way that matters to the C-suite. And I think in preparing for that, when we talk to, just come down a notch on the ladder, we do probably utilize different success metrics, different KPIs that do allow us to really measure those successes and, how is our money being spent with the vendors, and how are we having more efficiencies with our team internally, more than maybe bringing more work internal rather than external, depending on where we are. It might be company to company, but now I think one of our focuses is doing a little bit more with what we have, trying to be more efficient. And the way that we described it to the C-suite is important for our team to show our value.
Yeah, I agree with what everybody has said. And, I like to say this statement, if we're not showing business impact, we're not showing value, right? And I think a lot of times, we're counting numbers. We're saying how many trademark searches are we conducting, how many clearances, how much, sort of how many takedowns, so sheer volume has traditionally been, I think, how we measure value. And I think what I'm sort of seeing now is, even within our own team, is we're really telling stories, right? We're telling the business a story about the impact that we're having on your business from we helped you launch a product on time, ahead of time, right? We've helped you, sort of see the market positioning and the market value, whether it is by doing surveys or valuations, right? So we're really showing more than sheer number and sheer volume as a metric. That data is important, but I think partnering and showing the impact to the business has been particularly useful for us.
That's very helpful. Thank you. And related to that, how can you give us some examples or describe how you also translate risk into concrete business consequences along the lines of what we were just discussing?
Can you ask that question again?
Sure. How do you translate risk into concrete business consequences? So you're talking
Sure.
about
Yeah.
exactly. Yeah.
Yeah. So, all right. So like, imagine like if you have a mark that's like, it's pretty clear that if they were to move forward with the use of this mark, you'd find yourself in some kind of infringement action. And at the end of the day, you're probably going to lose it. And there are all kinds of lose that fight, and there are all kinds of consequences that might, involving damages, injunction risks, that sort of thing. And the way that I would tend to frame that to my company is like, I would try to think well, what actually matters to them? All right. They don't really care that, that it would be hard for me to make the argument as long as I can make it. What they really care is I'm trying to put some stuff on shelves. What is an injunction? Does that mean I have to take it off shelves? And when the answer is yes, then it's really concrete, right? It's really clear. We really maybe we shouldn't do this one. But I think it's important also, when I come to the table to talk about that kind of thing, I try to make sure that I'm not just there saying, too bad, it's not going to work. Which was I came from a law firm and then went in house. And when I was at a law firm, I could say, this is high risk. And that's kind of the end of the story I was telling. As in-house counsel, I can say this is high risk. Here are a few ideas of things we could do to try to navigate around that in terms of how we might, for example, change the mark that we're using. I might even, sometimes to my surprise as in-house counsel, I found that I was part of the creative endeavor of naming and saying oh, well, if we did this, if we had this same notion, but we tweaked it and we changed it, and maybe then we can kind of thread the needle. And it's surprising how much different that conversation is than, how much more understandable it is, how relatable it is to the business, how much they can kind of work together, because that's what they hope to have, was a cross-functional team helping them get to the solution of the problem.
Somebody have anything else to add to that, or?
Sure, we can move on. So,
Move on.
you're all obviously operating kind of different industries, and you're in-house, you're operating in a dynamic environment where maybe things are happening quickly. Marketing's working on a campaign, and you're looking at a new product launch or a new service offering. And so when you're looking and talking about clearing marks in that context where things are moving very quickly, what can you do to make sure that the trademark clearance process doesn't hold up the company's ability to offer its new product offering or its new service?
I'm very passionate about this because one of the things I see, and I've seen it, as an outside counsel and now in-house for several years, where, we're not doing a good prioritization of, what is the Bet the Company brand, and then what are sort of the run-of-the-mill, we can just do a literal clearance screening in an hour or less, or even using AI tools and technology to do some of this stuff, right? So the sort of understanding the brand value of something before you start sort of initially running to the search. And I've talked, and again, I've been on both sides, so this is not an indictment, but oftentimes talking to outside counsel that says, oh, we've got to do a search on da-da-da-da-da. And I'm like, well, wait a minute. Like, what's our sort of strategy here? Like, what is the approach? Why are we searching everything? The day of 3 to 5 days of a turnaround is gone. Like the business is like, I want it and I want it now. Of course, we're not going to sacrifice value and we're not going to sacrifice quality, I should say. But we've got to get this stuff going. I mean, no longer do we have that luxury. And so I think it's also, and we'll probably talk about it more, but having sort of a tiered approach in how you address clearance, how you address feedback, right? What marks do you look at? Are they high value, high visibility, high impact, or are they literally something that is just niche and will go away in a week, right? And so I think having those conversations up front. But another reason I'm very passionate is I think that we've got to be much more embedded within our marketing organizations, our product teams. Now, that's not easy, particularly when you're talking about small groups in-house, right? Like, you know, I think all of us can talk about how we are overly busy and capacity is always an issue. But I think when you're there at the table in the beginning and are a true partner to your marketing, brand, and communications teams and products teams, it makes a huge difference because sometimes you're making the decision in real time. So just sort of being embedded is a real, to me, I see a real plus.
Yeah, just following up on the risk weighting piece, I think that's an important part of the conversation. And I'll also add education, right? So for us, this is really understanding that intended use and helping our partners come to us with information that's relevant to that risk weighting analysis. I would think another unlock for us has really been insourcing some of the technology platforms that allow us to move at the pace of the business, because we cannot, from a financial perspective or from a business intelligence perspective, meaningfully outsource all of the trademark clearance searches that we're doing, right? We've got new lines, we've got new fabric colors, we've got new individual product names, which may or may not be used in a trademark sense. We've got new collection names. We don't know if they're going to be used in a trademark sense, right? We've got fast fashion campaigns. Let's not talk about that as trademark, right? And so really that conversation needs to happen for us internally as we engage in that risk weighting and then being responsive to the business in a timely manner. Once we understand the intended use today and potential future intended use, to be able to give that business feedback, you know, that's really an embedded business function where we've had a lot of trouble outsourcing that. Osmosis is difficult, you know, to sort of transfer that knowledge to work with outside counsel to make a I think that risk management and combined with education has been very important for us to be proactive around understanding the what and the why, but also, frankly, issue spotting other issues that might arise. Performance claims, other things, whereas part of the water cooler conversation relating to clearances, we find some other pieces that we need to pull the thread on to better understand the business intention at a point where we can't, it's malleable and we can shape how they're talking about certain products or how they're using certain language, whether it's intended as a trademark usage or not.
One other thing just to tack on is when we're talking about just communicating those decisions, we have the strategic approach, different measures that we've discussed already, but also the different tools and the speed that we use to communicate those messages also matter. So more recently, we've been using different internal platforms to try to communicate those decisions faster, educate those business partners as we go along, but also be more collaborative and sort of communicate to them in the way that they want to receive the information. So it's not always writing, you know, a long memo or even 5 bullets. They just want, you know, a quick message on Teams or just to explain, you know, what's going on here. Or maybe it's a collaborative document where we can actually add comments and work together to find a solution. just to keep us moving forward. And Andy mentioned earlier that sometimes, or I guess more recently for me, it's being brought in to help actually with the naming, which sometimes you expect that to be a purely marketing team function. But more and more, I think that when they can come to me and actually seek the advice of the IP counsel or the general counsel, when it comes to making those decisions, I think it'll also lead to better outcomes for all parties. So I think also just making sure that you're communicating in the way that those business teams prefer and in an easy to read format.
When you're coming up with those alternatives, though, I do recommend you go ahead and do a search ahead of time behind the scenes, because it's no fun when you say like, here's a good idea that we cannot do. I do have two other thoughts on the conversation we're having about assessment of risk. Like first on the like the nature of the use absolutely should inform the risk analysis, and that's all we're doing is like analyzing what the risk level is, and like practical risk is part of the risk. So if something is going to be used for a single day on one social media post, then, you know, there may be you may want to treat it differently in terms of how you're thinking about searching than you would for something that's like, this is going to be the platform for this brand for years and years to come. So I do think that's important to bear in mind. And then another thought, so part of it's on us to speed up the process. Part of it's also on the business. So one thing I often say in like trainings to my teams that I'm working with is like, you know, I try to remind them that I'm a human being and that I work with other human beings, and that human beings, for the most part today, run those searches. And I don't think that AI is kind of up to the task, frankly, so far from what I've seen, but I'll keep working on that. But then I'll remind them that we're humans and that the searches take time and energy, and that they shouldn't be like, I'd rather they didn't throw the spaghetti at the wall, you know, like give us the marks you care about. And we will be faster and more efficient if you do it that way. If you give me your list of my 50 top favorite lines, then okay, we can get through those, but it's going to take a long time. And so that makes life better for both of us if you can call before you share with me. Yeah.
Have you guys found any good tools or steps that you're training the business teams to do to sort of identify and get rid of red flag naming before it even gets to you?
That's a great question. I'll jump in real quick with my immediate reaction, which is that, yeah, I do ask that they like, you know, just like Google it, like, just could you like Google it? I do feel very nervous though. I know that Oma mentioned AI, and like, I've heard some like rumblings of like, what we could just let the marketers to find good AI search tools, and then they can run their trademark searches. And, you know, first of all, like, they don't know what that information that they got necessarily means. And second of all, it's not privileged information. So they have now like let the world know what they know and what they want to find out and what they have found out.
I would also say I'm just basic, you know, it sounds very basic, but like, you know, Google, of course, but like, you know, look at acronym dictionaries, look at, you know, if you're asking for a brand and you know the corresponding domain, name is critical. Have you done a Whois, sir? But I think even giving your marketers a list of things that they should be looking for, you know, I don't want to go into too much detail, but I think we have some of the best partnerships with our marketing groups. And a lot of it is because we've done a lot of the embedding ourselves into the group, but also because we've also sort of sensitized them to, before you give us your top, you know, and usually we're talking about 5 to 10 favorites. The 50 has to be dwindled down. They are assessing the favorite based on some criteria, obviously feel and, you know, that good stuff, but also legally, they've done some initial screening on their own. People are also using Copilot a bit more and other AI tools. But again, by the time they've come to the table, they've actually done a lot of the homework so that they're not going, oh, wait, I didn't realize the .com was gone. And so I think it's also a lot of education and training, and then also sort of the partnership.
Yeah, I think it also depends on who it is that you're working with, those partners, because over time you build relationships and you can understand who has a better grasp of IP, the non-attorneys that you, or the non-legal partners that you work with, well, non-attorneys that you work with, who has a better grasp of IP, because some, I might have suggested do a Google search, and I'd love to suggest, just does anything pop up immediately? But also with some others, you might not want them taking that first step. I just want you to bring your ideas to me because I've seen some of the results from that have happened, and just bring it to legal and we'll take care of it. But for others, like the ongoing training, just having regular sessions explaining what it is that we do, what it is that we look for as our processes develop, also explaining that to them, like, hey, now we have these tools. And sometimes there may be a way to also allow for some tools access to some people that have a good understanding, a good grasp of IP. But just having that understanding of who it is that you're working with, I think also will direct you on what tools you suggest that they utilize.
Chair, go ahead, advance the slide.
Absolutely. Next topic is optimizing in-house outside counsel relationship. And we've touched on this already, but we would love to sort of have everybody's take on how you evaluate what work stays in-house versus what work suited for outside counsel as far as cost, efficiency, and business impact.
All right, sure. So let's see, like big picture, first of all, like a lot of prosecution and strategy for filings and that kind of thing are in. I tend to think of that as in-house work. And the reason is that, I and my team are really well positioned to determine what the strategy is for something like the global filing, because we understand, for example, what the business plans are for a company, what its long range plans are, how like if I were external counsel in a vacuum, I would just say, like, you should file in every country in the world. It's good for everybody. But in fact, right, like I may not ever have an intention to bring, like maybe I have a product, for instance, that requires like cold storage and travel, and there's no chance that we're going to be able to take this thing to certain markets. And so we're just not going to, it's not reasonable for us to try to police or protect the brand in that country. Or even if we do, we may not, we're going to open ourselves up to vulnerability, to non-cancellation later, that cancellation for non-use later, that sort of thing. So yeah, prosecution makes sense in-house. Litigation, I kind of agree with this slide a lot, by the way. So like, right, litigation, particularly once it starts to unfold and blossom, and then it's like, it's just big and it's really time consuming. It would, that's definitely something where I tend to bring in my external counsel to support me. And when I'm also, if I'm working on some sort of prosecution thing where I've given it a go at a response to an office action, I couldn't persuade the examining attorney, but I know there's somebody super smart at a firm that can help me maybe get over the line, then I definitely go. So there's all those one-offs all over the place, regardless of what side of prosecution or enforcement that we're talking about, that I might wind up with external counsel.
I think it definitely depends on the size and skill of your team when you're thinking about these questions. We're small and scrappy at Spanx. And so definitely, we want to influence strategy because we have all of that business knowledge and we're going to make the final strategic decision. But we do a lot of outsourcing of some of the day-to-day activity. And so when we think about who's the right partner for those outsourcing strategies, brand protection is not really going to live with lawyers. There's great companies that do the day-to-day activity around brand protection based upon our guidelines, what we want to accomplish, the marketplaces we're most focused on, and they have the technology tools to enable that collaboration with the in-house team. When it comes to the portfolio piece, that's a piece that we outsource, and we're continually looking at technology platforms and business partnerships so that we have that transparency and visibility into our portfolio, and we can plan around maintenance fees and statements of use and international use declarations where we know we're going to have to put some information together. But what about actually talking to the business 6 months before? You got to talk about your marketing spend on a particular brand and get ahead of that so the business can go, oh yeah, we actually have documentation. Do you want us to increase our spend? Right? Does it make sense to do that? Because this is a really important mark that we want to maintain. So I would say that that business intelligence piece is a piece that we're always looking at. Whereas we look at our outsourced partnerships, whether it's lawyers or vendors, how can we be more collaborative using technology and having that transparency and visibility so we can stay ahead of some of those things that are more transactional in nature, but also have good visibility on the strategic pieces where we're really partnering with our external partners to really understand strategy and execute on strategy in a manner that makes sense for everybody. We have an e-control partner, right? We have lots of different partners. And I would say the other piece that's really important for us, because we have a lot of brand knockoff issues, is our international relationships, where our international partners have that direct connection to law enforcement and the ministries and can help us navigate the local activities. I call this street sense. We want to have the right partners with street sense. And that's a very important spend and collection of partnerships for us as a brand.
I wholeheartedly agree with just team size and budget being one of the factors that shapes what stays in-house and what goes to outside counsel. In addition to that, I think leadership also makes a determining factor in that decision as well, just whether they have a preference on how to direct those two items. But I agree with this slide for the most part as well, but for portfolio strategy, I think while that is an in-house, that does stay in-house, that's an in-house function. Oftentimes we utilize outside counsel to help do the research, to inform that strategy, to help us make those decisions. But we also, I think it comes to just the team size, if we have a larger team, we might be more inclined to do a lot more of this work in-house. But as that size might change, we might get a smaller team, then we may have to lean on outside counsel more for a season, or just the strategy may shift to sending more things to outside counsel. But yeah, largely I agree with the slide as it appears.
I mean, I as well. I think outside, I'd say you execute, inside we sort of build and determine strategy. But I think just to take it even further, I think the more we align and the more we collaborate outside and inside, I think makes for the most successful sort of the relationship, right? I sometimes am amazed at how, and trust me, again, remember I said I've been outside and now I'm in-house. So I understand the pressures of, outside counsel having, 50, and I don't want to be, 100,000 clients that they have to tend to. And so giving, specific attention to each client is not easy, but I do think you've got as outside counsel to really take that time to really understand that portfolio strategy, the risk tolerance of the business that, we are responsible for in-house. The budget, how often are you talking about what's your budget for the next fiscal year vis-a-vis the work that I do for you? If you think about sort of what are the results you're looking for? What are the solutions? And having those conversations versus, how many hours should I spend on this project? I never even talk about that, right? Like that never even comes up. Like, is it going to take you 20 hours to do this? No, like, what are we getting for this? What's the value? So I think having that close connection. One thing I'll ask, and I won't ask by show of hands because I'll never do that to embarrass anybody, but I do ask to think hard about how often, if at all, you as outside counsel are meeting with your in-house lawyers and teams to ask if it's on a yearly basis, every 2 years, every 3, if it's difficult, but how are we doing? How are we aligning with you? Are we doing a great job here? are there places we have opportunity, right? What are the things on the horizon for you? As a business, we are always dealing with new initiatives. I'm thinking of, AI adoption and digital literacy. And, now at our company, we're doing a lot around leadership prescriptions and changing what that looks like as leaders at the company. Are you in tune with what's happening? And I say, if you're not doing a regular check-in, you need to check on that, because it's important to us as inside counsel to see, in-house lawyers, to see that our outside counsel and prospective are actually interested in what's going on in our business. And if you don't know and understand that integrally, I think it's hard to be a great partner and have a great relationship.
Leads into the next topic I wanted to raise, which is how do you define a high-performing outside? Is it number of times throughout the year that they're checking in? Is it this person I know knows the industry, and so I can go to them and they understand from a trademark perspective what's happening in the industry? What makes I think a lot of us here today are in private practice, and so when we're working with our corporate clients, what are other things that we should keep in mind to become one of those high-performing, reliable outside counsel that you know you're going to go to every time to get the advice and help that you need?
That's a great question. I like that one. So I'll throw out a couple of things. So one thing that I like to see from my external counsel, so important to me, is that they have thought through the problem, but they've given me a clear recommendation on a solution. It's like, it doesn't have to be singular. There might be more than one path forward, but that I understand your conclusion of where you would go if you were in my shoes. I agree with that slide previously that it's up to me to make something like a key enforcement call. But if my external counsel can make that easier by making it clear what the call is, should be from their point of view, it really helps. It's not as helpful if it's like you ask a question and you get, here's every conceivable thing you might be able to do, including bringing it to the Supreme Court, which we all know isn't going to happen. It's very helpful to have clarity on what to do. That's one thing. And I also want to, and one thought, and I also want to second what Oma said earlier, which is like understanding the business. Frankly, I don't think I fully appreciated how important that was before I came in-house. And as in-house, it's just a symptom. But when I see someone, like when I get on a call with my external counsel and they're like, hey, I saw XYZ on the news about your company. Like, I know they're watching the news because that's only news that I see. Like, my wife thinks I'm crazy because I'll be like, did you see in the news the thing about what happened to Sprite? And she'll be like, that's not in normal people's news. And it's, so we're very weird. The in-house counsels, they're weird because they're like in this niche area that they're completely obsessed with. And so external counsel is like very helpful. It's very convincing to us that you get it when you're also in those weeds with us. So those are my two pieces.
I'd say that one thing that's very helpful is when your outside counsel will go along the business interaction journey with you based upon the legal advice, right? So I've worked with a variety of counsel when I was outside and, also in-house, where they would go up to the line and give you this very complex answer. And then I really would want that thought partnership on, okay, let me give you some variables or some factors in our business. Let's work through this together. And I'm honestly looking for that working through it together. You're not going to make the business decision for me, right? But I want to be able to think through this with somebody else who really understands the legal issues. And that's very valuable for me and my outside counsel, is to not only understand the business, have spent the time with the business, but to be that business thought partner with me, to meld the legal with the business risks, to help me work with my team and ultimately make some recommendations on the information that we have. The other thing I think is really helpful is when we work through how we work together, right? And we start to get a good rhythm. Are there things where it's a particular type of matter where there's a team that they need specific information from? I don't have time to be the middle woman in that journey to get the exact information they need. can I turn it over to them and trust that they can talk the business language to be able to gather that information so that then we can get to the final product we need to get through, right? When I can turn those trusted relationships over to the business, that's a successful relationship. We built trust on both sides. They know when they need to come back to me on certain risky issues, but the business can work with certain outside counsel direction.
Yeah, several great points already made. Just to give two other thoughts. Is outside counsel providing me with different tools that I can use to make to be more successful at my job? And when I say that, I mean, are they updating me with different case law, different trends, different news? Andy mentioned he's reading the news, and it's good to see when outside counsel references something that he might have picked up on, but also providing news that maybe I didn't see. Oftentimes, our resources are a lot more limited than the resources that firms have. So it's valuable when you might come across an article that's relevant to our business, or you understand a decision or a path that we have discussed, and this could impact that decision. So I think just also being a resource from that perspective is also a tool that I think can distinguish different outside counsel. Also, are you giving me enough information to make the decisions that I need to make on my side? Because when you're in-house, you're in meetings all day, all the time. It's hard. When I have a day or a morning without meetings, I get excited because I know like work is gonna get done. But when I have to then I come back to the email and I see that I have to follow up for more information, which I would assume could have been in that initial email. It's just, it slows down the process. So just making sure that those emails and the information you're providing addresses questions that you might think would be natural follow-ups. So just providing sufficient information, I think, is another thing that, while it might sound common, it isn't always.
And yes, I'm going to say again, the regular touch points are critical. That to me distinguishes sometimes the good from the very good outside counsel. The other thing, and we had this conversation, so I want Brent to back me up or dispute. But for me, the business grounded advice versus what I call those memo dumps is what I'm looking for. So you bring back an opinion on, whatever the matter, but let's just say it's a clearance surge and it's, a 10-page or 5-page memo. And maybe no executive summary, no headline. And so those are hard for in-house counsel. Again, we're in meeting after meeting after meeting, hard to decipher, to just, drill down to what exactly is the solution. And I know it's hard to, obviously, we're not asking you to say, make the business decision, but help me have enough information to literally just make that decision on my own without having to read many, many, many pages. Now, we talked about, it might be that some outside counsel feel, so I'd love for you to say, because I'm like, I need it to be clear, decisive recommendation and not long sort of, very, I almost call it academic or theoretical, but I'd love to hear.
Yeah, so my counter to that was also just understanding who the recipient of that information is. So while AUMA and Antigone, they, general counsel, chief IP counsel, they may receive a different email than you send to counsel, associate general counsel, or someone, a little lower on that totem pole, where we might need more support to back up the decision when presenting it to the general counsel or chief IP officer. But once it gets to, if you're communicating directly with, those officers, then your email and the tone and the length should be a lot different. Brevity is always key. Even if it's a quick, here's the answer, see below if you have some free leisure reading time, that might be an approach to take. So the answer I'm looking for, but if I have, just thoughts later, I can come back and I'll see the analysis and the case that backs up that decision.
One last practical thought for external counsel to consider for us is like staff appropriately. Like it just comes down to dollars. Sometimes there will be certain matters where I'm like, I'm thinking like, how do I want to staff for this? And sometimes it'll come down to the costs. And if, you know, I mean, I absolutely want experts on the call, but if there's like 3 partners that I'm doing the budget and I see how expensive all the 3 partners are, and they're all kind of in the same, they all have the same point of view at the end of the day. Maybe I just need one of them.
Can I also say too, just those free CLEs or seminars that outside counsel do are so important, and we take note. I'll just give a personal, so recently, part of my remit is now ad tech. Ad tech typically will sit in some companies with the privacy legal, sometimes cybersecurity legal team, sometimes compliance. For us, it's now coming within the intellectual property group. And the minute I said that, I remember somebody who doesn't do work for us immediately said, oh my gosh, I can put together a small team and we can do some presentation for you, because I know, Auma, I know you in and out. I know you do not do pixel and tracking technologies as you're in your day job. So how can we help you? And that was so important. And of course, I'm like, note to self, right? And so thinking about, sending those articles, great, decide, maybe sort of helping people understand a key issue that's coming up in their industry, but thinking, just listening for those places where you can plug in and really give that inside lawyer an opportunity not to have to worry so much about how do I figure this out? And then maybe even monthly providing updates or being very intentional. And I say, listen, people say, can I send you or should I? Yes. Now, I think it's polite to ask, but I do think that is something that is always beneficial for us, just because time is so limited.
Risk tolerance litigation in the past 2 years. I guess I'd just like to open with the question of how do you prioritize enforcement decisions within your different organizations?
Oh yeah, go ahead.
So I would say part of it is how much does it matter, right? Because you could spend every day, all day enforcing your trademark portfolio multinationally. And if you've ever been in places like India, the oppositions go forever, right? And so you have to be, again, strategic about how you're thinking about this. I think this goes back to protect what you want to protect and then enforce against that based upon your priorities. And those priorities also include some of these business concepts around, is this a significant strategic market for us? Is this a big counterfeit market in terms of manufacturers? Is this a market where we believe ultimately we're going to move into in the future? So this actually makes a lot of sense for us today. So all of those things are part of the mix when you're thinking about enforcement, but we do have to make dollar-based enforcement decisions every day. And also talk with the business to understand not only where are we in certain jurisdictions today in terms of that mark activity, but where do we want to be in the future? And the business moves very quickly, right? So the answer you heard last week may not be the answer this week. So I would say this is a constant judgment. But ultimately, we have to call balls and strikes, right? We have to make a decision about whether we're going to enforce against somebody who's sort of like our mark in Russia, right? We probably won't be in Russia in the foreseeable future versus another place where it's our 3rd largest market. I'm probably going to put some money there, right? So all of this is about, for us particularly, making data-based decisions and business-informed decisions and highest and best use of our offensive protection activity. I would also say different business leaders have different perspectives on how widely you want to put your elbows out in terms of protecting your brand. So really having that strategic business conversation about how far we go to protect the moat and what makes sense in light of our current and ongoing business intentions, that's a really important conversations to have. So they understand if they want to put their elbows out further, there's a cost associated with that, and they have to be willing to eat that cost.
So one thing I think when I'm thinking about enforcement, sometimes it's very helpful to think like, what is my goal for this brand? Like, what am I after for these enforcement actions? So put in more some context, like, let's say we're just talking about like oppositions. So there's some brands that are so important that are just like scorched earth, right? It's like anything that remotely close to it, anywhere in the world, you're gonna take action because you have such a clear registry, you have such a strong mark. Then you have one strategy for that brand, but you might have another brand where you've got to be realistic and you've got to be like, okay, just for example, like we're still just talking about opposition's registry, then it's like, okay, for this brand, when I look around at what the landscape looks like, I recognize realistically, there's less that I can do. There's less places I can win. And so what do I want to achieve? Like, why am I opposing these marks? And maybe it's because this is actually someone who seems like they're trying to get up in our territory, or maybe it's because they've gone over that line. They're close enough where now, even though my brand doesn't have a lot of space around it, it's got enough that I've got to defend what I've got. You know what I mean? I think it's really important on the front end to have like almost like a flow chart in your head or a strategy of like, if this happens, if I see this, I'm going to do this. If it gets to these kinds of goods, that's when it's close enough for me, that kind of thing. I think maybe similar principles apply in other kinds of enforcement. I'm just thinking here about one example.
I was just going to say also, I think it's good, and actually it's important that you have some SOPs around enforcement, that they're clear, they're defined, people are aware. You're not just making haphazard decisions. So for example, where do you sell? Where do you have presence? For us, where do you source? Where do we manufacture or have contract manufacturing activities? Where are the hotspots for counterfeiting, piracy, infringement? And those sort of stay on the list. Now we can make exceptions based on cost, based on sort of speed to market and things like that. But essentially, the SOPs are very clear, and we as the IP team are not the only ones who are aware of them, right? Our clients also, our customers also. So I think making sure that you're not sort of feeling that sense of, let me think if this is something we should do. You sort of have guidance and guidelines around what you should do and what you shouldn't. So what stays sort of within the zone of enforcement and what stays outside. And then people have to live with the decision, right? Like, somebody saying we should enforce in Russia, you might say, no, we're not going to. But again, you have that close enough partnership where there's enough respect to understand that when you're saying the answer is no, the answer is going to be no.
Does consumer perception play at all into the decision as to how hard to enforce? I mean, if you don't want to be perceived by the purchasing public or people that might look for brand as a trademark fully out there, shutting down every possible use of every possible similar mark, how important is that in the analysis, if it's important at all?
I would say very important, and we're sending and receiving more internal trademark orders than we ever did in the past. And I think part of the reason why is businesses realize that things can end up on X or other platforms, right? If somebody, particularly an individual filer, decides that if they're going to make it their cause celeb, right? So we're definitely seeing more business to business trend discussions, particularly when you've got close competitors or almost close competitors and individual filers that you're dealing with, which I appreciate, right? I'd much rather have a business discussion if we've potentially got a problem, to talk about a sell-through period, to really have the human discussion with a business leader on the other side about, I'm not here to talk about all the legal issues, but I see some other stuff on the register that's closer, and let's find a business path forward. So we're definitely seeing that trend. And I think that that's supportive of what we're trying to accomplish, is sort of keep it out of the public forum and try to move forward as a business, make those decisions, make those risk analysis. And if there's an issue, can we solve it internally before we have to go for an external fight?
I agree with that 100%. It forms the way you even write a letter, in my opinion. Like, right, like everything can go. Everyone has a voice, and it can be everyone's voice can be equally loud, and depending on the circumstances. So, like, if I send a letter, I try to think every time I send a letter to someone, like, am I comfortable with this being out in the world? And I've crafted it differently for someone who I mean, sometimes the person who's infringing your mark is a fan of yours. So it's like, that's your that's your target consumer. So yeah, I want them to, like, you know, they're making t-shirts because they love you. And so you just have to kindly tell them to stop making the t-shirts, and you don't wish you didn't have to, and stuff like that.
Move on. Looking at next 3 to 5 years, are there any hot button topics as it pertains to trademarks? I mean, I guess maybe AI is an obvious one, but what do you have your eye on in the next 3 to 5 years from a trademark or branding perspective, whether it's an opportunity or a tool or technology that you're looking to take advantage of, or potential risks?
Yeah, I think two things probably. You mentioned AI. I think AI is something it's not just that legal is using, but the marketing teams are also using it, and they're using it to come up with their different ideas. They're using it to create videos, and they're just using it for everything. And I think the results of their use will continue. Their use will continue to evolve over the next few years. And I think that just for us means that we need to continue having regular training with them and informing them on, different risks, pitfalls, things to when to come to us, when, just different tools that we might have learned might be better vetted just from the different resources that we have just internally or through other calls with other in-house counsel. Another thing I think would just be digital or online enforcement. Now it's like when you're trying to target these online infringers, they can, before you can even get to them, they might have taken the site down. They may rebrand it. They may bring it up later, but I think that will continue to be an issue over the next few years. And I think just continue to find different tools that can help us just have more effective online enforcement as that area continues to evolve with all of the, again, the AI tools are also impacting that. Infringers have the same tools, may probably more advanced, but often more advanced than what we're using it for. So I think just online enforcement and just the different tools that our marketing teams are using are two things that I think we're paying attention to right now and will continue to over the next few years.
Yeah, I would just say for me, I guess I mentioned ad tech, so I'm all in advertising right now. But something literally yesterday, I was having a meeting around like the whole, I think you're probably all aware of the New York AI law. I think it's going into effect June of this year, around, sort of disclosures around synthetic performers. And as I was reading some of the, like, how should I prepare our marketers and what sort of guidance I should send out, like now, in preparation for June, I started to think about deep fakes, and that just keeps me up at night a lot. And, are we over mediatized? Are executives oversaturated in terms of sort of their image, name, likeness out in the market, and all of that good stuff? So it starts to make me go, gosh, what you can do with AI. Today, maybe we're not worried as much, but like I am thinking we should probably be thinking about that really hard. So.
Look, I guess I'm gonna have to stick on the AI thing because it really is so central right now. I mean, and the two big places that I see it being really important in the next couple of years for trademark and IP attorneys is right? When our marketers want to make something, they want to own it. And of course, there's all these challenges around what ownership looks like when you create something using prompts or and using AI. It's really important to find strategies to help them own this thing to the best of your ability, to understand what human contribution means in the copyright context and how to get some human contribution in there so you own something. And then I think it's also for us attorneys, obviously it's a tool. I don't know. I don't know about you guys but at my company, I think a lot of companies, there's just a really strong push for us to find ways to leverage that tool and for our own practice. And I think that's that's thorny because it's like, there's room for incredible efficiency. I think there's a lot of potential value. I see a lot of possibility for for the future of AI as it relates to, for example, trademark clearance in particular. But I also see a lot of problems with it and a lot of ways that it could can feel a lot like a solution, that it doesn't actually solve the problem. So I don't know, that's the stuff I see coming.
I'll just add a few notes on the consumer and brand protection perspective. I think one of the most interesting things that's happening now is the in-chat shopping experience effort by OpenAI and some other parties as they're trying to figure out how to monetize their AI offerings. And I will share that we're part of the beta in-cart experience with Shopify. This is publicly disclosed. So Spanx made the decision to get in there early and understand what's happening with the idea we might sort of block the gate for others who are trying to sell knockoffs of our product, but we actually don't know what the future looks like going forward, right? What rules will they have in place as part of this private browsing, private chat shopping experience? And it's a lot like the issues we see with fake Instagram accounts from our founder that then take people over to private Telegram channels. There's more walled garden activity happening where we have less visibility around our trademark issues. And I think that is a challenge today and will continue to be a challenge. The other thing I'll highlight is the proliferation of fake ads on major sites, whether it's Amazon, Meta, all the Meta properties is a big problem today, and AI has really put it on steroids. So, the consumer experience on these platforms, it looks like a legitimate ad. It's probably a ripped off version of our influencer video or a mashed up version. And then they're sent to a website where the URL is not clear. That website was set up using AI, ripping off our images, right? It's really automated and reduced the friction around some of the brand issues in a way that I just couldn't have imagined 2 years ago. And I think we're going to see more of that, right? So really understanding the technology and bringing in partners who can help track and trace, right? I think one of the most interesting changes we've made as an organization is thinking about some of these issues a little bit differently and getting people who have intelligence backgrounds and enforcement backgrounds who really understand deep intelligence techniques to try to find those bad actors that are a real problem for us. Using some of those methodologies, it's really changing the way that we're approaching certain brand protection issues.
Probably time, guys, but if anybody has a good question or two, I'll give you guys a couple extras. There you go.
How are each of your companies balancing the efficiency with AI and confidential issues, especially maybe the marketing department that doesn't understand? Could you put a trade secret into AI that might?
I could say quickly, very controlled environments, a lot of training. I almost think that over education and over has helped. And so if ever in doubt, folks are really calling the legal departments. I think it's making sure that people are exposed to what the risks are, and that's not just training once, but sort of periodic.
All right, everyone, we're gonna go ahead and get started with our last session before lunch. I promise you it would be well worth your time. As I said at the beginning, my name is Devin Knapp. I'm the co-chair of the Patent Committee. I'm joined today by my other co-chair and co-moderator, Clint South. Today's panel is going to be focusing on the various ways in which artificial intelligence is affecting the practice of patent law, starting from AI-assisted inventorship and those issues to the increasing availability of AI tools and services in the legal industry broadly, but also in the practice of patent law. My panelists behind me, up first we have Jason Chang. Jason is the Assistant Vice President and Head of Patent Development at AT&T. In his role, he spearheads AT&T's patent prosecution team, overseeing the strategic management of AT&T's extensive patent portfolio. His expertise extends to negotiating IP contract provisions with a diverse range of vendors and suppliers, alongside managing pre-litigation defensive patent matters. Up next is Yuri Eliezer. Yuri is the co-founder and CEO of Junior AI. With nearly 2 decades of prosecution experience, Yuri strives to use his firsthand knowledge of the legal industry to develop innovative methods to improve the practice of law. He has been recognized as a player in the law practice technology field. Furthermore, Yuri has also been invited by the United States Patent and Trademark Office to provide technical training and industry insight to patent examiners. Last and most certainly not least, joining us virtually is Professor Artie K. Rai. Artie is the Elvin R. Laddie Professor of Law and Faculty Director of the Center for Innovation Policy at Duke University School of Law. Her recent publications focus on the influences of artificial intelligence on patent law. In addition to her work in academia, Artie has held numerous governmental positions, including a recent stint as a senior advisor on innovation law and policy issues to the U.S. Department of Commerce's Office of the General Counsel. As we begin to discuss the different influences that artificial intelligence has on patent law, I think it's helpful to start from the beginning, from when inventors come up with their inventions, their specific innovations. So, Artie, recently the United States Patent and Trademark Office issued some new guidance as it relates to AI-assisted inventorship and how much AI is too much for an inventor. Can you kind of tell us more about this guidance, its potential effects on inventors receiving patent protection?
Sure. First of all, thank you so much for inviting me. I hope everyone can hear me all right. Devin, can you tell me if the audio is okay?
Yes, we can hear you well.
Terrific. All right. Well, my apologies for being unable to be there in person, but I live in North Carolina, so it's a little bit more difficult than that, given on teaching days, to participate in person. So yes, thank you, Devin. I think it's a quite explicit departure from the 2024 guidance that relied quite heavily on the idea that the PANU versus IOLAB factors for joint inventorship among natural persons might have some relevance to inventorship using AI. And so that prior guidance has now been rescinded, as you probably know, in its entirety by the 2025 guidance. And the 2025 guidance makes it really clear that in the view of the current PTO, PANU only applies to joint inventorship issues when they occur among natural persons. And so it doesn't apply in the context of AI use. The guidance characterizes AI use and AI more generally as just like use of other tools like lab equipment or other types of software or databases. And so as a consequence, the guidance provides the view that only humans can have conception in the traditional sense of a, quote, definite and permanent idea as it is hereafter to be applied in practice. So that's the very canonical view of conception from the Federal Circuit. And the guidance is pretty explicit that it says that only humans can have that sort of conception. So as a consequence, only humans can be inventors. All of that suggests to me that for purposes of getting a patent at the PTO, the office is not necessarily that interested in knowing a lot about what AI use the inventor had, and so it may be quite a difference in tone, at least from the prior guidance. Now, of course, that doesn't necessarily tell us about what the courts will do eventually, but it does tell us, I think, where the PTO is with respect to only humans being inventors.
Thank you. And so I guess building on that, is there anything that you think practitioners should be aware of to advise inventors on as, artificial intelligence becomes increasingly present in, their scientific practices?
Yes, absolutely. I don't think that the PTO guidance is the last word. We all know that PTO guidance is not law. And so I think, this is consistent with what I've seen in the general law firm kind of literature that I've reviewed, and also in speaking with law firm lawyers, that we should continue, or maybe even more so than in the past, inventors should be really very careful about documenting exactly what they have done in terms of their AI use. So if they developed, for example, a proprietary model, they should be very careful in documenting exactly how they developed the proprietary model, because that could be important for future challenges. If the model is not proprietary, or even if it is, they should, in addition, be very careful in documenting their prompts, any iterations they've done with respect to AI use in terms of their prompts. They should also document what they have done with respect to output from the AI system, and more specifically, what sorts of refinements they've made with respect to outputs from the AI system. So all along the way, all of the human aspects of the interaction should be documented, in my view, by inventors, because that is, it seems to me, best practices for purposes of anything that could come down the line in terms of a challenge.
Yuri or Jason, do you have any additional comments regarding this?
Hi. So inventorship is always a really tough issue to think about. What I will say is that I think Professor Artie is correct, which is you should document it from an inventor standpoint. What I would tell you is, from a practical perspective of having thousands of inventors across the company, that is an overwhelming challenge for us as a company. The reason why I say this is because inventors have this notion that, for example, if I use AI, my company will like my invention disclosure a lot better, right? And that my outside counsel won't need to spend as much time on it. And I actually think that's exactly the opposite, right? Is imagine yourself as outside counsel, and you now have a 30-page disclosure that looks like a patent application. You have no idea what the invention is. You don't know what's important. And now I have to give outside counsel all this record of prompts and, what the output was. What are you guys going to do with that? I mean, it's very complicated. And so what I'll say is, from my perspective, what I would tell my inventors is, you don't have to use AI, right? It's not going to make your invention better in my perspective. I'm no more likely to approve it. And I would rather you just write it the way you previously did, in a way that allows me to understand where your inventive elements are and kind of how you're using it, so that we know where to focus on.
And then, sort of building on something that you had mentioned, Artie, this guidance is not binding on the courts, and it rescinded guidance from 2024. There could very well be new guidance published later this year. It could change in the next administration. Who knows? So is there anything that you would say, practitioners should, should they not take this guidance as gospel just yet?
Yeah, I mean, I think that in general, PTO guidance has never been gospel. The PTO has never gotten Chevron deference, even when that existed in the court system generally. It no longer exists for any agency, but the PTO guidance has never been treated by the courts, in particular the Federal Circuit, as anything other than advisory. So yeah, I mean, I see where Jason is coming from in terms of not necessarily wanting to have inventors document everything that's quite onerous. But then I do worry that if they are using AI, I mean, it's a different question, obviously, if they're not using AI. But they are using AI, and that comes out in discovery down the line. If there isn't some documentation of what the human did, then I do get concerned about what would happen with the courts and how they would think about whether there was sufficient evidence of human conception. I've actually written on the ways in which my view is that given the pervasiveness of AI use, at least in certain industries, there should perhaps be less concern about there's this old-fashioned view of conception that we used to have of the human having this complete idea in their head. That's a kind of a little bit of an antiquated notion, and reduction to practice should be the more important piece of the puzzle. But I'm not going to be able to tell the courts what to do. So it'll be interesting to see how the courts think about the conception versus reduction to practice kind of balance in inventorship going forward as well.
Thank you, Artie. And I guess another thought on that is that this guidance and the USPTO don't really require you to disclose the use of AI, though sometimes they say it must be disclosed if it's materially relevant to patentability. But do you have any thoughts on, maybe having a requirement for disclosing the use of AI by inventors or, in their inventive process?
Yeah, so I wouldn't have a requirement, and certainly this guidance, I think, would seem to suggest that they don't want to know. The PTO doesn't want to know necessarily, even if you did use AI. So it's certainly under this guidance, I wouldn't counsel inventors to spend a lot of time thinking about that for purposes of their patent application. I do think that going forward, in future administrations and the like, it'll be interesting to see if the courts end up saying, in the context of, say, some sort of litigation dispute over inventorship, well, the discovery yielded this information about how AI was used, and as a consequence, we think this is the balance that we'd like to strike in terms of humans being involved vis-a-vis what AI did. If that ends up being the law from the courts, then the guidance will have to change, it seems to me, because right now we don't have any law on kind of what that balance is. And so in that case, things will be very different. But given the current lack of law and the fact that the PTO is the only entity that has explicitly addressed the question, in the current administration, it seems that they don't want really to know about AI use. And that doesn't mean that I don't think inventors, I know, again, I see the point about onerousness. I still think that inventors, if they're using AI, should have some sense of how they are contributing vis-a-vis the AI. But that doesn't have to be in the patent application.
Yep. Thank you so much. I wanted to see if Yuri or Jason have any additional comments on that before we start to move on. Okay, thanks. Well, so in a similar vein of inventors using artificial intelligence, practitioners are starting to see inventors using AI to draft their own patent applications or even court documents. So my question for the panel is, what are the ramifications of inventors starting to use AI to draft their own applications, their own court documents, their own office action responses?
I mean, I think I addressed a lot of it earlier, but I think it creates a lot more work for everyone downstream, right? Which is, if you give me a work product that is lengthy and it kind of hides the ball, from the inventor's perspective and the engineer's perspective, they'll tell you, wow, this looks really good. And, from this level up, like really high, I would say, yeah, I really agree with that. But when we dig in, it's not great. And I have a lot of concerns about inventors trying to do essentially legal work and not really having the training to understand what they're doing.
I guess I'll chime in. So what is writing a patent application? Let me start with that. And maybe a primitive way of seeing it is, when I drafted patents, starts out with, how well do I break down the invention into its fundamental parts, and how good is my process for breaking down any invention you throw at me into the right foundations for me then to understand and decide, what am I going to claim? What is the strategic value of what to protect here? And then there's the writing of the patent application phase. Now I actually reconstruct the invention, maybe not in the way the inventor originally presented, because a patent is ultimately a legal document in which my job is to accurately and technically reconstruct the invention so it could be used by one of ordinary skill in the field, but in a way that adheres to the drafting guidelines and all the rules and the case law that many inventors would argue we created ourselves just to have a job to do. But that is the process. Now, where can they be useful in that process? Where can they speed up the result? Probably not in the reconstructing phase, but probably in helping me deconstruct and get down to the core and provide me a good starting point. But if I'm being honest, I don't think putting a patent application together is that difficult. I think the hardest part is understanding the technically difficult inventions that I'm writing about. And the rest is formulaic. Once I decide, using my judgment, what I'm going to claim and how, yeah, the rest I would trust AI to do. And if and when a tool is good enough for the inventors to use that will, as Jason put, actually save me time, I would encourage it. I think it's increases the access to the patent system worldwide and is overall good.
So Jason, I'll start with you. I think a lot of us in the room, particularly that are law firm lawyers, are looking for sort of clues, insight into how our clients using AI, implementing them in the patenting process. And you can talk about sort of what it looks like currently. You can also feel free to scare us with your future visions of AI agents running the world, operating independently.
Yeah, I'm happy to do that. And I sit at a really interesting point in time. And when ChatGPT first got released to the public, I think this was at the end of 2022. I remember being one of the very first people to kind of sign up and be able to kind of see the prototype of it. And it was only a couple months later that I got introduced to a patent drafting program. And just because I enjoy technology, I just had to demo it and see what it can do. But after that demo, I got on the call with 3 of my law firms. I told them all of this. I believe this is the future in terms of what you already kind of referred to in terms of patent drafting, office action drafting, all of the drafting exercises. But what has unfolded over the last 2 years has been a diverse range of responses. And in fact, my 3 law firms are exact examples of how firms are reacting. Well, first, a firm that actually ended up embracing it the most was also the one that pushed back the most at the beginning. Basically, they said, I've seen this before, right? This is like ClaimsMaster. This is like all the other AI tools I've seen. This is just hype. No, it's not. I completely disagree. I believe in over the next couple of years, the law firms that AT&T keeps are going to be the ones that use it the most, and in the right way too. And I'll caveat that a little bit later. So what did this one firm do? As of just a couple of months ago, they have released their own version of AI drafting software. So they actually went out, invested in developing their own solution, and now have released it into the marketplace. That's pretty crazy, in my opinion, right? Is they've accomplished this in the matter of 1 year, including getting their SOC 2 compliance done as well. That is a phenomenal pace. I have one other law firm that basically is telling me that we'll use it when you force us to, right? And then I have one in the middle that basically says, I know I need to get on board and I'm doing demos, but it's like riding a bike. It's really hard when I first start, right? And that's they're ultimately going to get on board, but these tools are expensive, right? You have to decide which one to pick. And now there's a lot of tools to pick from. I mean, who do you pick? Who do you go on board with? And I have that same issue because while we don't do drafting in-house, we have to approve the tools that our law firms want to use. And so I have to go through these demos and decide which ones are okay to use from an AT&T perspective. Now that I've set the stage and kind of let you know that my law firms do the drafting, I'll kind of tell you what we do in-house, at least what I'm thinking about. Some of this we've actually implemented, some we have not, and we may never implement it. But I want you to think about AI from the whole continuum of my invention disclosure from my inventors, all the way to patent grant issuance, right? And how you could apply AI at every stage of the patenting process. So I think Professor Artie kind of mentioned is have engineers use AI to help draft those invention disclosure forms, right? And there's a lot of issues in terms of potentially doing that. But when the invention drafts get submitted to my team, now we have to evaluate it. Our decision point is basically from an in-house perspective, do we pursue this invention or not? And there's a lot of factors we consider, right? We consider whether it ties into our business, what our other filings look like. But you can imagine that you can have an AI workflow basically evaluate that invention disclosure. It can tell you, for example, how it scores according to your guiding principles. It can tell you which patent developer should get this, right? So a lot of the workflow can be done. Now imagine once you get an office action in, what can you use AI for, right? You can, for example, analyze the prior art, you can analyze the office action, potentially think about how you might want to respond. So if there's two options that I can proceed, which one helps AT&T the most according to where we want to go, right? And we've started doing this. And what this means is that we used to wait for our law firms to give us a recommendation as to what we should do in terms of an office action response. We're now within 2 weeks telling them, this is what I think we should do, right? And now I have my outside counsel telling me that I don't know who's the outside counsel anymore. I mean, you guys are beating us to the punch in terms of where you think we should go. And I think that's a very uncomfortable feeling right now. And it's something that I haven't resolved, my team hasn't resolved, but the tool is powerful enough where we feel like we're giving good recommendations in terms of where we should take these claims. Now, we're not telling our outside counsel how to draft the claims, but we're saying this looks like an opportunity that we as a company want to head down. So help figure it out, whether you can draft a claim amendment that matches this. Think about it also when you get a notice of allowance or when we get a notice of allowance. we have to make certain decisions, right? Do we file a continuation application? What subject matter would be helpful to AT&T? Those are all decisions that can be AI assisted, right? And so we actually have implemented this, and that helps us make a better decision. Now think about after your patent issues, and when you get to the maintenance phase, right? We have thousands of decisions that need to be made every single year. The question is can we use AI in a way that helps us inform those decisions, decides, are there certain inventions that I think are more fruitful than others? And, we haven't built that yet, but what I can tell you is that I just saw a LinkedIn post from one of my counterparts at another company, and they've already prototyped this, right? Is they've taken 30 hours of work down to, an hour. It is an incredible time in terms of what you can do with AI right now. So I think that's how to answer this.
And one follow-up question is kind of what you just talked about, which is, if AI can turn 2,000 hourly, yearly hours into 200 hours, and first, what do we do with the rest of those hours as patent lawyers or IP lawyers? And then, secondly, what does this say for potentially, a complete segment of the patent legal market, if that's where we're going potentially?
Wow, this is a pretty deep question, right? Because I've been struggling this. I've been outside counsel before. I've been inside counsel. Here's the issue that I struggle with the most, right? Is I initially think about what is the theoretical maximum number of office action responses any one of us here could potentially draft in a year. And I think the most comfortable situation is you do one a week for the whole year. I'm one a day and in a week you can do 5, and roughly 45 weeks you can do 225 office action responses, right? And I've been challenged. I mean, people have asked me, we think our outside counsel can do double that. So, instead of giving people 8 hours to draft an office action response, can they do it in 4? Right? And I think conceptually that sounds okay, right? You could just do 2 a day. But I can't even imagine who here could draft 450 office action responses in a year while still keeping up with the rest of your work. I mean, that's a lot. I can't imagine how we keep people from not burning out at that rate. And the same question also applies for new application drafts, right? When I first started practice, I think roughly we had 30 hours to draft a new application. By the time I left, I think we were down to roughly 22 hours. And now the question is, and Yuri will give a lot of insight in this, man, can we get that down to 10 hours? Like, how fast would you have to work to do that? And could the tools help us get there? But even if you could you keep up that pace for the whole year, right? So roughly every day and a half, you're starting from an invention disclosure call to a draft that you just filed, right? And so roughly every week, you're now potentially throwing out 3 full new applications from beginning to end. That's a lot, right? I don't know how many people can do it. I mean, that's 150 application drafts a year. Maybe you're doing some office action responses along the way, but I don't have the answers right now. I'm just asking the questions, trying to figure out what we do in this situation, but I'm hoping that maybe Yuri has solved some of this for us.
Yeah, that's a good point to transition to this second topic, which is we can start with Yuri. I think a lot of us, this has moved so fast, and I think also that are outside counsel, if you want to think of us that way, are curious, very curious about what all are the products that are out there? How do we go about learning how to use them and demoing them? And for example, how do you distinguish between, ChatGPT versus other more highly specialized products for in the chemical space, for instance? I know I can't put a chemical structure into ChatGPT and get any kind of meaningful output, but what does the landscape look like for current products, and what are your thoughts on how we might, as outside counsel, go about learning more about them and trying to get our hands into this field?
Well, it's a great question. But first, I'd like to address what Jason mentioned, and I think the question of outside counsel's role is very interesting, but also the USPTO itself in adopting AI is very interesting. And the reason I bring that up is because we're still looking at it in the framework of getting, drafting a patent application and then getting office actions and getting a notice allowance, and that process taking a year and a half, 2.5 years. What if that process comes down to, maybe a month or 3 months, and why do you have to even draft a patent application that's going to get rejected? In many ways, I hope that one day that anyone, can have a good work product without a patent attorney being, or a patent agent or representative being a necessary item if they don't need one or can't afford one. So that is interesting to me, is the direct to USPTO system. And the USPTO is very technologically advanced compared to many other agencies. So what happens when applicants just go straight to the USPTO, and why not? Right? So, but now there's a lot of folks looking to solve problems, and primarily in legal, because we are the word. Our work product is the word, and a combination of words, if you see it that way. Everything comes down to the deliverable, which is generally a document. And when AI gets better and better through all these tools at producing the document, whether it's a patent or a complaint you're going to file in court, what becomes the job of the attorney? And what job do you want to do as an attorney? And maybe there's a tool out there that keeps you doing what you enjoy doing and takes the rest off of your plate. And I think that what ultimately our job is going to become is curating a very good sequence of inputs and being proficient in reviewing the outputs. Because I think lawyers are there to underwrite a contract, underwrite a patent. I'm hired because I know what I'm doing, right? So however it's produced, I still need to sign something. And as long as I need to sign something, I need to be inside of a document. That's the way I see it. And if I don't need to sign something, then why can't my client just use this tool? I don't know if that was responsive or not.
Yeah, I'm not sure a lot of us wanted to hear that. But yeah, the other part of the question kind of was this, the products that are out, the marketplace for AI products for lawyers, whether it be your general purpose products like, I know, for example, ChatGPT, obviously firms have different, and maybe individual practitioners have their own rules about what they can and can't use and why. Some of this may eventually get into bar rules, or ethical rules. But the products that are out there that are both general purpose and specialized products, how are they different? How do they work? And where do we as lawyers go about learning how to use them?
Well, I've tried to get Georgia Tech to host, and if there's anyone from Georgia Tech in the audience, I try to get them to host a general review of all the different tools out there for patent attorneys, an objective, unbiased assessment, a scoring, a ranking system based on parameters like many other AI fields do. And it's been hard to put that together. I hope someone does. what I would look for the most for every attorney, not just patent attorneys, is the following. How much does this decrease my review time? Specifically review time. Is this adding more for me to review or reducing how much I have to review? So, in general, I wouldn't say do a Google search. I'd say go to conferences and meet people. But every player is entering even law firms themselves are entering the AI space. Even your clients are entering the AI space. And if you're not preparing your library of prompts and your style and your training data sets and using AI, you're probably very close to retirement, or have a strong relationship with your clients. And the two lawyers I like to say are generally safe are the ones who show up in a courtroom and the ones who show up in a boardroom. Outside of that, if your work is transactional, you're underwriting a document, then look for tools that help you reduce document review time.
I will just say, with the rise of these tools, I think we as attorneys have to be very careful what we offload to the AI systems. So one thing that I've made a decision for my company is that our law firms should never offload the drafting, at least of the independent claims, to AI, right? Because the less you do of something, the worse you get at it. And in my opinion, claims are the most important. So if you lose your skill, you're not going to add the value that I want you to add to our cases. So and this is kind of the rub for all of us here, which is, I think most people saw the Wall Street Journal article that basically says we are getting dumber because we are, you stop thinking, right? Think of how many of us use GPS and you don't even think about where you're going anymore, right? So I think we have to be very conscious as to, is this something that I want to get worse at, or is this something I want to get better at, and only offload the things that are not adding value?
Jason, can I follow here on that?
Yeah.
I completely agree. Claim drafting is critical to use, human intelligence for. But what aspect of human intelligence would you say that requires? Is that my lawyer training or is that my engineer training?
It's I think it's both, right? I mean, I don't see how you kind of not understand the technology versus, the legal aspect of how to draw the bounds around that technology. What I will say is that part of my reasoning for having our law firms draft by hand the first independent claim is it's really hard to think outside the box once AI shows you a claim.
That's a good point.
Like you see it and it's like, man, it looks pretty good. Like, how would I rewrite this? And you've kind of locked yourself in. So I would say, don't use it before you have a couple of options on paper.
That's a very good pointer.
Yeah, along those lines, your product is junior AI. And, if I were to, for example, give ChatGPT a claim and ask it to suggest an amendment that would overcome a piece of prior art, ChatGPT has a brain behind it. Your product has a brain. Obviously, you don't have to disclose or divulge, trade secret or craft here, but what differentiates these specialized products like Junior from your general purpose sort of $20 a month subscription product like ChatGPT?
Fundamentally, it's, does AI save you time? And the rewrite you would have to do. I think ChatGPT and Anthropic, they provide excellent logical, I think, technical responses. But if you can't control every line, every sentence, you might not be saving much time when you're using these tools. And so what we did at Junior is to provide a platform, an AI-centric document editor. We started with patents and our customers realized that document editing with AI is a lot better than copy pasting in and out of ChatGPT. And so it enables law firms to maintain consistency in their style and their output, because you ask AI twice, it's going to give you two different answers and two different styles. So you want to retain some of that control because you want to reduce review time. You want to provide consistency to your clients, especially in accordance to their individual drafting guidelines that each client may have. You might have your own practice group procedures and guidelines. And you might want to reuse some figures and definitions and terminology. And so that would require some sophisticated prompting of these foundational models to maintain. And most importantly, I think your juniors are going to be using AI. And they should be using AI, but an AI that keeps them within guardrails so that their training is actually augmented because they use AI, because they know that their output is supposed to look like what it's supposed to look like. And supervising attorneys will have less of a tough time reviewing AI slop from 6 different associates on the same client when they're using a product that keeps everything consistent. So again, I don't think that competing with the foundational models is a good idea for many AI companies, legal tech companies in particular. So I think the foundational models will give you the good foundation. And then you need to take your law firm, your practice groups, and your client guidelines and add that application layer on top of it.
And along those lines, I think there's been some discussion of sort of law firms or in-house lawyers or outside counsel developing their, prompt libraries and optimizing those for different tasks or questions. What we talked about a little bit as preparing for the panel here was the question of whether that's even really necessary. And for example, so I know some specialized AI products, you can tell it to enhance the prompt, and that may or may not result in a better prompt. I'm not sure personally, but how do we as lawyers get, how do we become prompt engineers, or do we even need to, I guess is the question.
I'll kind of start here. If you had asked me this question a year ago, I think I would have told you how important prompt writing is, and I probably would have gone into, here are the 3 steps you should follow, right? Is you need to tell them who you are, what you want, and your constraints, right? And something along those lines. And I think that's still important to some extent. But I'm hopeful that we'll get to the point maybe next year or the year after that where we really don't talk about it anymore. Because what's happening right now is that learning a prompt is like learning another language, right? The problem is also that as the foundational models improve, that language is changing. And what I mean by that is what we might have had to have described 2 generations back from ChatGPT is no longer relevant today. That is, I can give it a shorter prompt and it tends to know a little bit better what I want. But in terms of prompt libraries and things like that, where we do focus on the prompts, at least at my company, is when we build workflows that are persistent, right? These are things that are coded in, they don't change very often. We try to get those right? We test them, and believe it or not, you've got to figure out which model you're testing it against as well. Because there are some tools that will say auto, and auto means the tool will decide for you which foundational model it uses. And so if you don't lock that down, you would be surprised the variations of outputs you'll get on the same prompt. Now, where we don't focus hardly anymore, or at least where I don't focus, is on a day-to-day basis, I don't think about prompts. I don't have a prompt library, right? When I work on a task, I literally have a conversation with the model. I might upload a document, I might ask a question, if it didn't give me the right response, I'll follow up. Right. And if it's taking me in a slightly different direction, I'll redirect it. And really, it's no different than if you were to talk to somebody, an intern who's not that knowledgeable about a space, who's very motivated. You just continue the conversation until you get the right result. Or if you don't, you just flush it away and start a new conversation. Right. So that's how I think about it.
And so prompt libraries, I think, were one way to look at it. And a lot of companies are now starting to merge with, let's build your prompt library. And I think now, however, that's already going to take a back seat to more of a agentic process, which here, watch me review this document, watch me revise this document and study this and save it. And eventually you build these agents and you share them with your team. And instead of sharing the prompt libraries, you share the agents with the team. And so that's already the next step. And I think companies that are building agents are seeing reduction in workforce, increased speed, response times. And I think law firms should be no stranger. Build agents. It'll improve, I think, consistency, reduce time. And I even envision clients sharing their agents with outside counsel. These agents are trained to our spec, to our standard, on our training data that we don't have to now share with you. And they're going to review it. They're going to ensure that when you get a score of an A, we know it's ready to file. Just agentic now, I think, is where I'm seeing things.
And Yuri is right. Agentic workflows is the next big thing, and it's already here. That's what the scary part is. I'm talking about as in the future. It is here today, and anybody who's been paying attention to this space knows how quickly this has moved. I mean, we're talking about the end of last year, it kind of being on my radar, to just in the last 3 months, just being absolutely insane how good these agents have become. And maybe people want to ask the question of, well, what is an agent, right? And we're seeing it already in use right now. Whenever you go to Claude and you ask it to do something, there's a planner that says, here are the steps I need to do. There's something that's going to execute it and say, I'm going to run these 3 steps. And then the most important part is there's somebody to evaluate this and to test it. It is absolutely crazy how fast you can build an application today. And I'll just give you an example. I participated in a hackathon this past weekend using Replit. And I'm not a trademark person, at least I don't profess to be one, but I created an automated trademarks search clearance tool in a matter of a couple of hours that links to the USPTO trademark database. It links to the web search. It gets all these results. It considers variations, and it tells you potentially whether you have an issue or not. And just imagine, for example, I mean, we're talking about patents, but in the trademark space, imagine if your clients had this, right? That they could make preliminary evaluations of whether they want to consider a name or not before it even gets to an attorney or the legal team. I have an 8-year-old, right? I sat down with her just a couple of weeks ago to say, hey, let's go program a video game, right? Tell me the parameters that you want on this video game. How should it work? What's your idea? And she said, I wanted to make a tracing game on like Microsoft Paint where, there's a stencil and I could trace it and learn to draw, right? In a matter of 40 minutes, Claude basically creates a fully functional app that would have taken someone months to do. I mean, it is absolutely incredible. I just cannot emphasize this enough. By this time next year, everybody will be talking about agents in ways that we can't even imagine. I have law firms right now coming to me to show me their agents. So it's live and well. And when I say they're building it, it's literally happening on the fly. I mean, we're talking about, they talked about it 2 months ago, and now they're showing me what they've built. I mean, it is that fast.
And Professor Ryle, I'll shift to you for our next sort of few minutes here before we open the floor to questions. And And the thought is just that, I think, and from an academic perspective, certainly legal scholarship influences legal doctrine. We've all seen the Supreme Court cite renowned law review articles and things of that nature. And so to the extent that AI is behind this legal thought, I mean, what are the thoughts in the academic community of either policing or figuring out how to use AI in a responsible manner, and, moving and shaping the law to the extent that, our scholarship does?
So in terms of scholarship, I think it's fair to say that, it's been highly embraced. I think the initial sense of the academic community was a little bit more reticent, but and this is my sense of also the legal community, 4 or 5 years ago, or certainly even when the first foundational models came out, there was probably a little more reticence, particularly with respect to concerns about the information that you provided the model being used to train the model, and potentially even stealing your stuff. But I think it's been fully embraced. And so then the question becomes, to what extent does it's almost like what I think Jason and Yuri were saying with respect to how fast we think we should be expected to produce scholarship, and how fast we're supposed to kind of respond to the latest developments in terms of producing yet another article on those developments. I mean, are we now supposed to produce, 5x number of articles per year? And, what kind of influence might that have? I think it's a little bit different from patent drafting, because from a purely private sector standpoint, so long as the patent gets through the Patent and Trademark Office, it may or may not get challenged in court. So maybe that's a concern that one doesn't necessarily have as much of, particularly if it's not in the life sciences industries where, you really want to have a gold-plated patent with respect to every patent that you file. Whereas with scholarship, I do think that there's a concern that, there will be a lot of AI slop produced, and how do we monitor that? Because at the end of the day, if our scholarship does have any influence, it shouldn't be slop. And I suppose that the question that kind of maybe the only kind of parallel I see in the private sector is I have seen some concern about AI generated prior art just being slop, and what does that do for purposes of securing patents on things that are good and that are not slop? And so that's a concern that I think has some parallels in the academic world as well.
I think now if anybody has questions, we have a little over 5 minutes. So, yes.
Art Gardner here. I've been practicing for 38 years, and I was trained by George Thomas and Bob Kennedy and Phil Kelly, an old Bell Labs patent attorney. When I started, we were using typewriters to do patent applications, literally typewriters, dictaphones and typewriters. And Jason raised the question of how much can a patent attorney do? How many applications can you write? How many office actions can you do in a year? And I think more than you imagine, because when we were new patent lawyers, all of it was very interesting and exciting, learning this new skill about how to draft patent applications. We were very enthusiastic about it. And over time, thank you.
Over time, we got beat down by it. It's very difficult to draft a long, detailed patent application. And the fun part is figuring out what you're going to put in the claims. How are you going to claim the invention? Are there alternative ways to do it? One of the best things that I was ever taught was write a claim put it aside, do not make an electronic copy of it. A couple of days later, write a different claim with different terminology, different combination. Anyway, so I used Yuri's tool, Junior, and it has restored for me the joy of writing patent applications, because now I'm getting to focus on the fun part, figuring out what I put in the drawings, what do I put in the claims, and Junior helps me to do the drudgery. It turns the handle and spits out, or helps me spit out a detailed description that I can then edit and write. And I think you'll be surprised at how many applications you can put out and enjoy doing it. I certainly have been had a revival in my enthusiasm for it, the work.
Thank you, Art.
I have a question, Jason. Sorry. So for the three firms, can't hear. Sorry, no problem. Sorry, because my firms now are actually contacted by our client to push us to really use the AI for drafting. So we are evaluating several tools. So one of the things, I like to have your honest opinion or answer, like the three firms that you work with. Do they really reduce attorneys' time when they use the AI tools to drafting their patents, maybe in the beginning, like maybe with the new tools? So have you ever had that comparison? Second question is the claim drafting. So like you said, you want your inventor to not to use AI to draft the claim. And then when you in play, can you compare what AI drafts for the claim compared to what's the manually, by the person or by a experienced patent attorney to drive those claims? What makes you feel, how do you think about those claim drafting? And at the end, do you go with the AI drafting or do you go with the person drafting? Thank you.
Yeah, and that's a good one. I'll take your second question first. We haven't done a comparison of what AI drafted versus what a human drafted. I do think that is an interesting exercise. So hopefully by next year, I'll have something to report to you. One thing I'll tell you is my firms, nobody is very quick to say it saved us a bunch of time, because I think they know what's coming next, which is, but the way they do sell it is, hey, you're getting more for your money, right? Is you're getting a fuller draft, the quality's better. We couldn't have done this before, right? And that's how they've sold it to me.
You could tell them you'll send them more AI inventions from AI inventors.
One back there.
Oh, yes. In the back.
You might be able to hear me without it. 25 years ago, if I did a patentability search, after a week of search, I still had very little confidence that I could tell a client that, this is a great idea, it's going to fly right through the patent office. And this is a question for both law firms and to the extent that what is the patent office using? Are law firms now able to go out and say, okay, we've got tools that look in databases all over the world, every university, every patent office, whatever, and say, yes, this is in fact a new invention. We don't find any prior art. And is the patent office doing that? Do you think the quality will be better of the patents that are coming down the pike, that, fewer interferences, fewer problems with, prior art being cited in litigation, things along that manner? Thank you.
I'll give you my initial response. You don't feel good about making a recommendation to your client after a week of search. When I was practicing, I didn't feel good about making a recommendation to my client after 3 years of examination, because folks, the patent litigators in the room, I see Josh Curry back there, they'll find some prior art that somebody missed and give you enough to spend money on for a long time.
I don't really have much to add to that. I'll just say prior art searching is inherently a difficult task. Even when I compare different tools, they all kind of perform differently. And from what perspective you look at it, may also determine whether it is prior art or at least considered to be prior art. You know, you did ask the question of, you know, will this lead to better patents? I think initially it will, but also run the thought experiment of if everyone starts drafting it with AI with fuller disclosures, you might actually need to use one of these tools to figure out what you can claim, right? You might have had an early advantage, but at some point it might just be survival because the prior art is so hard to navigate without a tool.
Is the patent office using any of the tools?
I've heard they are. I don't know which one they are. If anyone knows, it would be nice to know what the patent office will see before you submit it.
There's a program called ASAP, and they recently made it, I think, free. If you consent to AI-based search, you get a free expedited examination now. I still think there's certainly a human in the loop there. I don't know what tool is being used, but I think it's a wonderful step forward for the patent office. And ultimately, until they can guarantee that the patent they issue is enforceable, it's all.
All right, guys.
No,
that's
I can
Chop.
just jump in on the patent office for if
Go ahead, Dr. Ryan.
30 seconds. So yeah, they were, I mean, I do know that as early as 2018, there was interest in using AI tools for prior art searching. So, and I assume that has continued to be of great interest. One of the problems with having worked at the patent office is that procuring the leading edge, cutting edge tools is often more challenging for the government than for the private sector for obvious reasons. So.
Good afternoon, everyone. My name is Alcide Honore. I'm the co-chair of the copyright section, along with Jelani Miller. I believe he's in the audience somewhere as well, right there in the back. It's our pleasure to introduce to you Paul Ogunmefun, and to speak a little bit about exactly as the slide says, the anatomy of a music catalog deal. Paul is really a technology guy who got involved in, in representing both buyers and sellers in catalog deals through his extensive background in technology, working with investors and developing broad experience in the music industry from, relationships with Universal and major distributors as well as publishers. And so he sits in sort of a unique space. And these are very interesting deals. So we'll just, get right into it. Hey, thanks a lot. Okay, so tell us a little bit about why these deals are happening now when they haven't historically been, all these catalog purchases talked about in the news. Like, why now and why not 20, 30 years ago?
So in the past, music was shared through liner notes, CDs, cassettes. It was very lucrative, but once you sold them, that was it. And now we have DSPs, which are Spotify, Apple, Deezer, Amazon, and they're constantly going. Think of a stock. When songs really take off, very lucrative. And it pays dividends now. Say if a song is rediscovered 20, 30 years ago, being played over and over and over again, millions of dollars again, whereas in the past, it was just a set price. Buyers are looking for passive income, and sellers are always looking for more money.
So obviously there are a couple of different, sort of parts of, a song, right? And different sort of things that could be sold, right? When you're doing these deals, right, what parts of a song are typically being sold and how does all that work?
So you have the
Speak it to the.
you have the composition, you have the masters. You have the masters, I'm sorry, the masters. This is where you have melodies, you have hooks, there are different parts of a song. You have the rights to the songs written, and then you have songwriters as well. You have producers, everyone gets their own cut. The masters is the overall part. So you can sell the entire catalog, or you can also separate it into sections. It's up to the actual artist who and what part they want to sell.
So do I have to round up all the writers, the record label, the producers and everybody before I can sell one of these? Or is there a way that these things can be chopped up and sold?
So it's based on evaluation and ownership. So before, when a song is made, you have something called a song split. So I would say, okay, I'll see you wrote this, give you 50%. I made the beat, I can have 70%. And that's ownership. It's real ownership, and everyone is paid accordingly based on how often the song is played each year.
So if I produced a song and someone else performed it, and I want to sell my part of the song, does the person that performed it also have to sell their part of it? Or can they sell theirs and I sell mine? How does that work?
You can sell yours, they can sell theirs, they can hold on to it, they can buy it out from you. It's called a royalty. So you have mechanical royalties. There's several different example you use. Mechanical royalty, you can sell just your portion and based on the valuation. And that audit would be done, and simply sell it.
All right, perfect. Let's get into just sort of covered those revenue streams and royalty flows. Now, does the market determine, say if the stock market is up, are these, royalty flows worth more? If the stock market is down, are they worth more? Or is this an asset class that's somewhat independent from the movements of the securities markets?
It's independent. Music is timeless. There are no downtimes. People listen to music when they're happy. People listen to music when they're sad. It's amazing emotion. That's why people are actively buying catalogs as passive income. You can make very lucrative. You can make so much money because what if you put in a commercial? The commercial is sad one day. You do a commercial where it's happy. There's a song, it's called Fear of a Job, but that can mean anything to anyone. Fear of a job, right? Does it mean you don't want to work? Or does it mean I'm never working for someone? Does it mean I give W-2s or I take W-2s? So music is inevitable. So what goes on in the economy, what goes on in the world does not affect music.
And so does that attract different types of investors to these types of deals?
Absolutely. You have people in Europe, people in Australia. We have people here in Atlanta. We have actual musicians too that admire other artists. And that's my favorite song. I would love to have that. It's big business due to just the current landscape of music is changing, and music is marketed, whereas tech innovates music. It's not going to stop. It's only going to pay more. It's always going to want more money, more. It's never going to go down. For instance, if a song came out and a fee for this, everything that's called a sync. So sync deals are very lucrative. Thank you so much. And sync deals are very lucrative. TV shows, movies. Imagine if you own that catalog. Imagine the possibilities.
So if I own, say, a Justin Bieber song, and I know one of the people that you work with actually purchased that catalog, and say the next Avengers movie decides they want to use a Justin Bieber song, do they have to pay Justin Bieber or do they pay the person that purchased the catalog?
The person that purchased the catalog. So, as an example, Bieber sells his catalog for $200 million. After he's no longer involved in the deal, and he'll see an uptick of 31% because of the same licensing deal. Now, but Justin Bieber, when he performs the song, he keeps that money. After the song is played, Justin Bieber keeps that money, but he no longer receives income from the DSPs in his.
That's interesting. So when we hear about these huge catalog deals, people are selling, income that they don't yet know what they're going to make in the future. So why should an artist, enter into one of these deals when, their music could be an evergreen asset and, they have no idea how much money it might make moving forward?
So I come from tech. Tech is about multiplication and the possibilities of what can happen. For instance, if you're earning 800 grand a year, it's great. It can depreciate possibly, but if someone says, I'll give you $30 million, you can just take a few million and put it in the money fund, and now you're getting that same income. It's just incredible what they're doing with music and finding different verticals. So that's why most of them sell. Some of them sell because they just love money and they just want lump sums, to be perfectly honest with you. Some of them just buy Ferraris every 2 months. They can't help themselves, perfectly honest with you. But if someone says it's like your house, if your house is 2 million, think of an option, like trading an option. Your house is $1 million, maybe it goes for 3 million. 16 million. You got to sell. You have no choice.
Right.
And you can also make new music. It's just on what you've already done. It's not on your future works.
So let's talk for a moment about what data you use to determine these valuations, right? Like what sort of data are you relying on?
Doing an internal audit, and we use a specific metric. I won't go too deep how we evaluate music, but the basis is what they are bringing in each year. Right there, I do know the actual value, but it's subjective also. If that's your favorite song, for instance, Alcide and we worked on a deal with Egyptian. He has a diamond record. This song is timeless in the Caribbean world. So what does that mean? Hoja will be played forever. What is that worth? So someone says, hey, I'll give you 10 million. No, you're gonna give me 30. You played forever. So once we have the actual value, we also think, how often will that be used? You go to Trinidad, you're gonna hear it. You go to Jamaica, you're gonna hear it. You're gonna hear this BET experience. You're gonna hear it forever. Never wanted to fully disclose metric. I'll be perfectly honest with you. But the first audit, you can see how much is coming in, how much is earning through your publishing, how much ASCAP or BMI is paying you. But the actual value of the overall catalog is subjective. Why they're bidding worse.
Okay, so let's talk about a way that, if there are practitioners in the audience and they want to understand, okay, what sorts of things are, say, hey, they have a client that comes to them. They say, I have somebody that called me that said they'll offer me X dollars to buy my catalog, and they come to me as an attorney and I say, well, I have no idea who these people are. What is the next step I need to take in order to prepare, my client and my firm for engaging in a discussion with a potential purchaser or with someone like yourself that brokers these sorts of deals?
Well, first you check the legitimacy. There's fraudulent people out there. There's all sorts of games. The music industry is ran on something called bots. Bots is automation where no one is actually listening to your music. That's why you'll see people with big numbers, then you go to a show and there's no one there. First, you're going to ask for CSV files and you're going to make sure that everything is legitimate. From there, what I like to do is I ask how much money they want. But you want realistically, they're not realistic people, but you can say, hey, you know how much money you've already made, what you can. I say, hey, if I gave you X, how would you feel about that? From there, because I represent the buyer and the seller, sort of a white glove service. So I have an NDA and I'll say, okay, we have 45, 90 days to 54 days to close this out. And so you want to give them real numbers or be subjective?
That's up to you.
So say if we say the buyer, say if the artist wants $5 million, I'll say, okay, if I get 8, now we have 3 million in the pot. But you have 54 days to close out the deal. And that's why we do so well, because musicians are like, where's my money? Where's my money? Where's my money? They're very impatient. Where's my money? So we try to be as efficient as possible. We've done deals in 18 days, 31 days. That's the best type of deal. That's what you want to look for. You want everything clean, but you do the audit ahead of time. You guarantee the buyer that you've done your due diligence. You don't want to get caught with your payment. Sometimes the musician will not fully disclose that he's taking out deals. Music is also licensed. So an artist can borrow against their catalog. And you will not know if they do not disclose it until you really look under the lid and go to ASCAP. So if they borrow against their catalog, then they have to pay back with the money they receive.
So let's talk about that for a moment. So it sounds like what you're saying is that, the buyer is going to want clear title to the asset, right? And you have an artist, right, that's selling. They just want whatever amount of money they want, right? What's the process of clearing that up, right? Do I, as a lawyer that's advising a client, need to say, okay, well, yeah, you need to raise the money, you need to pay off all your debt before we can go and talk to a purchaser? Or is there a way to structure a deal with the purchaser where they sort of roll that in?
Sometimes a buyer is a bit more flexible. What I like to do is just to do a full audit before I speak to the buyer. I don't trust the artists. People will look you in the face and say anything. I do my own audit. My team does an audit. I pay for that. Sometimes I lose money. You cannot leave any stone unturned. And then from there, we know what's what. And then I bring that information to the buyer. I'll say, hey, they have this loan. You have to make them whole, or these numbers are depreciating. I just try to be as transparent as possible, because it's about it doesn't matter what the artist did. It's just about how much money the catalog is making. It's that simple. So if it's making 700,000, 800,000, if the artist borrowed against it, that has nothing to do with the buyer.
So it sounds like an important practice point here is to make sure that there's not a lot of leverage out there on this asset. And this isn't something that you're necessarily always it's not necessarily always going to be disclosed, right? And I imagine it could blow up a deal if it's not disclosed. How do you find out, sort of what sort of data sources are out there, right, that help you find out if somebody has taken out some sort of loan against some future revenue?
Well, you find out. So for instance, ASCAP ASCAP will disclose that this person, if they do not pay back their loan, their catalog is gone. There are different, think of just piracy credit loan, or, you know, when you see on TV, those payday loans, think of it like that. So someone will say, hey, we'll give you $2 million. And they don't care. These artists will do it all the time. You just pay us 20 grand a month. They don't care because they're making it anyway. But what happens is after, say, 4 years, they'll say, hey, you want another 5 million? Just give us this, just give us that. The artist will not tell you that they did that. And now they're making such a small amount of money, they want to sell their catalog. And then that's when they come to you. They never come to you first. They mostly come to you when they're in crisis, when the money's slowing up. But it's okay, because that's not your business. It's fine. That's what they don't realize. They just going to pay it back with their own funds. I actually don't mind when it happens. Most people get upset because they think it's going to blow a deal up. It does not. I base it on evaluation. Okay, well, you're going to get 20 million, but you owe 6. And I tell the buyer, so I make the buyer pay the 6 directly to the lender, and then I give the artist their money. I handle it that simply.
So it sounds like if I'm an attorney and maybe this isn't something that I do all the time, some things that maybe I need to be on the lookout for are, hey, has this artist, already taken out loans or borrowed against this asset? Is this asset clean? Now, I want to touch on another point, something that you mentioned earlier called a split sheet. How does a split sheet factor into all of this?
Well, a split sheet is very important because sometimes artists do not have money to pay for a verse or to pay for beats, pay for studio time. Maybe the label is fronting their money and they say, oh, I'll give you 20%. But as you know, 20% adds up over time, especially if the song does very well. And you see all sorts of things. You'll see complex contracts with water bottles on your hand. And you're just like, and people will dispute it. Oh, that's not a 3, that's a 7, and the label can also go in and alter it. It's an unethical service. So it's very important for those split sheets to be clear, and who owns what, who gives what, does it expire. Split sheets are very important, and sometimes artists don't do them at all. They don't register their music. But once again, not my problem. My problem is to sell it. And once the buyer, he can discover new music. So artists won't copyright his music or register his music, but the buyer still owns it. It's that the artist did not properly fill out the split sheet.
Okay, so what you're saying is that if a seller has not properly registered all their music, there may be some incomplete, items where, hey, there's actually revenue out there that they're earning or that they're supposed to be getting paid, but they're not getting paid any of that money right now. But when they enter into a deal to sell the catalog, generally speaking, whether they have set themselves up to receive the money that they should get or not, that deal is what it is, and their opportunity to go and claw any of that money back is gone, and it's now been transferred to the purchaser.
Correct. And it happens often. Musicians or their managers forget to register music. They forget about different royalties. It's a mess. A good manager has everything lined up, though. But more so than not, there's always going to be a song floating around and there's just money. But that belongs to the buyer now.
So it sounds like another potential practice point here is to actually make sure that the entire catalog is accounted for. So that when you're going into that negotiation, because I'm assuming that the buyer, they have done their due diligence, right? And they know what it is that they're buying. But if all you're able to provide is income that represents, say, maybe 95% of what you should be earning, they're generally going to base your deal on that, or are they going to include maybe the 5% that you haven't been earning, even though it's not part of the income statements you're providing?
No, they love when that happens. When you forgot to register your music. It's new money. It's new money. They're solely looking at the valuation of what is. You make this amount every year, every 45 days, what's it worth? And anything new is just a bonus.
So, again, I think that people love to blame lawyers, right? And so I think an important point is to, consider the fact that oftentimes these, the split sheet verifications are incomplete. The repertoire has not been properly registered with the PRO, that's the Performing Rights Organization. And there's money that the artist should be receiving that they're not receiving. And so when you're working with someone like Paul and you're providing, income statements showing how much money the artist has earned over, whatever period of time, they're applying the multiple or whatever sort of, metric that they're using to determine the valuation, they're not going to give you credit for money that's not being collected. So it sounds like maybe there's a little bit of hygiene, if time permits, right, that should be getting performed in advance in order to make sure that, the artist is able to receive, full value for their catalog.
In a perfect world.
In a perfect world. Okay, good. Okay, so let's talk about what kills deals. All right. Everything's ready to go. The money's on the table. And the buyer comes back and says, hey, you know what? I think I'll pass.
Never happens. The buyer never backs out. It's always the seller. Always the seller, because a buyer knows it's a very small knit community. Buyer knows what it's actually worth. And that's why they they know exactly what they're getting. And what happens is usually the seller says, I don't want to sell anymore. This is my life's work. Or they'll to be honest with you, what normally happens is someone just offers more money. And they breach the contract. That's why it's important to do what I originally said. You have to say, how much money do you want? It has to be more. We're known for that. These deals, if something's worth 40, I get them 60 so I don't have that issue. But if it's close to what the actual catalog is worth, you have a chance of being outbid, because once it goes public, other people are going to come in and say, oh, that song, they're selling their catalog, I'll give you 50, I'll give you 60. So that's normally how deals get killed. That's the biggest culprit, personally.
Okay, so say there's drama associated with some of the songs, right? I'm sure that you've never experienced that. Can someone sell less than their whole catalog?
You can sell one song. You have different songwriters, and sometimes you have someone who just said, there's an artist, his name is Smoothie. He did a song, he sampled Elton John, and Elton John refuses to sell or let him, and it's his own work, he can perform it. You can say, well, I want to just sell this piece. I want to sell my portion. And you can do that. But hopefully the label or Elton John will just buy it from him before it's out in the world. But you do not have to sell your whole catalog. You can sell a portion, you can sell a song, you can sell 2 songs. It's however it's based on a number.
What sorts of documents have to be in that due diligence package in order for a deal to move forward?
First, you have to make sure they can still the sampling. You have unauthorized sampling that sometimes goes just get swept under the rug. You have unrecouped funds from other artists that they don't tell you. Maybe you have a handshake deal, right? You can't just say it's my guy. Once you're selling someone some, I'm not going to go after you. I'm not going to do anything, because with boys, it doesn't work once you sell a catalog, because they won't honor it. So you have to make sure that you have all your CSV files in order. You have to make sure they're signed off. You have recording agreements that have to be signed off. They're going to be very old, redacted sometimes going to be written on napkins. But most importantly, ASCAP, every year they send out a document that they make you read through, and it states the legitimacy of everything.
Okay, so it sounds like there are some sources that can be relied on for at least data about the songs that the artist has registered, right?
Yes.
And those are performing rights organizations. The major ones in the United States are ASCAP, BMI, and CSAC, right? And it seems as though something that has attracted these sovereign wealth funds, these hedge funds and other investors from all over the world, is not only that predictable revenue, but also the drivers of that predictable revenue, which are, as you mentioned, the DSPs and the streaming revenues and things of that nature. So how important is it to make sure that you've got that sort of source of truth to provide in order to move these deals forward? And, is that maybe a way that I, as an attorney, without spending $1 billion on auditing, can get a sense of, hey, look, is this person telling me, the whole story before I go out here and buy Paul some Rathbun steak and then end up not being able to get the deal done?
Good question. It's a really good question. That's why I do my own audits. You can spend thousands of dollars to find out. Sometimes it's worth it. Sometimes you just get a general feel for someone, and you can just trust them. You know that it'll fall together. But you can tell by how organized they are and how fast. Basically, usually you know it's going to be funny business if you ask for a certain document and it takes 3 weeks, and it should take an hour. You have to go through everything. I do my own audit. As you said, as I told, I represent the buyer and the seller, so the audits should match. And then they do a third party one, and I have someone also look into my work, and it's really a percentage. It's a 97%, 96% accurate. And that's how fast and efficient a deal is. If I have 96% and you have 94%, it's good. That's the easiest way to do it. The audits are most important, to be perfectly honest with you, because you want to be as close to the number as possible.
Okay, so when we're closing out a deal, right? I found it interesting that the nature of the documents when we're closing a catalog deal look a little bit different than the way the documents look when an artist is entering into a deal with a label. So can you tell me a little bit about just how that process works in terms of, is a seller approaching you first? Is a buyer approaching you and asking you to see if you can track down a catalog? And then, what sort of document sort of wraps up all the business?
Well, normally they're looking, they know, but there's a letter of direction. It's going to, so usually, to be honest with you, there are multiple components of a deal. People who are agents, there are people who know somebody, there's your cousin, and then, there's your manager who's like, I just want $5,000 because I exist. And I'm like, send it to him, I'll see. So you will see basically what's so interesting about that final document because you'll see why the artist is selling. Their mom might be getting 40,000. Their manager will, and it's all in like a spreadsheet. That, you know, the lawyer gets this, or this person gets 1%, and it's very interesting. Oh, I want my house paid off. I want the money to go to this loan, and it dictates. And also, you have a final analysis of all their music that's made at the time, and you know, is it big in Egypt and everywhere it goes? It's all encompassing, encapsulating document that explains everything. It's compressed, it's very detailed, and then after that, the deal's over. It's you know, it's when that's why I leave you up to it. Where's my money? Where's my money?
So what you're telling me is that besides the artist, when you're finalizing the asset purchase agreement and there's a schedule, I guess, of how money is going to flow, right? That oftentimes there are other parties other than the artist that are getting paid out, and that fortunately or unfortunately is customary.
Correct. There will always be third parties. There will always be someone's cousin. Deal. You know, there will be the record label. The actual record label will get a significant. Sometimes I own a record label, so sometimes I will take a major portion of the artist's earnings and give it to them over time, you know, or put it into a fund for them. But it's all detailed, it's all documented at the end of the deal.
So I think maybe the upshot there is that, you know, the opportunity exists to get creative with the way things are paid out. And have you ever seen outcomes in these deals where maybe you're able to resolve a dispute over a record by, you know, making some considerations in the payout in an asset purchase agreement?
Absolutely. That's where things get interesting. New record deal. So let's just say money's being freed up and maybe you owe, you can buy yourself out of the deal. Maybe you want to join a new record label, match the money. There are all sorts of things you can do with catalog this. It's all about your creativity and the willingness of the artist. And catalog sales are amazing because there's so much capital. And if the artist is big, they're going to do it again. We use the Justin Bieber example. His new music, since he sells, already upwards of $35 to $37 million. That's his old music. When he was a child, he was a teen star and a kid star. Although that music was valuable, his new music will be worth significantly more than the 200 million already made for him. He's already made.
So let's just say there's ongoing litigation, maybe because the split sheets weren't done properly, or there was a sample issue that wasn't resolved or something of that nature. You're telling me that potentially these sort of, you know, catalog purchases can offer a capital source to potentially resolve some of those sorts of disputes without them having to be fully litigated.
Absolutely. Never litigate. It's a number. So a record label, someone will say, hey, I own the distribution. You can't prove it unless you go to court, but I can say, well, I can see how much you make, how much this makes, and I can now give you X. And they're more than willing to pay because they know that they probably did something, you know, not great, a little unethical. And if you say, hey, well, the artist is willing to give you this X amount to have this back, now you have a new catalog deal. Maybe you could do a new distribution deal or a new publishing deal. So many deals are altered and changed and new money because of catalog sales.
All right, that's great information. It's always nice to be able to find an off ramp that does not require litigation. I guess it's not going to take us back to the beginning slide without me running backwards through all of them. But, you know, so tell me about, you know, one of the sort of most difficult deals you've closed and what made it difficult to get done.
Most difficult. I'd say I had a Russian artist and EDM. And EDM, people listen to it over and over and over and over and over again. They play soccer, it's different over there than here. So you're gonna have 1 billion streams. And you're like, why? You know, like but so they're like, we want this amount of money, and people are like, no, because you just can't explain why it has 1 billion streams. And on top of it, it just doesn't make sense. It just doesn't make sense, but it's our job to make it make sense based on their evaluation. So what I found out was basically people will just go to the gym and just go nuts with it, or they'll just have it playing in the background, kind of like their elevator music over there, I guess, when they work, but they're not listening to it. And the buyer he's just fickle. Because people want to know, because you can look at where people are listening to your music, what time, why, are they in their car, does it give them solace? It's attached to things. And for some reason, don't know why. You don't know why. And I always come across that because the number is so high. I hate doing deals like that. I do them, but it's difficult because you just don't know why. And also they'll have one or two songs, and they just do like 20 remixes of it. But it's the same, and so I would say that's what gives me the most challenges.
So it sounds like there's a degree of this that's almost ego driven by some of these buyers, right? Like, is there a sort of, hey, I really like this type of music, or this is a song that I really want, and how do you sort of leverage that or capitalize on that?
Yes, it's called respecting the art. You want to buy art. I don't look at it. Catalogs, publishing is the real estate of the music industry. I look at it as a painting. It's art. That's what it is. And you want your favorite piece, what recognizes you, what brings you back to your childhood. I always, we're living in AI, in times of AI. I always tell people, like, look at it as, and why it's better than AI, and AI will never take over music. It's, like, I don't know, it's like when you were a kid and you just don't have any bread, and and then you get your first Jordans, and then you're sitting on your bed, right? And what's the first thing you did? You grab your shoe and you smelled it. Everybody knows that smell, and that's what it is. And you want that. You want to recreate that. You don't want nothing fake. You don't want to buy a catalog that just makes money because you don't care about it. You try to buy something that you love, that you care about. So a catalog that's valuable, most valuable, is something that people love because they're always going to turn back to it. You don't want to get caught up in not knowing why someone enjoys something. But that's our job also to find out. But I try to get hot catalogs, that I can understand.
So in terms of some things that you wish attorneys knew before they started working on behalf of a client that's negotiating a deal, or if they're communicating with you on trying to get a deal done, what are just some things, just from where you sit, right? Like, hey man, I wish that the lawyers would know this or do this in advance. It would make things a lot easier.
I just hate like you just like send one email, like hey, got it, confirmed. Like, keep going. Like, there's more to it. Like, why can't you do more? Why can't you, like, say if like you can move it further so much faster. I wish like there was just some sort of eternal document, like do this, do that, do this, do that. But there's just so much double checking. And then some other lawyer comes like overlooks their work and just, hey, you're like, you know, I think, but the more you do, and some lawyers are better than others also. Some lawyers are like really in it and they know how to move it forward. But some lawyers are just new and they want to double check and they just ask for things. I don't know, maybe it's like a waste of money or something. I don't know. Some lawyers just like double check and triple check things and ask for things that aren't necessary. I wish there was just a way to say, hey, this is what's needed, period, to get this going. But it doesn't work that way, as you know, because you can have a lawyer in London that's different. You have a lawyer in Australia that's different. And the world's different. In Russia, that's different. I just wish there was just like a universal way to communicate. Like if we just check these boxes off, it can go. Things can go faster. Because what makes a deal, kind of why people come to me, is the efficiency and how fast I can get it done. It's not sloppy, it's just efficient. So I just wish that everyone would follow the same template, but they won't. That everyone has their own way of doing things.
So one of the things you mentioned earlier was the different players involved, right? Like sometimes you have the manager, maybe they have some of the documents, or, you know, sometimes there's the momager or whatever the case may be. Do you want the lawyer to step in and herd all those cats and gather all the information? Or do you want them just to, hey, whatever, you know, permissions are necessary or sort of, you know, deal, you know, memo that's necessary to engage you, and then they just give it to you? Like, what's your preference in terms of, you know, how to work?
That's the best way to do it. To have a lawyer that's excellent. You say, hey, how much money do you want? They say X and they sign it over to the lawyer. The lawyer retrieves the documents with you and you work together and you leave the client out of it. The client's just signing and they're receiving their money. Because a lawyer is more detail oriented, whereas a momager will, I don't have these files. I don't know what this file is. And then they want to be involved in the process. And you know, I can't really get into licensing with you. So it's best to have a lawyer and have the client work with the lawyer. I really enjoy when the client, you know, has a great lawyer that they've been working with for years, and it makes things a lot easier.
So I think lawyers going into these sorts of deals should be prepared to herd some cats and, you know, have a lot of touch points as on the artist side, if in fact they're representing an artist, to make sure that everything comes together in a reasonable time frame to, you know, to get someone that sits in your space what you need to get the deal done.
Lawyers is important and pertinent. Organize everything for you. You know, it's great to have a lawyer that's you know, that can represent the buyer.
All right.
So yeah.
Well, good. Anything else you can think of that, you know, this group of lawyers, many of whom, and we'll get to questions in a moment, that this group of lawyers, some of whom practice a significant, dedicate a significant amount of their practice to, you know, music and, you know, related issues, some of whom come into contact with it, but don't necessarily practice in that area specifically. You know, any sort of parting pieces of wisdom or advice that you could offer to folks who have a client that comes up to them and says, hey, look, you know, I've got something I want to sell, or I know somebody that, you know, is looking for a catalog deal?
Do it. It's the future. Music is constantly on a clock now, and you have no choice. This is how people are going to be paid in the future. No one's going to be patient. It's big money. We're seeing newer catalog sales, 4 years, 5 years, 3 years. The best catalog deals are 10 years or older. Now we're seeing younger ones because the way music is digested. Certain artists have core fans that only listen to their fans. They're called super fans. They want to cash in immediately. So it would be in your best interest to always listen and look out for new deals. If you're curious, to just at least minimally do the audit and charge your client, and at least you know exactly what it's worth. That's your job. Your job isn't necessarily to sell it. It's to find someone like me to find a buyer and seller. That's all. You just represent your client.
All right, we've got a few minutes left. Are there any questions? I believe we had one over here. The beige jacket.
Yeah, not necessarily a question, but you asked him a question about what could attorneys do in the early stages, I guess, to prepare for a catalog sale. And probably the most important, I'll say one of the most important things to do in the initial stages of, say, a publishing deal or say a recording agreement is to address the assignment provision of those deals. I've been doing music deals for about 31 years now. I've been doing music deals for about 31 years. And the assignment provision is one that is not a lot of attention and time is given to it. The companies retain the right to assign anything that they want to in the deal. They restrict the artist or the talent from assigning anything other than maybe the right to receive payment to like a loan out company. So your ability to transfer it to a third party entity is restricted, which devalues the asset that's created or those assets that are created under that deal. And so you have many attorneys, and I'll say I'm one. 25 years ago, I wasn't thinking about asset sales, in 2026. And so I may not have been as attentive to the assignment provision because what a buyer wants, they want all of the rights that talent had in that deal. They want audit rights. They want the right to receive all of the money. They want the ownership rights. They want everything that the artist had, assuming that those rights are beneficial to them. If you can't give audit rights to a buyer, then it's going to be less valuable to them because they can't come back and audit statements that have previously been received. And so that's one of the, if I say 20, 25 years ago, nobody was really thinking about these sales. I mean, this was happening back in the early 2000s with the securitization of assets. So it was happening even without streaming. So it's not solely streaming that's driving this. This is passive income, publishing income, income from master sales. So the passive income has been there. It might be increased because of the streaming, but these deals have been happening for a while now. But if you can't transfer all of those rights to a purchaser, then doesn't mean that they won't buy it. It just means they'll pay a lot less for it. So that's the first thing I think practitioners need to do if they're doing a publishing deal or if they're doing a recording agreement. If you're thinking about sale, is the assignment of it and the ability to do so.
Yeah, and I'm going to hold you to our next copyright CLE because I want to talk about that in the context of copyright reclamation. So we're going to talk after this because I think that's a great point. Okay, do we have any other questions real quick before we got to wrap up?
Yeah. You probably don't need the microphone for me.
Not for you, Marty.
Yeah, two questions actually. Number one, I'm wondering, as artists want to sell their catalogs earlier in their careers, how, if at all, do they still take into account their future recordings, such as a writer versus music? And two, how does certain artists go back to their earlier parts of their career and re-record some records for whatever reason? Lots of different reasons they might want to do it. If that happens, how do those new recordings, which may end up supplanting the demand for the early recording, affect these deals?
Well, we love re-recordings. Morris Day is re-recording all his songs with Bruno Mars under my label, by the way. I'm sorry, I just had to plug it. So I love when people re-record music. It's great. And what was the first part?
was asking about what future opportunities for artists to sell their catalog.
The younger catalogs. The younger catalogs, it gets tricky. Because you want older catalogs because the catalog can depreciate. You want to make sure the fans stick. You have so many different, for instance, you have these automated playlists. Sometimes people can just go to the gym and listen to songs. Sometimes playlists aren't real. So you think these streams are going to stick around and they won't. Young playlists are very tricky, but the good news for you guys is that's not your job. That's my job. You have to say, hey, you say this is worth this, Paul, and I want this, and I get it for you.
I have a friend who is wealthy, and so he's looking for ways to supplement his income. And so he's been thinking about buying music. And we've seen some third-party sites seemingly that, right. And I have been very wary of that, but I don't practice music law, so I can't really articulate to him why not to do it. So give me your thoughts on third-party sites to buy and sell rights.
Well, you already know what's worth it. My suit's made to measure. You know what you get. Right? If anyone can buy it, what's it worth? Why is it there? You're not going to just find something super special just sitting around on the internet. You know there's something wrong with it.
So do you think that signals low value?
Absolutely. Nothing that I ever sell, nothing. I know I'll see because of what we're speaking about. I've never sold anything that any of you will ever have access to. Ever. If you talk to me about something you had, I would make you sign an NDA with me because I'm giving you the buyer and the seller. You don't have to do anything. You simply say, we do our audit. You say, I want 5 million. Doesn't mean if it's worth 2 million or 3 million, I'm going to say, what do you want? And I'm going to get it for you. It's that simple. So you have to kind of white glove it. You don't want to sell it you don't have everyone bidding on it
and let me jump in real quick, right? Because I think what you see a lot of times is, Paul mentioned, hey, you got these random people showing up on an asset purchase agreement, right? Like, who are these folks? So unfortunately, if you don't have direct access to someone who's working directly with investors, you're talking to the man that's talking to the man that's talking to the woman that's talking to the other person. And unfortunately, you are not necessarily in a position to peel back those layers unless you have a relationship with someone that's directly plugged in with purchasers. I mean, and these are some high net worth individuals, right? And in the music industry in Atlanta is interesting, right? Because you have a lot more folks that are on the content creation side than on the content sort of distribution and funding side. So we don't always see fair market value for catalog offers here, right? So you may have a client that gets an offer from a local outfit, and they're working with somebody like Paul, or working with somebody that's then working with somebody like Paul, and that value of that catalog is getting chopped down along the way. So I would just say, definitely look to find some trusted partners in the space that can, help you get a range of offers. And then, hopefully there are a couple of sort of inflection points you can look at, without spending too much money, to get a sense of, okay, well, what's the real revenue? What's the real value? What is the income looking like on an annual basis? Are there encumbrances in a catalog that I need to be concerned about? So that you can, actually field some fair and reasonable offers, because the range in, the sort of the market in terms of what it will bear, it's insane. You're talking about 30, 40, 50, 100%, sort of differences.
And you'll notice you're known for your work. It's very small. What I do, it's a very small industry. So you have multipliers, 10 extra catalog, 5 extra catalog. So say if you've 12x, people know, so they're going to come to me. I'm not searching for my business. Like, I'm gonna leave here and one of you are gonna find me. Like, you did that. You know, I don't look for these deals. The labels give them to me, the artists give them to me, because they're like, hey, this guy will get you 10x. Someone calls LC, he'll say, look, he's did this deal for 9x. The Justin Bieber deal really did $200 million. It's not worth that. I just knew those songs. Like, this is gonna go. This is gonna go in Christmas time. This is going to be in this movie in 10 years. This is timeless. You have to have, someone has to really know music.
And I'll say one of the distinctions I see between the deals that are happening now as opposed to some of the deals that we saw, you know, maybe 20 years ago, right? Is that I think just you have a more diverse group of buyers that are participating, and you have some buyers that are participating now that are willing to pay much higher multiples than, you know, sort of the traditional players that you saw in the game.
Especially in Europe. They love, for instance, they love hip hop more than people. In
All right, everybody. Good afternoon. I'm Joe Staley with the firm of Perilla Knox and Hildebrandt. I'm in the one of the co-chairs of the in-house committee here at the State Bar. We promised you an ethics credit, and we're delivering on an ethics credit for everybody here.
Yeah.
We have a fantastic panel today.
Yes.
It's candor, confidentiality, and competence in the age of AI. I know we've talked about AI today, but this isn't from an ethical perspective, and it's insights only from in-house counsel. My other co-chair of the in-house committee is Justin Ward. Ward is the general counsel of Blue Force Gear. Justin is going to moderate the panel, and I'll let him take it from here.
Thank you, Joe, and thank you all for being here. Before I was general counsel, I was in the law firm setting, so I kind of have an insight on both the outside counsel side as well as inside counsel. So hopefully that'll, you know, I'll share that with some of my things today. So Andrew, why don't we start with you? Why don't you introduce yourself?
Hey, everybody. I'm Andrew Strickland. I am the general counsel at URAC. We are one of the largest, if not the largest, solar racking manufacturers in the residential and commercial industrial space in the solar industry. We do not make solar panels. Everyone thinks we make solar panels. That's not what we do. We make the hardware that attaches solar panels to things, mostly rooftops, but also ground. I'm really excited to be sitting here doing this presentation from this point of view, because when I was a firm lawyer, I always wanted to have this presentation where I could be in the audience. So I'm very happy to be here, and I'll turn it over to Shaitan.
Hi, everybody. My name is Shaitan Menzie. I am in-house counsel at Five Below. You all might know that your small kids and teenagers very much enjoy. We love that. Bring them often. And we love to have you all there.
Swag for us from Five Below?
What did you say?
You have swag for us.
We don't have swag.
Should we look under our chairs?
Maybe can.
But I encourage you all to go to your stores, your local stores immediately. Very awesome things there. Before I was at Five Below, I worked for another company as in-house lawyer. It was a franchise model company. So just very different legal issues, even though I'm an IP practitioner at both of those companies. And then before that, I practiced for it felt like a long time. It really wasn't a long time, but it felt like forever at large law firms. So I'm really excited to be here and talk to you all.
I'm Suzanne Hollinger, and I am also really excited to be on this panel. So I am currently general counsel for Welcome Leap, which is a nonprofit focused on global health innovations. And that's pretty recent. I joined in November. My last role was as chief IP counsel at Brands in consumer products. And before that, I was head of patents over at Coca-Cola. So I've been in-house for a long time. Before that, I was working over at King & Spalding. Or actually, before that, I was in-house at Emory University. And before that, I was at King & Spalding, focusing, as a patent attorney, really on a lot of prep and process in the early days. But excited to be here.
All right. Well, thank you guys. We appreciate you being here as well. Here's the agenda today. We have lots of different topics. We'll do our best to get through as many as we can. We want this to be interactive. So if you guys feel free to ask any questions, and then also we'll try to save some time at the end for questions as well. So the first topic that we're going to talk about, does outside counsel truly understand business. So questions for Shaitan. How do you evaluate whether outside counsel really understands your business, technology, and why does that matter ethically?
So I don't think there's hard and fast rules on how to evaluate it, right? Part of the journey is you as in-house counsel learning and mastering your own business and your risk profile of your own company. And then hopefully the outside counsel, whether that's multiple outside counsel or one who has been there longer than you, or you bring in, goes along that journey with you. And so my personal experience is that as my personal experience at my company has improved, so hopefully improves my outside counsel's experience because they're going along that journey, or I see ways in which they falter. And so I'm going to tell you guys a quick story. One consistent dose of constructive criticism I received as an outside counsel when I was an associate at law firms is like, I took too much time because I was doing stuff right to explore problems a little bit more, and I'm trying to dig deeper. And I think that's a good thing, right? Like that's actually what I want now as an in-house counsel from my outside counsel. But I don't think the incentives at law firms are set up where an associate, if you will, or maybe even a partner sometimes, is rewarded for that kind of effort, because our goal for them is always also to be efficient, right? And so I just think outside lawyers have to find a way to go beyond the question that is asked, right? To figure out whether that's length of time or just an interest in your client's business, knowing what they're doing, understanding what they're doing, and bring that value to the answers you're giving. And so I didn't tell that story just to say, wow, I'm a better fit for in-counsel work than I am for outside counsel work, but it's really to encourage you all to let your associates who lean in that manner, figure out how to make that work for you guys, right? Figure out how to make that, because they're less expensive anyway. Maybe you can write off some of that time for those older in the practice, more senior in the practice. Find those ways to like help those maybe junior associates help you look good along that journey. And there's a bunch of, rules that relate to that: competence, being a good advisor, diligent. And, that's just, it may seem like it's an expensive thing for you to eat in the short term, but in the long term, that's what's going to get that client to stay and continue to send you more work and continue to trust you and build trust over time.
Can I build on that as well? Because I totally agree. The one other area that's just sort of slightly tangential that I found is really making sure that you understand what your client's goal is with whatever this ask is, because I have seen so many times when you bring in outside counsel, and there's always the risk of bringing in outside counsel, particularly if you let them talk to the business, that they're going to pitch something that's completely inconsistent with your actual plan. And it's really because they're looking to sort of get more money. I mean, that's how it reads. It may not be true. It may be a junior associate that doesn't know what they're doing, but it reads like we're just pitching this in-house business person for something that's not consistent, that's not really necessary. And now you as inside counsel get to spend the next 6 months trying to figure out how to talk them out of it.
Let me just say one more thing. I also think it matters what the business is, right? Because you may have clients in a technology space like Andrew's company, but then you may also have clients in a retail space like my company. And those are two very different types of companies with very different goals and very different risk profiles and all of those things. And so what you might recommend to me might be different from what you recommend to Andrew and Susan. And so you have to really have a handle on that so that you make those recommendations appropriately to that business, what they're doing and their risk profile. And so investing the time into figuring out those differences and pulling those levers when you're having those conversations is just critical.
Yeah, I mean, in the earlier, right before the lunch, the patent committee did the AI is coming to take all your jobs discussion. And And somebody, I think Clint raised the question, like, well, it was kind of like, what are the lawyers supposed to do now? The AI is doing all the patent drafting. And I think the responses were on point, but I want to hammer that home. Like, you guys can't be advisors to us if you don't understand what we do. It's very simple. Like, our business is weird. Like a Unirac's business. The way we make money is weird. We don't even know who our customer is, which sounds weird, but we have long conversations about, is our customers financiers? Are our customers installers? Are our customers homeowners? Are our customers, asset owners, which, you don't need to worry about what that means. But my point is all of that trickles down into how we make business decisions and how we make legal decisions and how we make patenting decisions. So the way you separate yourselves from the robots, so it does not become Terminator out there for you guys, is to be someone that's an advisor to us. And someone that understands our business is like a prerequisite to being a good advisor. So I just want to, I don't know about everybody else here or your other clients. I am happy to spend all kinds of time explaining the business to you. Please ask. I will give you the explanation. I will give you the explanation even if you don't ask, because I like to hear myself talk. So just keep that in mind. Like, your clients will appreciate your curiosity. They will appreciate you asking the question. That is why they are talking to you in the first place, because they at least see something in you that it says, hey, I want to work with this person. They're going to be a good advisor to me. Show them. Ask the good questions. And that's a critical to building a really good relationship with your clients.
And you do not know more about the client's business than the client does.
No.
I've had lawyers speak to me, outside lawyers, in a way that suggests that they do. Yeah, you don't.
I can add some of my insight as well. I started with the company about 3 years ago, and we had pre-existing counsel, and they really didn't understand our business. Lots of trademark filings with multiple classes where we didn't even have some of the products. So I didn't even look it up. I didn't even know we sold this stuff. I'm like, doing the renewals and stuff. So choosing counsel that understands what you do and the product you sell is a great idea. So definitely you can start there to make sure you're the right team. Going with people you know and trust is always important. So a follow-up question for Shaitan. So say you have a new law firm, new outside counsel you're signing up. How much time do you think they need to get up to speed with your technology and business? What would be appropriate?
It's very difficult to say. I think that some of it is personal, right? Some of the lawyers may have, in my case, retail, right? They may have a lot of retail clients already. So that gives them a good starting point to what we're doing at Five Below. Or they may have worked with Five Below for many years, or they may have worked with the people who work for Five Below, so they have an understanding, of how those people work. I mean, I don't think there's a hard and fast rule, but to Andrew's point, like having those conversations sure does, and asking those questions very explicitly, inviting the counsel that you're working with in-house an opportunity to have those touch points with you, whatever that timeline is going to be, sure does reduce it a lot, right? And so I would encourage you all to not feel like you are doing, eating up their time by doing that. Like, I'm not billing, so that, I'm not doing billable hours. So that time for me, don't charge me for it, but that time that you invest with me will pay you, will result in dividends to you when you do that work. It will reduce your time in learning the business. When I bring an issue to you, by all means, ask me background information that I might not think to tell you, but may be relevant and help you, again, understand the business for the further things you do for us down the line. So I think it varies. It's very situational. But I think the people who go above and beyond on those question asking journeys, it is a journey. It's a journey of partnership. Do better and decrease that time.
Okay. Andrew, Stan, anything to add on that, or?
No.
Yes.
I guess I would say, I wouldn't expect this necessarily to be like let's sit down for 4 hours and I'll tell you all about the business before you do any work. Like I think Shaitan was saying, to me, this is a having a conversation as you're engaging and making sure you actually listen, because that's the part that I find is the real challenge, is that, and I think, you said, like, some outside counsel will come and assume that they know more about what you should be asking than you do actually asking it, and therefore won't listen to the actual requests that you're putting out there. I mean, I spent a lot of time repeating and re-repeating what I'm actually asking for, because I don't want a giant 50-page memo on something. I want a quick answer on a high-level question, because I'm not an idiot and I know the basics. I'm asking on a specific question. So that listening aspect is something trained to make you not AI.
We'll move on to a fun topic, AI, and ethics everyone's been talking about. So Suzanne, the first question's for you. When we're talking about AI tools and IP work for outside counsel, what crosses the line for effective assistance and into like an ethics problem?
I mean, to me, it's really about sort of critical thinking. And well, there's two things. First of all, you have to disclose, like you have to tell people that you're using it. And I think that's something, I don't know if we're going to talk about it here or afterwards, but I've recently started seeing engagement letters that have AI language in it. I think that's important. And I think if you have an existing client and you're starting to use AI, you really have to talk to them about it, and talk to them about what they're comfortable with you using, what tools you're using, confirming that you have confidentiality protections, confirming, what is going into whatever tool you're planning on using, and that they're okay with you doing that as a tool. What are your limits? So that to me is one, disclosure. The next one is not sort of passing off something that has no critical thinking and is purely a drafting tool as though it. So I think the last talked about it extensively, whether it's claims drafting or background drafting. I do not believe that a lawyer's value is just a document. I think that it is thought process and the assessment out of your experience, out of your training. And that is something that I have not seen any AI tools capable of even coming close to. It's just a lot of very well-written fluff. So great for boilerplate, but probably not for your actual thinking. So to me, if they're passing something off as though it was but actually it was just straight out of an AI tool, that to me crosses a line. So to me, those are kind of two things: passing off and disclosures.
What about confidentiality risks? I'm going to use generative IP for IP work. I've seen issues where there's obviously different types of AI you can use, where you have a closed system and open system. If an associate work and they enter into an open system, and they enter in a brand new invention, and I go, how do you draft independent claims? And then everybody has access to it because it's in the same. Your competitors can see it. So what do you think outside counsel needs to do to ensure stuff like that doesn't happen?
I mean, I think this is a real risk. I don't even think it's just an open system. Like, I don't know if you guys saw what just happened at Meta with their employee that was asking, and it's not patent drafting, but it's a similar concept. There was some employee that had, a chatbot. Their internal chatbot was providing advice on how to do something and had an error in it. And it posted on some internal chat site for employees only, but then other employees started using that inaccurate code, and then some confidential data that I apparently was of all of us was open to a whole pile of Meta employees for many hours. So it can happen, closed system, open system. There's just sort of a leak across the system. So it's slightly different than the training issue, but I think that the same can happen in a law firm. Let's say a big law firm that's putting invention disclosures even in its closed system. It's unclear to me how, if you have different companies that are all accessing technically that same system because you're putting your inventions in there to draft your claims, how that's not cross-pollinating across the system. So to me, that's something that I think any law firm is going to need to deal with. I don't know that there's a great solution for it. Every time I've used AI, you have to tell it every few minutes to forget everything, because otherwise it gets kind of like, it gets weird.
Yeah,
But-
that's a good point, because like, you know, some of the large firms could have multiple clients where they could be considered a competitor, and you might put all the safeguards in place, and then, you know, like you said, cross-pollinate. So there is a risk there. So I didn't think about that from the closed system. I was thinking it's more the open system. Inside. What do you think, Andrew?
So I mean, I don't know. My thinking's evolving, I'll say, based on what Suzanne just said a little bit. But I mean, my assumption, guys, is that you guys are using it. Like, that's just my assumption, baseline. And I will also say that I think you need to use it if you want to stay competitive, because what's going to happen is eventually it will come to our realization that you can draft things a lot faster. And then that means prices are going to go lower. And then if you want to keep the business, you're going to have to be competitive. I mean, everything we do is fixed, just to be clear, on the prosecution side. So like for stuff like that, I mean, I'm kind of expecting it at some level. Please disclose it. I don't want to be surprised by it later. I think the thing though, that's kind of making my spidey sense tingle from this conversation is the cross-pollination within the law firm. I don't have to think about that a bit more. So, I mean, again, I'm not opposed to it. Like, I think it's something you guys have to embrace. But just, we need to be careful and consider, like, the confidentiality issue obviously is a huge one, but then also, like, look, it's a tool. It's not the end result. Like, if you're, think of it as a rough draft kind of thing. It is not the final work product. I get so much wrong information out of the AI all the time. Like, I asked like a fantasy football question once. I didn't even know who the quarterback for the Colts was at the time. And I was just like kind of annoyed by that. I was like, that's pretty easy to figure out. So just keep in mind that there's holes.
Sorry, I just wanted to build on that, because to me, yes, it maybe could slightly reduce costs. I actually have over years worked in industries where we are cheap. We are not paying, you know, enormous amounts of money. So I would prefer, I actually have thought for a while that it's probably so cheap that we're not getting the best work, but I would prefer you reallocate those resources to just thinking a little bit longer about work and keeping the same price, and maybe using, you know, not using all the time to redraft boilerplate, which I assume you're already not doing. So I don't worry about that as much, but I do worry about junior associates not getting trained to sort of establish critical thinking. And so I think that's a real problem and a real risk. Overuse of AI tools by people who are using them to replace their thought process.
So as a follow-up, do you think outside counsel should have written policies that they share with in-house counsel, or do you trust their independent judgment at this point?
I mean, I trust their independent judgment. I think that it is useful to have policies. I think that's an important thing, depending on your size. But if you're in a relatively decent sized organization, I think it really helps to establish principles that you can articulate across your organization.
I was listening to a CLE a couple of weeks ago, hosted by the National Retail Federation. And it's interesting, they had people with differing points of view, practitioners, outside counsel, on disclosure of AI and its use to its clients. And their kind of position was, listen, we don't tell the outside counsel every single time a paralegal touches this for us if we're not billing for it. So why would we necessarily tell them about every time somebody uses AI? And I don't necessarily think you have to tell me every time you use AI, but I also can use AI myself. So I guess if, you know, I'm going to be paying you however many hundreds of dollars an hour, and I'm trying to establish ways that my being an IP practitioner in my company is a value add for my company, the very least you could do, again, as my partner along this journey, is tell me you're doing that in an engagement letter or what have you, so then we can talk about the ways that you can multiply, what we're doing and trying to accomplish together for the good of my organization, so I can continue paying whatever it is I'm paying you, right? And so to not disclose it at all, I think is a real bad take.
All right. Next topic, what does good communication actually look like? This is very important that you have that with outside counsel. So Andrew, for you, what does good communication look like? And where does outside counsel usually fall short?
Thank you for asking my question, Justin. This is a very special topic that is near and dear to my heart. So look, if you could go to the next slide real quick, because this is the actual rule for the communication. So I don't need to read the whole thing. It's small anyway, but my old eyes can get it. So one of the things is you need to keep us reasonably informed about the status of the matter and to explain matters sufficiently to permit informed decision-making. Okay, so it's table stakes, guys. Like keeping us informed of what's going on so we don't have surprises. Please do that, right? And think about it this way, like, I don't want surprises. It is fine if you email me too much. I will tell you you're emailing me too much. If you don't email me enough, I will notice, because all of a sudden there will be a surprise that I don't like. So frequency is number one. Okay, that's kind of baseline. I think the other thing is, and we've touched on this a few times throughout the day, but be concise. So one of the things that's interesting about this panel is that none of us are exclusively IP up here, okay? And I am the only lawyer in my company. I have limited time. I wish I spent all day on IP. Trust me, I wish I did. I do not. It is a very small part of what I do. So I need things fast. And when I was, ironically enough, for my current company, when I was outside counsel of that company, I'd be like, why didn't you read this big long thing that I sent you? I explained it down there in paragraph 2. So nobody's reading past like the first 150 words when you guys send the stuff out. I mean, that's just a reality, especially at like a smaller company. At a big company, you're a dedicated IP person. Yeah, okay, so know your audience. When it's a company like ours, I mean, even me, I get the details and I don't read them all initially. So I kind of need to know, be concise, get to the point up front, and then say, okay, but here's all the details and the if, this, that, and the other thing. On the same note, make a recommendation, please. Please, please make a recommendation. Don't tell me it's risky, whatever. Like I think Andy Weeks mentioned that earlier. Well, that's like counsel, that's a risk. Okay, what's the impact? How can I act on that? Like help me help my business make a decision here. And I'm going to agree with you, but like I'd like to at least know what your take is so I can think about it, right? We talked about understanding the business. I think that's a big part of it. And then I will get on my hobby horse. And the people that have worked with me, they will laugh when I say this, that are in the room. But please, please have good billing language in your bills. Please, please. Now, Shaitan and I, we worked for a common partner at a law firm in our past that was very specific about the billing language. And I thought this guy was crazy. I thought, like, what is the point of this? But that is the primary way you demonstrate value to us. It's through what you say you are doing for $800 an hour or whatever you charge. So, I say that because I look at the bills and I scrutinize it. And, if I see review documents, $5,000, I don't like that. I don't like it. Tell me why. I know it seems like busy work, but please, like, you look at it as an opportunity to communicate what's going on in a case to somebody like me. Use it as an opportunity to demonstrate value through your billing language. As far as like what could be improved, I mentioned eliminating surprises. I have that on my list here, obviously. Maybe somebody touched on this earlier today, but like, we want partners. We don't want someone looking at us as a profit center for your business. So, I mean, we really need like partnership with our outside legal providers, someone that's kind of invested in what goes on with us. I know it's a little abstract, but I mean, honestly, if it's better for us to settle the case, tell me. Just tell me. Like this is a dumb thing that you guys are doing. Please stop it. I need to hear that, right? Because otherwise we are going to keep doing that same dumb stuff. And it might be good for your business, but it's really bad for ours. So please, just like, hey, you're an idiot. Stop. Like, it's okay. I can take it. I'm an adult.
What do you think is good communication for you? What do you like to see?
Okay, so if you all haven't noticed, I'm more junior than my three of my panelists here. So I think something that Brent and the trademark panel said earlier really holds true, right? Like to Andrew's point, you have to know your audience, because I may want more details because I am a IP practitioner, right, who funnels up to a general counsel and a deputy general counsel. And my deputy general counsel wants to talk to me about every little iteration of things to know that we're making a good business decision, to know that we're spending the money well, and things like that. So I actually do need probably more information than you would send one of these guys, because they're the GC and Andrew's the only person at his the only lawyer at his company. So they don't need that. But I do need to spar with you a little bit and wrestle and be like, well, what about this? And what about that? I don't want you to get annoyed by it. Like I really need that to be able to confidently walk into my GC's office and say the right things. So with communication, you need to really, really not only understand the business, but your audience within that business, because my needs are going to be very different from my boss's needs. I was on the phone with one of my lawyers last week, and he said something to me that I will not repeat here, but I was like, dude, literally, if you say that to my boss, I will murder you. Like, do not. She was just in a board meeting. Somebody said something really stressful to her that is related to this thing. And what you just said was so flippant. Like, do not say that to her. And like, I'm almost kind of like borderline. I can't believe he said it to me, but I'd rather he say it to me because we have that rapport than him say it to her. And I don't know if he would have said it to her, but like, for me, it was like, oh my God, you're going to make us both look awful if you say that to her. So those are just the kinds of things that you need to just always be mindful of. And if you're the senior person on your outside counsel team, right, be communicating down to your more junior lawyers so that they have that point of view too. Because if they get an opportunity to talk to me directly and you empower them to do that, you know, I want them to be knowing the things that you already know about, okay, Shatan is the in-house counsel and she needs to hear it this way versus, you know, this person is the more senior lawyer and she needs bullet points for sure because she only has 5 minutes.
Suzanne, what's good communication look like to you? I know you feel strongly about it.
Pretty similar to what we just heard. I am more of a believer in the bullet points. I do think that there's a true value in making sure that you've sort of given a short highlight of what your recommendation is with sort of the key elements. If you need to attach, I've actually personally do this. I'll like write out my full, what I actually need to get off my chest, the full thought process, and stick it into a document that sometimes I attach, sometimes I don't attach because I realize I don't need it. But I actually find somebody advised me on that many, many years ago, and I found it to be enormously successful for somebody who really wants to articulate all of the issues, have them somewhere. Doing that, and then just putting your email, putting your decision, your recommendation, and your couple of bullet points, super, super helpful, because I also don't have the time to dig into it every time. And I will say what happens is that somebody will send me a 14-page email and I will see it come through and I will sigh heavily and I'll be like, oh, I need to get to that. And then it takes forever. And then eventually they send me like why haven't you responded to me? Oh, because I didn't want to dig through it. What was the answer? How about we just have a phone call? So I will do a lot of phone calls. I actually think that that's something that I personally like. I much prefer to just get on a call and walk through it because I do like that back and forth, the ability to ask questions. And again, so few people will give me an actual recommendation with 3 bullet points. So I like that. I want to also really emphasize what Andrew noted. The billing language and bills is like your primary communication tool, especially when you have high volume So I've worked in, several organizations where we had thousands of patents, thousands of trademarks, like we had tons of bills, like literally thousands of individual little stupid 0.1, 0.2 bills. And it is a painful exercise, but it is the one thing you are forced to actually look at. Like the 14-page email, I can ignore. The bills, I cannot ignore. I have to get those in. There's somebody in finance who's like, if it's not closed by the end of the month, then you're going to get on some nasty gram list that goes eventually, all the way to the CEO. I don't want to be on that list, so I'm always looking at it. And when you communicate and some junior associate says something like snarky in the bill, or they say review documents, $5,000, it is not a good look. Like, this is the one thing that I have to grade you on when I'm looking to grade you at the end of the year. Like that, because everything else, to Tan's point, is sort of soft and a little fluffy.
One thing that Andrew said that hit me really hard is if you're doing something stupid, please tell you immediately. So IP is only a small portion of what I do. I'm general counsel, so we have all sorts of stuff. So we did like 3 acquisitions last year, and that's a new area for me. I've never done it before, so I was working on it, and obviously it was new to me. So outside counsel said, "Hey, I would not recommend this. I'd recommend that." So I really appreciate that. So if your in-house counsel is doing something that needs some help, speak to them, and I'm sure they'll appreciate it. So I really did like that. That hit me hard.
Yeah, just one thing I'd like to add, just to kind of put a finer point on the bullets up front, the details down below, whatever. But like any of the point, I think also like what's in the bullets is important, and I don't want to gloss over that. So we have a lot of conversations at my company about being impactful, like having impactful insights into the data, or just making observations about the data. So in other words, like, the new tax bill passed last year. It's going to be bad because the solar tax credits go away. Okay, but what is the impact on our business? Like, really, at the end of the day, and that's like where like the real money's made by you guys and by us too. When we advise our stakeholders internally, is impact versus observation. So I would definitely lean, and this is again my preference in your bullets, recommendation and impact. Like, what is the impact of the recommendation downstream? Because nothing's perfect. We're asking you because it's not a layup, right? That's why we come to you. The layups we can handle. So when you guys get brought on board, we actually need some like real impactful and meaningful advice from our, council.
We talked about this. The next topic is billing and ethics. We talked about this a little bit. But let's further develop. What causes you the most heartburn when it comes to billing and outside counsel?
When they don't stick with their budget. I mean, I know that's stupid, but I do ask for estimates or budgets up front, or we have, flat rates. And it is completely unacceptable to me when somebody doesn't let you know that whatever number you would have to is just not going to work because of X, Y, and Z, and they don't let you know that they go ahead and spend all the money. That really irritates me. Less on the communications, but on the, just straight out, that to me is a bad thing. On, fees, to me, the AI, I think what we talked about before, as you are using more and more tools to spend the time, I do think that there's going to need to be some assessment of how you're looking at your fees. I have turned a blind eye on occasion to law firms that are clearly just making up their numbers, because I know for sure that they just billed it under one person and that person was not the person who did the work. But that's generally for a flat fee where I'm like, whatever, this is how the billing system did it. But that only works in certain very, very specific situations. And I think as these tools take over a lot of that busy work, a lot of that sort of time spend, how are you assessing your fees structure and how are you really planning on billing that out is something to to think about, because I think it will continue to create these situations where you're actually just lying on a bill. Like it's not true.
I'm
And that's unethical, by the way, to lie to your client on the bill.
Yeah.
Just a note.
Yeah, exactly.
I typically prefer flat fee billing, at least when it comes to IP, so it's predictable, so I can put patents on the trademarks we need to file a year. And when someone doesn't, meet that fixed fee, then, it is kind of upsetting, and then you have to go back to the team. And so, related to that, how important is it to you, Suzanne, that they communicate who's going to be on an IP?
So it depends a little bit on what it is. If it's a like prosecution, like prep and pros, and it's flat rated, again, I don't love that there are firms where the billing system flat rate bills it under a single person, and that's not the person that actually is doing the work. I don't like that. I think that's probably unethical, and that's just the way it is. But I don't know that I always need to know who's doing it, depending on what it is. If I want something where we're building up a relationship where they're going to be working on more and more matters, eventually I will want to know. But if it's a junior associate, you're training and you're the sort of face person, you're managing them until they're on a lot of matters, that's okay. If it's something where we're doing like an M&A deal, or we're doing litigation, or, something where we're actually going to have like a staff for this extended matter, I do really care, because I have seen so many situations where we have like 5 partners on the same matter who are all doing the same thing, and then like 4 different senior associates and doing like document review. And to me, that's just a padding. And I think it's
Andrew, you touched on this earlier. What do you think of block billing, and do you think it's ethical?
I'm going to expose myself here. I'm not sure what block billing exactly means. I will say fixed fee billing.
Well, block billing is when you have an attorney that does like 8 or 9 projects, and they have one entry, and they put like 17 hours, and then you don't really, they can't really distinguish between each individual thing.
I think the only time I actually care about that is we're filing a fees motion, and now I got to break it up. But I also don't want billing. I'm very particular with billing language. I want it thoughtful, but I don't want a lot of extra busy work and extra time entries. Sometimes I actually rather just see like, oh, this person's, if I add up all their individual 5 things that day, it ended up being 27 hours. I don't know how that works, but okay. So, I mean, I think I prefer a block billing kind of thing.
Yeah.
Fixed fee on things that it can be fixed fee. And like we do prep and pros fixed. I think trademarks fixed. I think a lot of the IP stuff's fixed. There's opportunity there for other things too, especially like when I work with accounting firms, a lot of the work they do for us is fixed fee. And I like it to Suzanne's point about budgets and going over it. It's not that it's expensive. It's just that it's a surprise, because, I don't have a budget. I have a forecast. Now it's treated like a budget, but it's a forecast. So what I really need is certainty over cheap, if that makes sense. Like if it's literally going to cost $100,000 a year, or $100,000 a month to do this particular litigation, that's fine. Then I can talk to my CFO about it and we plan for it. But if you tell me it's $100,000 a month and ends up being $500,000 a month, that's a problem, because now we've burned our whole runway off for the year in 2.5 months, right? So certainty is really important. If you're going to go over, just communicate. It's really like the fees. Look, we all got to make money. I get it. But, it's at the end of the day, we just need to be able to plan. Planning is super important. So, yeah. And then, a lot of what Suzanne said resonated, so it doesn't bear repeating. So turn over to Shaitan.
I think it would be nice if outside firms can be thoughtful about planning who's working on what, right? As you have more attorneys who are with a business for a long time, which is a good thing, because then you are going on the partnership journey with the inside counsel and you're learning along the way, improving outcomes. At the same time, you, associate, are now hopefully transitioning to counsel and partner or whatever, or, whatever the model. Be thoughtful about bringing people up behind you so that, that bullet point on the previous slide said overstaffing junior associates, but like she said, like also overstaffing very expensive attorneys, right? Along the way, because I don't necessarily I want the benefit of you having the relationship with my company, that the business for us a long window of time. But at the same time, if we're just working on trademark prosecution, right? Like I don't need your excessive billing rate doing that work. What I'd rather you do, sort of as an egalitarian matter as well, is training somebody up behind you and then having that person also learn my business and then doing that work so we can stratify who does what at what value add and those sorts of things. So I think that's another thing to be mindful of when billing, right? And I don't necessarily want to have to ask for that. It's an awkward conversation for me, one I'm very willing to have. Don't make me have it, right? Like do the right thing, which is to train up somebody behind you and then let them, sort of help you take over. And then that way you can put your effort into the more expensive, really necessary things where your built up expertise over time is more useful.
And just sort of building on that, I do think that it's particularly challenging for large law firms because of the cost model and the structure, that there's just such a short runway where junior associates are actually inexpensive enough to learn. So having alternate types of people staffed is really useful for sort of long-term consistency, whether that be patent agents or, of counsel that are just going to say somebody who is going to be consistently the same price for a while or close to the same price, instead of these leapfrogging costs where there's nobody who's like $800, $900 an hour who can do some of this like standard work. They just can't.
All right, the next topic we're going to move into is conflict of interest. So Andrew, this one's for you. What are your thoughts on what outside counsel should do with conflicts of interest in a world where many companies, they represent many companies in the same industry?
Yeah. So first thing I'll say, just rule of thumb, you can trace this down into the rules, but if you have to think like pretty hard about it, it's probably a pass. Just think about it. I mean, like it's kind of your gut's probably telling you the answer without you. It may not be the answer you want to hear, but your gut's probably telling you your answer. Now, I'll say like I work with small firms, I work with big firms. I love the big firms because if I have some weird, like general practice firms, if I have some weird issue, I can go to my contact and they're like, oh, I got a guy that does that. What I don't like is that everything's a conflict. And that's really frustrating when I want to work with a particular firm. Small firms have the opposite issue. Oh, no conflicts, right? But they may not have the people I need. So I think I'm pretty liberal about conflicts as far as like my expectations, as far like if it's not a direct competitor, then I probably don't care that much. I expect the firm to have to know the conflict of interest rules, set up ethical walls where appropriate, and all that's fine with me. Things that do drive me a little nuts are engagement agreements with prospective conflict waivers. Mm-hmm. And if you work at a firm that has a prospective conflict waiver and an engagement agreement, I would highly suggest you just take a second and think about how somebody like me justifies that when that comes up down the road, because it's not good. And that's usually the argument I use to get them struck out of the agreement. Now, sometimes I don't care. Sometimes it's fine. It's rare. Usually where I give firms a pass is if they do a lot of M&A work, and especially on the bank side, like that's really hard. I get that. It's hard for them to work through those. And then I say, okay, if that's the issue, then narrow your prospective conflict waiver to what you're asking me to put sign in here. So like what as far as my expectations, don't do that, right? Keep your prospective client waivers normal. But other than that, I think I'm expecting you to not have people work on things where there's like real conflicts of interest. Like, and what would be a conflict of interest in our world for patents, especially, is the subject matter is going to overlap. And then you're going to have to like hold back what you would say about a prior art reference because it's one of your clients. Like that's kind of the classic example. Like, I don't want you having to do that. So you need to staff your matters appropriately so that we're not doing that. And if your firm has that issue, I don't know, maybe you have to think about that, but I don't get too bent out of shape about it. And I actually err on the side of choosing the lawyers I want to work with over getting bent out of shape about these guys represent some third-party operator, financer type in the solar industry. Like that one comes up a lot because there's 2 or 3 of them that use pretty much every law firm in the country, apparently. So I don't care about that. Sometimes the firms do. So I don't know. I think most of us probably have a pretty reasonable way of dealing with that.
Next topic is lots of fun, and people outside counsel usually doesn't want to deal with this. Bad news, mistakes. This one's for Shaitan. When and how soon should outside counsel tell you if they've made a mistake or if there's bad news or something along those lines?
Yesterday. Please tell me immediately, right? Because again, I can't express it enough. I feel like we're on a journey together of partnership, right? And so just like my boss would tell me, Shaitan, if you made a mistake, just tell me right away so we can address it. Like, I'm not about to get fired for a mistake, right? We're all human, we make mistakes. And so if you've done that, like, give me an opportunity to help you address the mistake, work on it together. Because you have to remember, I also have a duty to report a mistake. So your mistake probably is going to be seen as my mistake, right? And so I need you to tell me that as soon as possible so we can mitigate together. I think, don't take me down, right? You are my partner. We want to get back to good together. And so I just, as soon as possible. And I know another question we'll get to, though, is about just telling me versus doing something about it. We'll get to that. But I guess I'll say, when you report to me, have a plan about what we're going to do to address it. I might not agree with that plan. I might have other ideas. We might go back and forth. But give me a starting point to be like, okay, what's next for us? How can I help us get to the right business decision? How can we pivot? Those sorts of things. And you giving me a baseline of, okay, this happened, not good, but here are our options. I can go, okay, option number 2 sounds good, but we need to do X, Y, and Z instead.
What about for you, Suzanne?
I mean, I feel the same way. And I have had a number of experiences where my team has found mistakes that have happened, particularly missed filing dates of various types of filings. And that's bad, because we weren't looking the next day. This is months later, we're looking why didn't we see something? Oh, let's go look on every single publicly available database that we could be looking on. But again, we're busy. And wow, there was nothing filed. And now we spend hours trying to figure out, is it our error? Because clearly they would have reported. Nope. Multiple law firms just never report, never do anything about it. It's one thing if they were fixing it and we're planning on, and it's 3 days. In every instance, it's been weeks or sometimes even months of just radio silence. And that makes them less of a trusted partner. That makes you not trust them anymore, in my experience, at least.
Yeah, don't let me find out before you tell me. It's
the worst.
The worst.
So how should they come to you with a mistake? Should they own the problem or simply just report it, or what do you prefer?
Please own it.
Do you want an apology or what are you looking for?
And when I'm nothing. Well, there's a lot of things that frustrate me, clearly, but when there was a mistake and I'm like, hey, what's going on here? And the response I get is a lot of CYA kind of stuff. It's man, that is just not helpful right now. And it's making me more irritated. Really what I need is a solution, because you know what? Mistakes happen. So just own it. And here's the thing. You won't lose the business because you owned it. You won't lose the business because you made a mistake. You will lose the business because of, now look, if there's a lot of them, that's a different story. But you're more likely to lose the client if you're not being forthright with them. I mean, ethical issues aside, if you're not being forthright with them, you're not offering solutions, and you're not even reporting it in the first place. That kind of blows my mind what Suzanne just talked about. And so look, it's okay, but own it. Don't push the blame off to an associate. Please don't do that. If you're the partner, don't do that. That is not a good look, because you own it. Like, you are the responsible party from my point of view. So just own it, come up with a solution, and we'll work through it. It's really what it boils down to.
Just re-emphasize that because it makes me more angry than almost anything else. Like, don't push stuff down to an associate or paralegal or docketing clerk or anything like that. It is unacceptable. Like, I just think that is such bad form.
It looks like we have about 5 minutes left, and want to give the audience the opportunity to ask any questions that you guys may have. So please feel free. You, sir.
Related to the topic of rates and fees, do y'all have any comments on the typical law firm practice of like rate increases and how y'all react to that, how y'all handle that, view that?
I don't care. I expect it, actually, and it's okay, because I was in that. I think I think if the rate increases are ridiculous, that's a different story, but I haven't seen that, so it's okay. And just be forthright, like, hey, we're raising our rates. It's the end of the year. Fine. Others?
Yeah, I'm like the opposite. I don't like rate increases. It's maybe every 4 or 5 years, but we want predictability, and we want to understand unless something new is coming out, new substantive work that's so much better, a new person, because we do lots of fixed fee. Every couple of years is fine, but not every year. Like, all right, like, because since we're a product company, every year 5-10% of our products. But with legal service, I typically don't like to see that.
Yeah, and to be clear, I'm talking about hourly rates. Fixed fees are a different story. Yeah.
And I'll just sort of build on that, because I've worked at a couple of organizations where, I've run IP and it's been largely fixed rates. So I generally don't care what kind of rates you put in there, because what you're going to bill me is whatever we agreed on a fixed rate. However, I'm working within legal groups that really care about it. And so I'm constantly having to approve the rates. And I will say, I am a big proponent to agreeing on the price. I will almost never hire any law firm without having some agreed price that we're going to, whatever this matter is, whatever this engagement is, we're going to agree on some sort of budget for it so that I can have the predictability. So I don't so much care, but I have worked in a lot of organizations where we will not agree to any sort of rate increases for years and years. And it is like a hard conversation every single year. And then when you finally do agree to it, it's like this dramatic difference, because like the rate increases are a little bit crazy. I mean, I will say I've recently paid numbers that I didn't even think could exist.
Like, I understand that. Yeah. Tax attorneys in New York are like, I got a couple. I almost had a heart attack, and I'm like, I'm in the wrong line of business. You want to make money? Be a tax attorney. It's insane.
In Silicon Valley,
Yeah.
I thought I was going to die.
Yeah, it's crazy.
What about you, Shaitan?
I just wonder if I've worked for partners in the past that have been thoughtful about their client's business and how much they offer to charge vis-a-vis that client's needs and business or whatever, probably 1 or 2 across a few different law firms. And so I just wonder why more law firms aren't that way. I currently work for a company that, for as inexpensive and high quality our products are, we are pretty liberal in paying rates that come to us as is. I'm trying to whip my company into shape, being a little more stringent about that, because I think I'm probably one of few companies who still sort of pay full freight and talk about it on the back end. And I think I need to do that because I think it creates a discipline in the attorneys, the outside attorneys, to do their job better and more efficiently and what have you. But I just encourage some of you all, again, on this partnership journey, to be thinking about ways that you can say, hey, partner, general counsel, I know that you guys have had a lot of stuff this year. And although it might seem like shooting yourself in the foot a little bit, we're going to freeze these rates for this year, recognizing that like last year, man, you really did pay a lot of money in legal fees or whatever. Those sorts of little things will definitely put you ahead, I think, of your competitors. And again, increase the partnership journey that you're on with your client.
Sorry. I just wanted to sort of build on that because it got me thinking about the communications that this has. So when I see somebody who is billing at $2,000 or more an hour, I will say nobody is worth that. Like, and I will look at you like this is a person I no longer trust, and I am going to be annoyed before they even open their mouth. Like I'm going to take their advice because that's what I'm paying for, but it better be perfect. It better be so perfect. Like there's like, wonderful stars coming out of it. And that is not a feeling that I want to have with a partner. Like that I inherently am irritated before they've even done their work. That's not right.
Definitely not a good partnership, but I wanted to thank you guys for doing this presentation. Always doing an ethics credit is hard, so I appreciate that you guys took that curveball. So thank you.
All right. Good afternoon, everyone. Thank you for sticking with us throughout the day today. We're down to our final panel, and this is a good one. We're all going to get our professionalism credit right here. And we obviously have a very highly distinguished panel for you today. And so with that, I'd like to introduce our panelists, 4 judges from here in the Northern District of Georgia. I'll start by introducing Judge Ross. Judge Ross received her BA from American University and her JD from the University of Houston Law Center. She previously served as Assistant District Attorney in Tarrant County, Texas, was Assistant Solicitor General in the Office of the DeKalb County Solicitor General, was later an AUSA in the Northern District, and was a judge in the DeKalb County State Court. She was nominated to the bench by President Obama in January 2014 and confirmed in November of 2014. Welcome, Judge Ross, and thank you for being here.
Thank you.
Next, introduce Judge Brown. Judge Brown received his BA from Georgetown University and his JD from UGA School of Law. Prior to being nominated to serve in the Northern District, he clerked for Judge Edmondson of the 11th Circuit, was an AUSA in the Southern District of Florida and Northern District of Georgia, and was in private practice at King & Spalding and Alston and Byrd. He was nominated to the bench by President Trump in July 2017 and confirmed January 2018. Welcome, Judge Brown, and thank you for being here. Next, I have Judge Grimberg. I realized that I didn't put my slides up here. Judge Grimberg got his BA from the University of Florida and his JD from Emory. He previously served as an AUSA prosecuting white-collar crimes and was Deputy Chief of the Economic Crime Section of the U.S. Attorney's Office for the Northern District. He was also a trial attorney in the U.S. Department of Justice Tax Division and later served as Managing Director and General Counsel of Nardello and Company. He's also served as an adjunct law professor at Emory Law. He was nominated by President Trump in April of 2019 and confirmed September of 2019. Welcome, Judge Grimberg, and thank you for being here. Finally, we have the Honorable Judge Boulay. Judge Boulay received his BA from Washington and Lee University and his JD from UGA School of Law. He was a law clerk to Judge Evans in the Northern District, then served as a captain in the U.S. Army JAG Corps. He later became partner at Jones Day and a judge in the DeKalb County Superior Court, where he founded the Veterans Treatment Court. He was nominated by President Trump in January of 2019 and confirmed in June of 2019. Welcome, Judge Boulay. I want to make today's panel interactive. So to the extent you have a question, we have a very unique opportunity here, having 4 judges from the Northern District here to answer questions. So if you do have a question as we go along, please feel free to raise your hand and I'll try to get to you. But But I wanted to start today by talking maybe about some high-level concepts of professionalism, and these apply to all attorneys practicing in the state of Georgia. The Lawyer's Creed was incorporated into the rules and regulations of the state bar, and they set out basically rules for attorneys practicing in the state to live by. I thought interesting was the third point down. It says, to the courts and other tribunals and to those who assist them, I offer respect, candor, and courtesy. I will strive to do honor to the search for justice. The question's open to anybody on the panel who wishes to speak on the topic, but what does it mean to strive to do honor to the search for justice, and what does that look like in today's modern litigation practice?
Well, I'll start. Good afternoon again. I think that it means making people proud to be in our profession, honestly. When I see lawyers come into court who are not prepared, who are not being civil toward one another, I'm embarrassed, not just for them, but on behalf of our profession. When I talk to jurors after jury trials, and I always, after every trial, invite lawyers to come back and speak to them and get feedback. And I hear jurors during the voir dire process were saying, oh God, I don't want to be here, and saying everything they could to get out of it, saying what a wonderful and meaningful experience it was and how much they appreciate what we do as a profession. It makes me really proud. And so when I see lawyers who are not striving to maintain that standard, again, it makes me feel bad. And it simply makes me feel embarrassed. So civility, preparedness, not coming to court and just winging it. We can always tell when that's the case. And respect to staff. I have a practice of picking up my own phone a lot of times, of course, not identifying myself because I'm curious to see who's calling the office and being rude to my staff. Yep, Shaitan argues with me all the time. Don't pick that phone up. But I like to see that. And so those are the things that are most important to me.
I agree with all that. I would just add that we have this unique adversarial system that is designed to reach the correct result, the just result. And as parties to that adversarial system, as you go about your everyday practice, I think it's easy to lose sight of that greater goal of justice. And what I would say to especially those who are less experienced in the room, because I think those with more experience will have already learned this, that there is no case, there is no client, there is no issue that is more important than your reputation. Your reputation with the bar, with the courts, that is your currency. And if you compromise that for the sake of gaining some sort of tactical advantage on behalf of a particular client or particular issue, it's going to cost you and your future clients in the long run, because you will have lost that currency. And I would protect that reputation of yours very jealously, over and above any particular sort of fight that you're having that particular day in the case that's before you.
When I heard you read when I read it, I almost don't see or hear the words respect and courtesy. Not because I don't think they're important, but because I hear the candor part of that very strongly. I think that is one of the most important things about practicing law, is being candid. And I sometimes think that there are, if you appear before me enough times, you will hear me say that I think there are people who use words to try to help reach an understanding. And there are people who use words to do the opposite, to obfuscate or to hide. And I find that group very, very frustrating. The practice of law is already hard enough. We deal with lawyers, we deal with clients, we deal with judges, we deal with scheduling, we deal with changing theories and witnesses that go south. And what we don't need to do is to make it harder by having somebody say something that they really don't mean when they have some ulterior motive or meaning behind it. So I think respect and courtesy is important in all things. But I think that the key to that for me is if you're in my courtroom or you're writing something to me, to tell me what really happened or to tell me what your real point is, and don't tell me about 5 things that don't matter if what really matters is one thing. There's usually like 3 things in a case that matter, and we ought to be fighting over the other 4 or 5. We ought to be really saying these are the 3 things that matter, and let's decide this difficult case based on those. That's kind of the way. Not that I don't think those are important.
Look, I would just add that, as I look at the lawyer's creed, think about back when I was practicing law. It's been a while, but I remember just how stressful your jobs are. And I know how easy it is to kind of take the bait when the lawyer on the other side perhaps is not following the lawyer's creed. I would say as I look at the lawyer's creed, not only the part about the courts, but everything, I always think back to, I had a grandmother I was very fond of, Fern. I look at all of this, each part of it, and I think to myself, well, how am I acting? Would I want Fern to see me acting this way? And so I would encourage all of you, whether it's your grandmother or your great uncle or your best friend from whoever it is that you just really admire, think about in every interaction with opposing counsel or with the court or with your client, what if Fern saw me doing? There's a lot of words here. It's hard to read the entire PowerPoint, right? But just what would Fern do, and would Fern approve? And I think you'll probably be on the right track.
Speaking on the topic of candor, I did receive a question from a participant today that he would like to ask. And the question is, how often do you see a brief that points out law that is unfavorable to that party in addition to law that is favorable?
I think not infrequently, maybe 20% is not that frequent, but I would say 20-30% of the time. I find it very helpful because if you're going to cite it, the bad case, you probably have a really good reason to think that you've got good cases. I just find that a lot better. I like to remember, some of y'all are old as I am, and you go to the library when you were a young lawyer in law school. You just keep wallowing around in the law until you kind of started seeing the same thing. I still try to do that. And I find that other side of it very helpful in that wallowing.
Yeah. Let me let you in on a little secret if you don't already know. Us federal judges, we have some outstanding law clerks. And so the idea that you're going to sort of try to get away with submitting a brief that avoids a negative case that's on point, it's not going to happen, because even if the other side doesn't find it, I promise you our law clerks will. And I cannot tell you how much your credibility is damaged when it's our law clerk finding a case that is on point that neither side has identified. So knowing that and assuming that, which is a good assumption for you to make, you are best served by going ahead and hitting it head on, acknowledging it, trying to distinguish it on the facts if you can, but don't hide the elephant in the room.
Continuing on this topic, also incorporated into the rules and regulations of the bar are these aspirational statements that each lawyer practicing in the state should strive for. And there are aspirational statements as between interactions between counsel, and aspirational statements as between counsel and the court. And as I was preparing for today and came across these, I was examining, it looked like 1 through 7 are fairly basic and common sense, right? Act with complete honesty, know the rules, give appropriate deference to court rulings. What stood out to me as interesting is number 8 there. Excuse me. Number 8 says, I should seek to understand the judiciary's obligations of informed and impartial decision-making. And in preparing for this, Judge Brown, I know you kind of took interest in that one as well. Why is it important, and how should a lawyer go about putting themselves maybe in the court's shoes as they're litigating a case?
Well, what hits me on this point is how often I hear arguments that are either emotionally based or some type of, quote, fairness based that really doesn't apply under the law. Or people that will tell me that there is a decision, but I could go the other way. I'm not exploratory in that regard. And it is interesting to me how often I see those types of arguments. And it is for me, it is hard. It is something I work very hard to do, to be impartial. It is a very thoughtful way that I go about it, because you read things and you can't read a story like a case without kind of wanting the outcome to be one way or the other, if I'm being honest. But I try my best to be very impartial in that regard. But it is a thoughtful exercise for me. And so I don't like it when I hear things that try to pull me to the other side. That's what I can say about it. If I'm being honest, I work very hard at it, and I don't appreciate sort of the arguments that are not really legal based or maybe even factual based, but emotional based or something that doesn't really, we all know it just doesn't matter under the law. Sometimes that's more in criminal cases than y'all have, than most of the people do here, but I still see it in civil cases very much.
Can I mention one quick little thing? Actually, number 6 about attire. I think that, and this says show respect by attire and demeanor. I mean, I'm never going to take any disrespect for how you dress, but just as far as how you dress, I think some people have gotten a little slack on that. We have a Zoom conference. You know, I do a lot of Zoom conferences if it's just a smaller discovery dispute or something, and from down to the courthouse, it's just a 10-15 minute thing about a disagreement about a deposition or something. But I would encourage you, if you have a Zoom hearing with a judge, dress as you would if you were going to court. I mean, don't dress like you would if you're, if it's casual work day from home and you're still in your pajamas or something. I haven't had pajamas, but I've had, definitely they would not dress that way in court. And usually if I'm on the Zoom call, I've got my robe on and everything. So just try to look professional.
On the other hand, I think it was last Wednesday I got out of my car.
Oh no.
Wearing jeans and a button down, and you got out of your car wearing jeans and a t-shirt, and a puffy jacket.
Oh, come on.
But you have on robes.
That's right.
We looked at each other and we said, I'm glad we can dress like this sometimes.
Right.
So, yeah.
I know that we've focused on 8 here, but just a couple of the other ones, the number 2, court rules and procedures. Of course, in our court, every judge has a set of set rules or standing order. And a lot of it is pretty much similar, I would say. But it's important to know an individual judge's rules and procedure when, simple things like on consent motions, give us a proposed order. When I have to have someone follow up with an email, per our instructions and cite the instructions, we did not receive this from you or that. It's just a little annoying. It's not the worst thing, not the worst, a cardinal sin. But just take a moment, there's a reason that we docket those instructions in every case. Take a moment to familiarize yourself with that judge's particular instructions. And one other one I want to mention is number 4, avoid undue familiarity with members of the judiciary. When I was on state court, of course, we had to run for office every 4 years. So it was more likely that we would attend events. Federal judges, of course, have a lifetime appointment that may have something to do with why you don't see as many of us at events. But I can tell you that I still go to a lot of events, primarily because my husband is a state court judge, and I accompany him to a lot of them. And I love running into lawyers and talking to them, but when you approach a judge and the first thing you do is try to discuss a case, even if it's one that is closed, and you'd be amazed at how many attorneys do that. It's just very uncomfortable and very awkward, and no judge wants to be put in the precarious position of saying, I really don't want to discuss that with you, but it happens a lot. And so just respect that that judge is at an event just to let his or her hair down and have a good time where you are, and kind of don't discuss the specifics of a case, again, even one that is closed.
And it's usually prefaced with, I don't want to talk about the case, but.
So judges, I have a question for you. Judge Ross, based on your very good point about, reading the standing order, knowing what the expectations are. Do you feel, just based on your experience, whether local counsel pulls his or her weight in your cases? And what do you think the obligations of local counsel are, other than obviously what our local rules say?
We've had a lot of issues with local counsel. Local counsel is brought in for the pro-hack person just to have an office in the district, and then something happens, the pro-hack person gets off, and local counsel is scrambling and says, hey, I wasn't really an attorney, and I get that relationship. But when you are looking, the court is looking to local counsel to guide attorneys who are not admitted in our court. And so it's very frustrating for us when you have gotten local counsel on a case and local counsel is not doing what they should in terms of letting pro-hacks know how we run things and what we do, because it may be very different from what that attorney is accustomed to. So that has been, unfortunately, a big issue for us at times.
I take this as an opportunity to plug local rule 56.1. The importance of that rule at summary judgment. I cannot tell you how many times I rule on summary judgment, and I'm not considering a bunch of facts that one party wants me to consider because they haven't complied with 56.1 as to either their statement or their response to a statement or their response to additional facts. I have gotten so frustrated with it that I thought last year about putting out a special order on it in my cases, and I didn't do it, and I'm regretting it now. And so I've got a law clerk that's working on it. So I don't want to let any opportunity go without telling everybody to pay attention to 56.1 of our local rules. You'll see that it says there's only one way to do those things. Okay.
All right, we'll work our way through maybe the life cycle of a case a little bit and various stages at which issues of professionalism tend to arise. I received another question via email last night, and so I thought I'd put it in at the start. A patent case is filed. It's assigned to one of your honors. The question really dealt with the issue of special masters and when you might consider bringing a special master onto a case. What are the factors that you consider in doing that analysis? And are there certain areas of technology where you are more or less comfortable, whether it's biotech or chemistry or a software patent? And what does that decision tree maybe look like for you? But to tie it also into the topic of professionalism, are there unique issues of professionalism that arise in that context when a special master is used? Any thoughts on that topic?
How quickly can I sign the order? Really what it comes down to. No, I have had a total of one patent case where I did not appoint a special master, at least cases that got past a motion to dismiss. And it was because the parties convinced me that it wasn't really that complicated. I could handle it. There was no need to appoint a special master. Boy, did I regret that. I was an English and political science major. I cannot even spell patent. So all day long, I will appoint special masters on patent cases because I think that the technical issues are such that it is I find it incredibly helpful to have that expertise, even though ultimately it's our final orders and we will take, objections to a special master's recommendation, I find it incredibly helpful to have that at least as a starting point.
I agree.
I third it, yeah. I mean, it's the truth. I wish that, that I were more, well-versed in patent issues, but, until that, that's one of the reasons, one of the many reasons that Chatham was such an attractive hire as, a law clerk. It's just a special, skill set and knowledge that a lot of, judges, quite honestly, have not mastered. And when things get technical, when I see an IP case come in, my first thought is, let me consider whether a special master should be assigned. I'm almost ashamed to say that, but it gives me comfort to hear my colleagues saying that. But yeah, pretty quickly it's considered when we get it.
I feel like I've missed the boat on this. I have not done that. And I'm starting to rethink that. I like those cases. I have a couple of them. I had some when I was in private practice. I had a couple of theft of trade secret cases that I really enjoyed working on. And I also really like sci-fi. So I kind of enjoy it, but I'm kind of now thinking maybe I ought to wake my law clerk up or thinking about this,
Or
because I haven't done it.
We can just reassign the cases.
No, that's
to
okay.
you.
And that doesn't mean that we're totally hands off. Don't get me wrong. There's not like that. I don't think any of us are like that with any of our cases, but definitely the special knowledge of a special master is very helpful in those cases. And I'm constantly getting resumes and letters from people who want to be considered as special masters. I look at those very carefully because I do not take that role lightly. It's very significant in these cases.
You've opened up a can of worms here, judges, because with this audience, all of you are going to get a bunch of business cards.
Obviously, talking about discovery, we're past the pleading stage. Discovery is obviously probably the most fertile grounds for disputes that arise. And I did receive a question via text that I'd like to ask with regard to the scope of discovery. The question is, justice in the courts is often not accessible to smaller firms or individuals with meritorious claims due to high fees. Large defendants can drive up fees in an effort to win by outspending a smaller plaintiff. Do you have any practical tips on how practitioners can use the rules or the court to help streamline discovery or otherwise constrain parties seeking to drive up litigation costs?
That's a phenomenal question. I'm not sure off the top of my head I have a great answer to it. I think as far as kind of tease off a little bit on that, the third question here, what can lawyers do to propound better written discovery? And my thinking on that one was that I think there's a tendency just to use your stock discovery requests that you have from the last case that ask all these kind of semi-basic type questions and not really think about what you need in the case, what you think the other side has, and ask for that more directly. I think that can probably save some time and money just by narrowing what you need. And by doing that also, the other side's not going to fire back immediately that you've propounded these overbroad requests. So I think my answer to that would be think about what you really need and ask for that. Not a lot of stuff that you don't really need that you asked for in the last case just because it was on a standard stock set of questions that you had from 3 or 4 cases.
Yeah. And probably most of you know this, but many of us have a joint discovery dispute process now because we were getting inundated with motions to compel. And what was becoming very clear is that parties hadn't even really talked to each other before going and filing these motions to compel a lot of times. So many of us have within our standing orders a requirement that if there is a discovery dispute, and a lot of times the dispute is this side is being overbroad in their request, they have to jointly submit an email or something to us that gives both sides point of view. And then what I do in my case, I don't know, different judges may handle their joint discovery dispute processes differently, but I send an emailed response of my inclination. This is what I would be inclined to do. It's of course not an order because I'm not responding to motions. And a lot of times that inclination, if I'm saying, look, my inclination would be to find that this side is being unreasonable and asking overly broad for making overly broad request, then a lot of times they are able to resolve their dispute based on that. If they are not, then I will go ahead and say, okay, you have permission to file a motion to compel, and it gets briefed. And once it's briefed, I decide whether to keep it or send it to a magistrate judge. But again, a lot of times just requiring the parties to submit something to me, and there's a page requirement so that they can't go on, and a requirement to not attach a bunch of emails and all of that stuff. I will send just an inclination, and that alone is often enough to trigger some resolution without it leading to a bigger dispute or even the filing of a motion to compel.
I will say this, and I think the question also sort of goes to sort of getting out-resourced by the other side. One thing that I find very helpful when if there's a discovery dispute about a request that is very burdensome, is to give me a sense for whether it is proportionate to the needs of the case, which is obviously part of our standards now. And because sometimes I find that the parties sort of assume going in that I know more about the case than I do. And generally, unless we've been involved with prior issues, we don't really know what the value of the case is, like what it's worth. And having that data point oftentimes is helpful in trying to fashion some sort of compromise when it comes to discovery issues.
So from the propounding party, I guess, to the responding party, and what seems to be the ever-present issue of boilerplate objections. I guess the question would be, are they still prevalent? And what can you do to reduce the problems that arise from asserting those?
I think as long as you have associates, you will have this problem. And it's not their fault. It's some partner will tell them to go do something, and they will just start pulling everything in. And then you just get this litany of objections. It is really remarkable to me that you still get this litany of objections. When I get the discover responses, when there are problems, I have a similar process to Judge Ross. I almost don't even read them because I know what they're going to say because I've read them enough in my time. I think they are totally useless. Somebody said to me today, Judge, we have to assert this every time or we'll waive the attorney privilege. I don't think that's true. You put it up front. I don't need to read it all those times. And this can't possibly be a privileged issue. I am constantly vexed by that. And I don't know why it continues other than the fact that people don't pay attention enough when they're doing the discovery responses to really focus on the issue.
Do you find?
No, please.
Do you find that they materially lengthen the case or cause unnecessary problems, or do you think they're just there and they're always there and you just kind of gloss over it and move to the real meat of the issue?
Well, I gloss over, except for what they say is subject to this, we'll provide essentially what we want to provide. And then it takes a lot of back and forth to figure out what the person is not really providing, what they're holding back based upon all of these boilerplates. I find that very frustrating. I find discovery, other than sentencing hearings, the least enjoyable part of my job. And I spend a fair amount of time doing it. I have a process like Eleanor. I usually bring people in and I try to parse through them with them at first. And usually that's enough if they get the idea of where I'm kind of leaning. But some don't. And then I just, at some point, I tell them that I'm just going to stop splitting babies. And if you are bringing a dispute up, give me your side and I'll just pick one winner. I don't know how else to make people be reasonable, but there ought to be that compromise that I don't think exists.
I've got a slide later on that same topic, but do you want to, each one of you, just briefly touch on what is your procedure and how did you lead to the adoption of that procedure in terms of resolving efficiently discovery disputes?
I do what Judge Ross said. I have people send me an email. It's limited to 3 or 4 pages. And then I will pretty quickly try to get them on the phone, usually on the phone, in order to resolve it. If it is not being resolved, and if I see sort of serial problems, then I will impose a requirement that people come in for a hearing, and we resolve it that way. And some of those are pretty lengthy. I was in one today, really all day long, going over things that I thought we had addressed and concluded several weeks ago. But it is just, it's a process that if parties really work at it to try to understand where the issues are, I think it can be very effective because it can be pretty quick.
And I've already explained mine, but to your point of asking how we got to that point, when I first got on the bench, I found myself having phone conferences all the time based on motions to compel. And I thought this is just not going to work to keep doing this. And it was obvious to me, as I said earlier, that during a lot of these conferences that the parties had never really had a meaningful discussion about the exchange of these things that they were coming to me arguing over. And so that's how I developed the joint discovery dispute process that I and it's worked very well.
Yeah, mine is similar. It was modeled after Judge Ross's and others when I came on the bench. I don't require a joint statement because I found that could hang the parties up in and of itself. But I have whichever party wants to email my courtroom deputy with a short statement. From there, we will generally go ahead and schedule a Zoom conference and then sort of work backwards from there and ask the other side to submit a written response either a day or 2 before that conference has been scheduled. And a lot of times by doing that and having that conference on the calendar, it gets the parties to talk some more. And I would say about 30% of the time, they later communicate to us that the issue has been resolved before we even have the Zoom conference, which is nice. But yeah, same result. I think it is incredibly helpful. 95% of the time we can get the issues resolved on that conference. Occasionally, especially if it deals with complicated privilege issues, there may be briefing required, but for the most part, it's been very effective. But this is an area, and I know we're harping on standing orders, but this is an area where it's virtual malpractice in our district not to check with your judge's standing order before you raise a discovery issue, because each of us have a process that is slightly different.
Yeah, and my system is generally the same of everyone else's. I would just encourage you to my standing order for the nitty-gritty details, but basically about the same general concept.
I think a lot of this is fear-based. A lot of these objections is, I don't think there's actually a conflict between the parties in many instances. I think they're afraid of what might happen if they don't put all this in. And you have to fight at the front line for fear of what the back end will be. And I think that's a lot of this. And I think that's what I've seen a lot of discovery is that you want to keep a frontline battle because of what your back troops are worried about. Ms. Hanlon has a question.
Your Honor. Thinking about what you're saying about discovery disputes and tying it to the question that Jason read a moment ago, about sometimes the power imbalance or the size imbalance between 2 parties. Do you see a large number of discovery disputes being waged simply to try to get an upper hand strategically? In other words, not necessarily over the documents that are at issue in the particular document request that's being addressed, but we're going to make you, little guy, spend money. We're going to fight you every step of the way kind of thing. Like, do you see a large number of litigants misusing the discovery dispute process to try to gain leverage overall?
I wouldn't say that I see that quite often, but when it does come up, and it does, I would say that, again, that joint discovery dispute process is helpful there because it allows the little guy to say, hey, this is just overly burdensome and there's no point to it. And we as judges are smart enough to appreciate that and to say, hey, big guy, settle down. You don't need all of that. Tell us why you think you do. And so I would say, no, I don't feel like I see it a lot. But I do think that the joint discovery dispute process that's in place for that most of us have allows you to sift through that and see when there is that type of abuse.
Yeah, if I can say one other thing on this point before we move to the next topic. I would say that maybe as many as half of those joint discovery disputes that I get, after I read them, I think to myself, really? They couldn't figure this out on their own. So I would encourage you, if you're having a dispute, you haven't worked it out, and you find yourself writing a joint discovery dispute statement to one of us, to think twice and say, well, maybe we should try a little harder to work this out, because you can save yourself some time, you can save your client some money, and maybe save us a little time too. Because I think a lot of those things you should be able to work out. But if you file it, we'll handle it for you, hopefully respectfully. But I think a lot of these you should be able to work out on your own.
And whatever you do, please don't attach emails going back and forth. I mean, there are not only because it's within our local rules that you're not supposed to do that, but that's just it's tacky. To see communications that clearly were intended to be between counsel submitted to the court, and then he told me this and then said this and he didn't call me back to this. I mean, it is really, we're not going to look through them. And just the fact that someone is using a tactic like that, there might be a time, I understand, when something needs to be supported by an exhibit. So there may be an exception to that, but don't just generally crank out a bunch of emails and attach them and send them to us. It's just really unprofessional.
Judges, this really tees up a burning question I have, which is many of the judges in the Northern District of Georgia have standing orders that require counsel to meet and confer before they file or bring a discovery dispute in whatever form before the court. I think this group would love to understand what your understanding of a meet and confer is versus maybe some of the meet and confers they've practiced.
Gosh, I don't know that I have an exact, I'd have to go back and look at exactly what that means. I think meet and confer means meet and confer, at least I'm not expecting you to go, from 14th Street to 17th Street to have an in-person meeting, but at least, pick up the phone and talk with each other and try to work it out, have communicated about it, versus just firing off a motion without even bothering to look at our standing orders, much less, put the statement together.
Yeah, my standing order defines what it means, which is it has to be either by voice or by video conference. That exchanging emails is not meet and confer.
Kind of sticking with the meet and confer topic, Rule 30(6) was amended in 2015 to require the parties, it says before or promptly after a notice or subpoena is served, the serving party in the organization must confer in good faith about the matters for examination. And the committee notes to that rule say, consistent with Rule 1, the obligation is to confer in good faith about the matters for examination, but the amendment does not require the parties to reach agreement. In some circumstances, it may be desirable to seek guidance from the court. So my question would be, do you think that essentially instead of eliminating disputes at the deposition level, has this invited disputes on the front end that maybe would never have arisen if they had gone on with the deposition and just kind of gone forward with the list of topics as it had been served?
I don't think I've ever had somebody come to me. Well, had them come after, or but I don't know if I've had. It just doesn't happen.
Yeah, I haven't had this issue either, but I would encourage people to, focus on the one or more officers, directors, or managing agents, et cetera. You don't have to find this magic person that can answer all 10 answer questions on all 10 subject areas. It might be that you have a couple different people or a few different people that each different sections of it.
I had a case recently where the lawyer got his neighbor to serve as a 30B6 deponent for a company he had no connection with. And then when that didn't work out, he got like that guy's cousin to do it. And it was unbelievable. The guy came back. Finally, they got an employee. The employee knew nothing, but he came back and there was a document sitting on his desk with all the answers. That was his prep. I don't know that I could have invited a quicker motion for attorney's fees. But I think you are exactly right, Judge Boulay, that it ought to be a thoughtful determination. But I kid you not, this was in federal court a couple of months ago. It was his neighbor. It shows zero regard for that law and what is technically you can do it. It can be any other person, but it sure doesn't impress us much. And that's what it was. Because I think you're right. It ought to be somebody that one or two people that are thoughtful. Otherwise, I just give another deposition. I think they're on their fourth or fifth 30B6 deposition. I'm not going to give up on that. I'm going to make sure the person has a chance to do it. I don't think there's a lot of opportunity to avoid that obligation if you really push it.
So we've touched a little bit already on resolving discovery disputes. I'm curious to know, are there any more creative resolutions that you've come to or had two parties engage in a creative solution? For example, flipping a coin in terms of where the deposition is going to take place, or rock, paper, scissors, anything fun like that?
I offered that today. At the end of a very long hearing, there was a final dispute about whether the deposition would start on a Thursday or end on a Saturday. And I said, if you all want me to decide that issue, I'm thinking of a number between 1 and 10. I did. They did not take me up on it. They decided. But I don't think there's a lot of those that you can do. The best thing to try to do is give the parties an idea early on where you sit on some of these issues. And then I think thoughtful and conscientious lawyers can work their way to that mark. And I think most of the time that's what happens. I think that's what Judge Ross is saying. You give an inclination and most of the people will find their way to that.
Yeah. I think another thing that works too is showing accessibility. I had phone calls back and forth from both sides during a deposition one day. And I was in the office, but my judicial assistant was monitoring the calls, was screening the calls and saying, are you all sure you want to talk to the judge? Because both sides were threatening to bring the judge in if this side doesn't do this or that. And finally, I just picked up the phone and said, hey, I'm here. We got a room in the back, the jury room. You all come on down here and finish this deposition right here, and I will make myself available. I'm on call. Didn't hear from them anymore. Sometimes those threats, I'm going to get the judge involved, okay, that we got to be here anyway. But it was shameful to me that it came to that because the types of disagreements that were taking place that day were very petty, I thought. But sometimes it's just a matter of letting parties know, hey, I'm here, I'm ready and willing to jump in if I need to, but I shouldn't need to.
I think on one more point on depositions and just discovery in general is, an issue I see quite often is with motions for extension of the discovery period. You have your 6 months or 8 months or a year, whatever it is, and you get to the end of it. And I get a motion that says, well, we've finally taken the plaintiff's deposition, and now we realize we need to do expert depositions. And you really put yourself in a box there and put me in a box too, because of course I want you to have your your expert discovery. But I always just say to myself, well, why didn't you factor this in advance and recognize you probably needed to take the plaintiff's deposition, not 2 days before the end of discovery, then to file your motion 1 day before the end of discovery, but plan that out in advance. I don't know if y'all see this as frequently as I do, but I think it's a pretty big problem, because I want things to be resolved on the merits. I want you to do whatever discovery you want to do, but I would rather you plan it out during the original discovery period than say, oh no, we haven't done it yet. Please help.
Yeah. And let me make one more point that goes back to sort of the professionalism piece of this, which is, Judge Boulay pointed out earlier, rightly so, that you should look at these discovery disputes from a sort of a 10,000 foot level and think about, what is a reasonable compromise here? If you're not able to get the other side to buy into what you perceive as that reasonable compromise, when you go into that discovery conference that we're having, you have so much credibility with us when you tell us, look, here's our position, but in an effort to resolve this, here's what we offered. And to me, that gets you so many points, because it demonstrates that you've been making that effort. And I'm much more likely to sort of adopt, the compromise that you suggested, if it's a reasonable one, just because you made that effort on the front end. So don't think that by making that compromise, you're somehow sort of giving up your ideal position, which is to, get everything you want or have to give up none of what you don't want to. It demonstrates that you have been trying and you've exhausted those efforts, and it builds a lot of goodwill with us.
I'm interested in your thoughts on the last question that's up there. And unfortunately, my co-moderator wasn't able to be here today. But do you believe that remote work and a lack of mentoring is an issue that potentially leads to problems in a case? Do you think it's had any impact aside from the obvious issue of dressing appropriately during a Zoom hearing? Do you think it's otherwise been an issue?
Well, I don't know how we know what's going on you're saying the remote working by people at a firm and the
Right. Yeah.
I don't know who's working remotely and who's being mentored. So I don't really know what's happening prior to coming to me. Now, I, on the mentoring piece in particular, I have had attorneys, these are mainly solo practitioners, so not with firms, come before me, and I may pull them aside afterwards and say, hey, I'm just wondering, do you have a mentor you might want to get into getting one? And I say that whether or not it's inappropriate, I can tell whether someone has not aligned themselves with someone who's more knowledgeable, and I will mention that. But in terms of working remotely, I never get into that. I never have a reason to discuss that with attorneys, so I don't know who is and who isn't.
Before we move on from discovery, any other questions from anybody in the audience?
This is thank you for sharing all your thoughts. It's been on.
Yeah.
Okay, yeah, it's been great having you guys here. So, listen, I don't want this to come across weird, but I've been to many of these over the years, and everything you're saying is super consistent with every other judges panel I've seen out there. So, what can we do as a profession to solve some of this? Because to me, like, we are not getting it. Like, litigators are not getting it. They're like, the fact that anyone's saying read our standing orders or meet and confer before discovery dispute. I mean, I know I don't want to put the problem at your feet necessarily, but are there any tips? Maybe it is a mentoring issue. Like, what can we do as a profession to help you guys have a smoother courtroom?
So let me just say, first of all, I think we say criticism. This is not like Festivus. And I mean that because I think most of the cases go perfectly fine. I might rule on a motion for dismiss and maybe a couple other things, maybe extend discovery. And then the next thing I know, I've got a nice summary judgment brief. Most of them are perfectly fine. So we're sort of dwelling on whatever 20% it is that causes most of the difficulty. I don't know there is a way of avoiding it because it takes both parties to compromise and to get along in this regard. And I think that's a little bit, I think lawyers are generally by nature very cautious. And so you always want to ask for a little more just in case there's a hidden gem there. But I remember when I was a prosecutor, I had a number of cases where Judge Thrash, who was a very good judge and a very stern judge and a very experienced judge. And I don't know if he still has it, but he had a plaque that said, "Keep it simple, stupid." And every now and then I thought he was like turning it around. But it has stuck with me the whole time that it is about being focused on what you really need or what you really don't think you should have to do, and giving up on those things that don't really matter. And when I see lawyers doing it, I always recognize it. And I think that if you started off a little more focused, maybe we'd have lessons. These are not most of the cases, right? The things we're talking about. But I think it is having the thought of being, I know my case, I know what I'm trying to do, and I'm going to be focused on this. And I'm not going to worry about, well, if I said, and including, but not limited to, and other things, maybe I'll get something. That almost never happens. And that's almost the first thing that gets cut away. So that would be my thought, would be confident in what you're trying to do and be focused on it, and go out and get that thing and then come back in and say, this lets me win, rather than hoping you're going to get, or you're going to apply some pressure on the other party by asking for more. I don't think that's much of a winning strategy.
I think that we've heard a lot of the things already discussed that would help. One, reading a judge's standing order, just to know how a judge does things. And two, as Judge Grimberg said, offering something kind of as a concession when opposing counsel doesn't go for whatever your initial request is, so that if it does go to the court, you can say, hey, in the alternative, I even offered to do this, which does go very far. I also think just being very prepared and very conscientious of your own work in terms of typographical errors and all of that, because if it does come down to a dispute between you and someone else, if your credibility is already intact over someone else's who's constantly having errors in their work and citing things improperly, you've already gotten some stock with the judge. And we do take notice of those things, just like you all talk about us. Oh, I won't finish that sentence. Yeah.
Olivia, I really appreciate that question, because as we were talking about this, I was listening, thinking, wow, this sounds a lot worse than at least I think it actually is. And my colleagues here might kill me, but I really don't think it is bad. I mean, we have, given the volume of cases we have, right? We have, I have over 400 civil cases at various stages, and I'll have maybe 2 to 3 discovery conferences a month. So if you think about it in that way, it's not bad. I mean, most lawyers do get it and are working it out. I would say that the one thing that we haven't really talked about yet that I would think about is setting clients' expectations, because I think what I get the sense of is that sometimes lawyers are making an argument because their client is demanding that they not just give up the thing without a court order. And to the extent that you have a relationship with that client where you can, on the front end, explain how this is going to go, I think that could be very, very helpful and save ultimately that client and us a lot of time.
Our last few minutes.
I'm back there. He has a question.
I missed you.
Good afternoon, Your Honors. I'm Tyler Bishop with Baker Donaldson. I just wanted to ask a follow-up question, something Judge Grimberg said. I'd be interested to know, if you keep count, out of the 2 or 3 discovery fights that you have a month, how many of those involved pro hoc practitioners from out of state? Our view is, I don't think my boss mind me sharing this, that folks who practice in this district act like it. And oftentimes we find that the problems we have are with out of state folks. So I'd just be interested in Your Honor's thoughts on that, if you're comfortable sharing.
I don't keep track of that, but I do keep track of how many times in a given case there's been a discovery dispute.
Yep.
And I've found that I do have a lot of repeat customers. It's usually the same case over and over and over. And I can tell how frustrated my law clerks are by their opening sentence. They'll say, in Smith versus Jones, Judge, I'm writing to you with a discovery dispute in Smith v. Jones. This is the party's 7th discovery dispute, right? And and it's at some point I just throw my hands up in the air and say, why don't you file a motion? And just because it gets too much. So I haven't really noticed it's been out of state folks versus in-state folks. Certainly sometimes there's some pro se parties that will have more disputes. But I honestly, I don't think I've noticed if it's been folks from out of state or not.
Yeah.
Moving to the last topic of the day, I think we'll get a few minutes left. Topic du jour is obviously AI, artificial intelligence, and I believe Judge Grimberg's the only one that's adopted specifically in his standing order a provision regarding the use of artificial intelligence. Judge Grimberg, do you want to speak to your adoption and how that came to be in your standing order? And to the other judges who don't have provisions regarding AI, do you intend to adopt provisions? Do you feel they're necessary, or any other thoughts on the use of AI and its use in the courtroom and litigation in general?
Yeah. Well, I'll tell you how this evolved. This particular piece of the standing order is just in the greatest edition, 2026. I had not done it before because my view had always been, Rule 11 should take care of any issues when it comes to AI. But the issue kept popping up, right? We continue to have cases where motions are being filed with hallucinated cases or fake citations. And so I felt like it needed to be addressed. But in looking at what other courts or individual lawyers had done previously, it seemed like those orders were not going to age well. Because they were either prohibiting the use of AI entirely or requiring a certification. And that just raised a host of other issues, right? Like how do you define AI? Is Westlaw and Lexis, even is AI, even without the particular AI tool. So I thought if I'm going to have anything at all, it would be something along these lines, which is just making it abundantly clear to the extent it's not already, that and trying to be forward thinking about it, which is that obviously AI is going to be very much part of the legal practice going forward. So acknowledging that we are all going to start using AI, but making sure that everyone is clear-eyed about the fact that at the end of the day, it's only the people who are going to be sanctioned if things go wrong.
I haven't felt a need to include this in my orders yet. And the main time that I've seen it has been with pro ses. And quite honestly, I don't know that adjusting my standing order would do anything for that. We have inserted footnotes about it in certain orders, but it's not my intention to call out attorneys by just kind of ruining their names because they have used AI. I'm not condoning it at all, but I don't want to do anything. I know certain judges have had big hearings over it and stuff like that, which I understand if it happens repeatedly, but up to this point, I think I've been able to manage it simply with the insertion of a footnote. I just haven't felt the need to change my order to reflect it. That may change.
That's essentially what I do as well. It's unwise and it bothers me, but so does citing a case that doesn't apply.
Same.
And a question that I had from an audience member earlier was, does the court use, or is the court aware of courthouse use of AI? And if so, in what capacity, or are clerks using it in any capacity?
No way. I should knock on wood on that.
No one that's still employed. Yeah.
Every time I get some that's in the paper about somebody doing it or some judge doing it, I take it to my law firm. I don't want to be this. And they say, Judge, that would never happen. And I say, good. I don't want to be this. So I don't want to jinx myself in that regard, but we don't use it for anything.
I will say that in looking at a resume packet I had for a law clerk position, I called another judge who said, oh, this person was good, except for there was that one time they used a little AI. I said, nah, thank you. And so, that just ended the consideration there, but I have not had that problem with
I think
anyone
we
that's
have
on
to
staff.
adapt to that at some
Yeah.
point, because I do think young people are being taught now to use it in whatever way. I don't know what the rules are, but I think it's much more wide open. But I don't want to get caught doing it.
Judges, I have some news for you. Do y'all know that the 11th, our circuit libraries are doing a trial run of Westlaw's AI platform?
Yeah.
So it's coming our way.
Yeah, it is.
Yeah, there's a pilot program. I think certain judges are in that pilot program and are testing those tools. So, but yeah, eventually it'll get rolled out to everybody.
Yeah.
Would it maybe sometime be helpful for people signing pleadings to certify that they've personally read the cases or that they've at least shepherdized their citations to verify, just like we verify that we've served papers and that we've stayed within the page limits or the word count. We certify lots of things as counsel, but we could certify that we've personally read these cases or have personally shepherdized these cases.
That is actually what Judge Johnson's standing order talks about and discusses that specifically. You must include a certification that says, I used AI and I've done that exact same, done that thing. I've shepherdized the cases, I've checked the case law, and you need to sign a certification to that effect. Are we out of time? Are we time to wrap up? All right. Well, are there any parting thoughts for the section that you'd like to share with us? And if not, we really appreciate you being here. Thank you very much for taking the time. But any final thoughts on anything?
I want to echo something that Judge Grimberg said, that in terms of everything we discussed here, it is more exceptional than the norm. It's just that when it happens, because it happens infrequently, we make a note of it and we remember, and we do remember what it was. But the problems that we're discussing here, from my perspective, are not ones that happen quite often. I'm very happy with the attorneys that have appeared before me and the level of work that is done.
Yeah, likewise, and thank you very much for having me.